Good morning, everybody, and welcome to the August 21st, 2024 meeting of the Arizona State Board of Pharmacy. My name is Lori Walmsley, and I'll call the meeting to order. Dr. Grande, if you could take roll call and conflicts of interest, please.
Thank you, Madam Chair. Mr. Braswell,
Here.
any conflicts?
No.
Okay, Mr. Thorwald,
Here, no conflict.
Ms. Snare,
I'm here and I'm recused on 4J. It's item 224-0229
Okay.
due to my employer.
Ms. Davis,
Present, I've submitted my conflicts in writing beforehand.
thank you. Ms. Walmsley,
Present, and mine have been submitted as well.
Ms. Lehan,
Present. Mine also have been submitted in writing prior.
Mr. Dang,
Present and no conflict.
Mr. Al Nassif,
Here, I am recused from 4A and 13A.
Mr. Anderson.
Present with one recusal for 8D.
Madam Chair, we have a full house.
Thank you, Dr. Gandhi. For members of the public, thank you for being in attendance today. I think this is the busiest meeting that we've had in a while, so nice to see so many of you in the public. If you are interested in CE, a reminder to sign in at the table. We will be offering CE for both the morning session and the afternoon session. If you want to receive the maximum number of CEs, you will need to sign in for both. And with that, I will move on to the next agenda item. We will need approval of the meeting minutes, which is the video. Do I have a motion for approval?
Madam Chair, I move for approval.
Do I have a second?
Second.
All those in favor?
Aye.
Any opposed? Hearing none, motion carries. Next, we'll move on to the consent agenda for the complaints. Staff ask that we pull item 4R for additional discussion. There was some additional information, I believe, that was added to the book late last evening regarding this particular matter as well. So we'll pull that for discussion. Is there anything else anybody would like to pull for full board discussion today?
Madam Chair, I have 4. I'd like to have pulled 4A, 4H, 4O, and 4U.
Anything else from the group? All right, hearing none, we'll take them in order. 4A is complaint number 24-0177. A incorrect medication was filled and dispensed to a patient. Dr. Anderson, if you'd like to talk about.
I'm sorry, I'm just recused from this case.
And
Okay.
so am I.
Thank you, Ms. Walmsley. When I reviewed this, the pharmacist, Ms. Mace, deviated from the critical safety protocol by not limiting production to one label and one medication at a time. That deviation and also not catching the mistake during product verification, which is a uniquely shaped tablet, did result in harm to an 11-year-old girl who experienced significant side effects that required her parents to take off time from work to monitor her. Applying just culture, specifically duty to follow a procedural rule, I think it goes beyond just human error. I feel like this pharmacist violated their company's policy, their safety policy, to do just one label at one time. And I do believe the compliance officer's noted violation is substantiated. But given the seriousness of this case, I do believe that disciplinary action is warranted.
Thank you, Mr. Anderson. Ms. Snare, Mr. Thorwald, anything to add from the complaint committee or thoughts?
I was just curious what Mr. Anderson was thinking as far as a motion.
I'm comfortable with the CE, but perhaps as a consent agreement, so it does reflect as discipline. So offer consent agreement to resolve the case to include 3 hours of CE on medication safety and prevention to be signed within 30 days and the CE complete within 90 or refer to hearing. That would be my motion.
Second.
Any further discussion? So specifically this one being different because they violated the company's standard of care.
Correct.
Dr. Gandhi, roll call.
Thank you, Madam Chair. Mr. Braswell,
Aye.
Mr. Thorwald,
Aye.
Ms. Nair,
Aye.
Ms. Davis,
Aye.
Ms. Walmsley,
Aye.
Ms. Lehan is recused, Mr. Dang,
Aye.
Mr. Al Nassif is recused, and Mr. Anderson.
Aye.
Ayes have it, 2 recusals, Madam Chair.
Thank you, Dr. Gandhi. I'll have you take the next three in order because those are all ones that I'm recused from. So, and then we'll go back to 4R if that sounds good with you. Sure.
4H was complaint number 24-0238. A wrong strength of medication was dispensed by the pharmacy. And the complaint committee's recommendation was non-disciplinary order for continuing education for 6 hours and error prevention, patient safety to completed within 90 days, in addition to the continuing education required by the renewal. So some similar thoughts on this case. The pharmacist overrode therapeutic duplication alerts, which are essential safeguards against medication errors. And there was a significant dose change that occurred in this one. The pharmacist was dispensing 750 micrograms when the last fill was only 150 micrograms. And any reasonable and prudent pharmacist should have prompted a review further and a deeper dive. It also mentions that the pharmacist counseled this patient, and just the quality of that interaction was likely inadequate given this outcome. Also, I do note that the compliance officer's violations were substantiated, but we place an extra emphasis on opioid education for our licensees and require them to complete 3 hours at CE annually on opioids. And this pharmacist, again, violated their company policy, huge dose change, didn't catch it, counseled the patient, had an opportunity to catch it during that counseling session. And I think this, again, merits more than just non-disciplinary CE.
So is it your recommendation that it's 3 hours of disciplinary CE? Or do you want to keep it at the 6? What's your suggestion?
I would like to move it to a consent agreement, so there is discipline, and 3 or 6 is fine with me.
Can we clarify what was the last motion that you made on 4A? Was that for 3 hours?
Yes, it was.
I'm inclined to agree with you. I think we should keep it consistent though and keep it at 3.
It's
Any
not-
further discussion?
In the last case, there was patient harm that happened because of the medication error, but in this case, there didn't appear to be, correct?
Oh, no, there was significant harm. This
There was-
patient went through withdrawal.
Oh, withdrawals,
Yeah.
okay.
Second.
All right, so that was a motion to offer a consent agreement to resolve the case to include 3 hours of CE on medication prevention above and beyond renewal requirement. Consent to be signed within 30 days and CE to be completed consent to be signed within 30 days and CE to be completed within 90 days or refer to hearing. And that was my motion, and seconded by Mr. Thorwald. Any further discussion?
I just have concern about, like, previously we did not go with for consent agenda for same errors. And so I do agree with you, like pharmacist has to prove public safety and patient safety, but I don't know. I mean, I like to be consistent with previous errors that we handled. So
I agree with you.
okay.
I think Mr. Anderson, though, has called out some reasons why to justify the difference. I just think that we should be nervous about saying what the outcome was if we just focus on what action was taken and not on what the outcome was, because the outcome could be different, but the action is what we're here to discuss, in my opinion.
I agree with what you just said. I concur.
Any further discussion? All right, we've got a motion and a second. Since there's discipline, roll call, please, Dr. Gandhi.
Thank you. Mr. Braswell,
Aye.
Mr. Thorwald,
Aye.
Ms. Nair,
Aye.
Ms. Davis,
Aye.
Ms. Walmsley is recused, Ms. Lehan,
Aye.
Mr. Dang,
Aye.
Mr. Al Nassif,
Nay.
and Mr. Anderson.
Aye.
Ayes have it, one recused, one nay.
Thank you, Dr. Gandhi. Moving on to the next case, which is 4O. And that was 24-0340. The complainant, the prescriber, alleged the pharmacy used his credentials to process a prescription for a C2 that he did not prescribe. The complaint committee recommended an advisory letter to the PIC and the technician and to dismiss to the permit holder. Since I asked this to be pulled, I just have some comments and would appreciate my colleagues in their discussion. The case involves a C2 prescription that was e-prescribed and correctly entered into the system on 9/26. That prescription was placed on hold in the system, but was later released on 10/9, at which point the system incorrectly changed the prescriber from the correct one to an incorrect one. The incorrect prescriber was mistakenly listed and filed a complaint. Like the complaint committee, I don't find any evidence of malicious intent in this case. It appears to be a system error that contributed to the unfortunate event. While I don't see harm in issuing advisory letters to the pharmacist and the technician named in the complaint, I believe there should be a focus on the understanding what Walgreens is doing to investigate and prevent such errors from happening in the future. The PIC, Mr. Din, has already entered an event into Walgreens' internal event tracking system. I'd like to see what the outcome is of their event tracking, what has happened, to investigate this to make sure it doesn't happen again, and to ensure that the issue's been resolved. So I quite honestly think it's important for this board to seek assurances from Walgreens that the system error has been investigated and corrective measures have been implemented to prevent this reoccurrence. So, and that's the reason why I specifically don't think we should dismiss against the permit holder. I think we need to see, what their internal investigation has revealed.
So I don't know what is the outcome when we ask them, and I believe it's like IT system has glitch, right? And then I'm sure like pharmacies will do their best to prevent these errors, but I don't know what the expectation to hear back from them.
It appears Mr. Patel has some
Yeah.
updates. Oh,
Sorry. This is Ram Kalapudi, Compliance Officer with the Board of Pharmacy. I investigated the complaint. On August 12th, Walgreens sent me a letter saying that the technician in fact changed the doctor. It's not the system. It's the latest update. And they had some issues with the East Coast, West Coast timings, the timestamps on the sequence of events. They are going to correct that. So
very good.
I just wanted to add that extra information that I received on August 12th. I'm sorry about that.
Thank you.
Yeah.
That's great.
It is great.
Yeah.
So it did clear that up. Appreciate that additional information. And it appears that what the complaint committee has already recommended seems appropriate. So since we pulled this, do we need to?
No, we can take it as a full motion later on.
Okay, very good. All right, last one is
I thought you did 3 already.
for you. And this is complaint number 23-0663. The complainant alleged that a prescription container filled for 20 tablets contained only 11 tablets. And the complaint committee recommended dismissal. And the complaint filed by the patient, it was just very, very plain and matter of fact that the prescription was short by 9 tablets. I'm curious, who was the compliance officer on this one? If Mr. Wagner is coming to the front. Welcome, Mr. Wagner.
Good morning. Dennis Wagoner, Compliance Officer.
Good morning. I am just very curious, did you have any conversations with the patient? Because the complaint that was in the board book was just very simple, that it was shorted by 9 tablets. Was there any additional information provided by the patient?
No, I did not contact the patient directly.
And the audit came up as no shortages, correct?
The audit for that period, there was a shortage, but an overage would indicate that the patient was shorted. So the audit didn't substantiate the complaint.
That's what led me to dismiss.
Yes, that was our thinking at the time.
And, you know, another question I had is the internal investigation that the PIC did, they didn't mention any camera footage being reviewed. I mean, this board has reviewed, since I've been on the board for just a year now, I mean, we've had tablets diverted from will call outside of, you know, the pharmacist and the technician counting. And so I'm just curious, did that PIC review any camera footage? It just looked like their internal investigation was simply that, just this internal audit of counts. I didn't see any further investigation looking at camera footage.
Unfortunately, I don't know. I don't have their internal investigation.
Yeah, I just,
Even with that, I still don't feel like there's enough evidence to support that that we have the information to show that they had been shorted the 9 tablets. Sorry.
yeah. All right. I have no additional questions. Thanks. Ms. Walmsley?
All right. We pulled 4R for full board review. I think Max was the compliance officer on this one. The complaint committee discussion on this one was brought before us because there are multiple repeat violations on routine compliance inspections. The board committee had originally discussed potentially having the compliance officer go out and do another inspection with potentially doing a summary suspension. Max was very diligent and got out to the permit holder again since last week. So I think he added some additional information into the board book. Not sure if everybody had a chance to review it, but if you could give us a summary of your findings and kind of where you feel like things stand since you were just there a couple days ago.
Very good. Thank you, President Walmsley. Max Jacobson, Arizona Board of Pharmacy Compliance Officer. Just like President Walmsley said, this pharmacy had several violations and they do operate a very high risk operation. The violations were on repeat inspections, so they were repeat violations. And at complaint committee, we were directed to go and do another inspection to see if there had been any improvement. Officer Steve Hyber and I did that inspection Monday of this week, and we were pleased to see there was much improved operation in all of the categories of violation. There was a few needs improvements, but nothing that was egregious and nothing that really spoke to the previous violations.
So you're satisfied where they're at least from a basic patient safety standpoint at this point? You don't feel like it's an imminent risk to the public that we would need to take action today or in an immediate fashion?
I think that's a fair statement, Ms.
Okay.
Walmsley.
Then are we able just to keep our recommendation of a conference? Okay, that's what I would recommend.
Any other discussion or questions for Max? Hearing none, I guess we'll keep the complaint committee's recommendation. Do I have a motion with regards to the rest of the complaints that are listed on the consent agenda?
I move we accept the consent agenda.
Do I have a second?
Second.
I have a motion and a second. Dr. Gandhi, roll call.
Thank you, Madam Chair. Mr. Braswell,
Aye.
Mr. Thorwald,
Aye.
Ms. Nair,
I noted my recusal.
Ms. Davis,
Same, I noting my recusal.
Ms. Wamsley,
I noting recusals.
Ms. Lehan,
I noting recusals.
Mr. Dang,
Aye.
Mr. Al Nassif,
I noting the recusal.
and Mr. Anderson.
Aye, this is only for tab 4, right?
Yes,
Correct. Aye.
ayes have it, Madam Chair.
In the interest of time, I would like to consider taking the rest of the items on the consent agenda as one item unless there's anything anybody would want to pull. So that would be tabs 5, 6, 7, 8, 9, and 10.
I'll make a motion to approve items 5 through 10 consent agenda.
Second.
I have a motion and a second. Dr. Gandhi, I do want to disclose I have 2 recusals, so I don't know if we need to pull those out separately or if I can just note that when I do my motion or do my vote.
You do not need to hold.
Okay, thank you. Since there's discipline, any further discussion or we can take a roll call?
Mr. Braswell,
Aye.
Mr. Thorwald,
Aye.
Ms. Nair,
Aye.
Ms. Davis,
I noting recusal.
Ms. Wamsley,
I noting 2 recusals.
Ms. Lehan,
I noting recusals of 10A 1 through 4.
Mr. Dang, Mr. Al Nassif,
I
and Mr. Anderson.
I noting recusal on 8D.
Thank you. Ayes have it, Madam Chair.
Thank you, Dr. Gandhi. Moving on to tab 11, item 11A, I will give this back to you, Dr. Anderson.
Good morning, Mr. Leo.
Morning, Dr. Anston, board members.
So this is case 23-0118, tab 11A. Would you like to share with the board why you're here today?
Certainly. So on December 9th of 2022, Walgreens entered into a multi-district settlement agreement between all the settling states, most of the states across the country, including Arizona, regarding the opioid crisis. Under the agreement, Walgreens agreed to pay $4.5 billion over 15 years to the settling states. The settlement applies to the state attorney general, as well as the state departments, agents, divisions, boards, and commissions. Under the agreement, as of the effective date, Arizona released all claims existing prior to June 8th of 2023 related to distribution, delivery, monitoring, reporting, supply, sale, prescribing, dispensing, security, warehousing, use or abuse, related to a certain list of products. That list of drugs includes opioids, benzodiazepines, and gabapentin. Complaint number 23-0118 involves conduct occurring in 2022 and early 2023, which is prior to June 8th of 2023. The conduct involved drugs, which are included in the definition of product that's in the settlement agreement. And the allegations describe concerns regarding the monitoring, reporting, and physical security of the products, all which fall within that definition of covered conduct. So under the terms of the settlement agreement, the claims in the complaint have been released and no further action may be taken. For that reason, Walgreens respectfully asks that this matter be dismissed.
Board members, discussion?
I don't want to cut off discussion, but I would like to have make a motion for legal advice.
Do we have a second?
I'll second.
All right, all in favor, aye?
Aye.
Any opposed? All right, we'll see you in executive session. Okay, board members, any further discussion? Or are we ready to make a motion?
I'll make a motion.
All right,
I'll make a motion to dismiss this case for lack of jurisdiction due to the settlement.
Second.
shall we take a roll call or? Okay, all right. All in favor, please say aye.
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 Any opposed? All right, motion carries. Thank you, Ms. Trujillo.
Next item is 11B. Complaint number 24-0293, Noel Valdez Escada. I'm sorry, Valdez Escada. Is Miss Escada present? Oh, I'm sorry, Mr. Escada, please. If you could please make sure you push the green and introduce yourself for the record. Followed by Miss Canavang.
My name is Noe Valdez Escajeda.
Welcome. Miss Canavang.
Good morning, board members. Jennifer Gilnavong, Deputy Director. So just a brief background, Mr. Escajeda was issued a pharmacy technician license on January 29th of 2016. His license expires this year and it's currently open. He's currently employed at the Winslow Indian Health Center, which is a facility not permitted by this board, possibly through dependable staffing, and his employment information is not up to date in his online board profile. On May 28th of this year, board staff was notified by the Aureus Group that Mr. Escajeda submitted a pre-employment urine sample on April 25th, 2024 that resulted positive for cocaine on May 1st. His contract with Aureus was canceled pending the outcome of this complaint. On May 29th, the Aureus Group provided board staff with a copy of those results. On June 5th, board staff contacted Mr. Escajeda and notified him of the complaint. He was required to provide a detailed explanation of the events which led to the positive drug test, as well as his place of employment. On June 7th, he responded, and he indicated that around May 1st, he was out of the country and given a substance without his knowledge. He indicated that he was unable to be fully tested at that time, and he denied being linked to any drug use. On June 11th, staff requested that he supply documentation of his hospital visit. He did provide a response, but his response did not include that documentation. On June 14th, staff again requested that he supply documentation of his dates of international travel. He did not respond to that to staff at that time. So again, on June 26th, staff reached out, asked him for the same information. On that same day, he responded that he did not see board staff's message until today, and that he was in Mexico for a couple of weeks from around April 15th to May 1st of 2024, and he did not supply any documentation as requested. On June 26th, staff contacted Mr. Escajeda and asked how he underwent drug testing in Phoenix on April 25th at the same time he was in Mexico, which again, he indicated was from April 15th to May 1st. He responded that he had come back to Phoenix to do some paperwork, some medical tests and drug tests, seemingly with the agency that he was employed by. On June 27th, staff issued Mr. Escajeda an interim order for drug screening. This included requiring him to provide a urine and hair sample no later than 5 p.m. on July 1st, 2024. On July 1st, he contacted board staff. He indicated that he was unable to leave the reservation to go back to Phoenix for the screening due to weather and lack of transportation, and that he could get a ride and schedule with the lab for Saturday morning if that was an option. Staff corresponded with him again on July 3rd, informing him that he was not in compliance with the order and that his compliance was expected by July 6th or the matter would be escalated. On July 8th, we reached out to Mr. Escajeda and asked him to confirm whether the drug testing was complete and if he consented to those results being released. We did not receive a response that day. On July 10th, the executive director spoke with Mr. Escajeda by phone. He was told that he attempted to make an appointment on July 6th. The facility only did screenings Monday through Friday. He stated he was not able to afford the test until July 11th. Dr. Gandhi, the executive director, indicated that he had until noon on July 11th to complete that testing. On July 11th, we did receive a copy of the urine drug screening results. The hair follicle results took a few more days, and after a few more email communications on July 15th and 19th, we received those results on July 20th. Both of those results came directly from Mr. Escajeda and not the lab. A point of collection test sample was collected on July 11th that resulted negative. It's unclear what the biological sample was. And then a hair sample collected on July 11th was also negative. So today, the case is before you due to the positive pre-employment drug screening, which resulted positive for cocaine on May 1st, the untimely completion of the board order drug testing, a lack of evidence to substantiate the allegations surrounding the cocaine exposure, and also, as a kind of a secondary note, a failure to update his online profile. That's it. Thank you.
Thank you, Ms. Cannavong. Board members, any questions for her before we go to Mr. Escajeda? Hearing none, Mr. Escajeda, would you like to make a brief statement?
I mean, it's pretty much everything that was said. I do work up in the reservation. It's kind of hard for me to go anywhere during when I'm scheduled, due to my lack of transportation and the fact that the test was quite pricey, out of my range. Also, you did mention, it was mentioned that I was employed with this company where the pre-employment testing was done. I was not employed at the moment. I had been out of work for a few months. That's why I went to Mexico to be with some family and try to get some financial things going on. And the incident happened. I mean, I'm not saying it didn't happen. It did happen, which is like extremely personal, but the testing that was done, I tried to comply as much as I could, being that I'm 3 hours away from Phoenix. And that was it.
Board members, if we would like to hear about his medical information, executive session is possibility for confidential medical information. I believe it is medical related. Is that correct? You don't have to say anything further.
Yes.
Oh,
Not sure if it's relevant, but just throwing it out there so that way we don't ask questions that make him uncomfortable.
Where do you currently work?
I'm working at the Winslow Indian Health Community Center through dependable staffing.
So I've got to ask the question, is there no lab in Flagstaff?
I don't have a car. So I'm in Winslow, which is an
I
hour
would
from
think there would be
Flagstaff.
something in Winslow.
And the Winslow, I mean, there's a small hospital besides the clinic that I'm in.
I mean, it just seems like there are a lot of excuses here.
mhm.
Sure.
And Winslow is less than an hour from Flagstaff, and Flagstaff has got to be big enough to have a comprehensive laboratory to do your test.
I would think Winslow could support it as well.
Yeah,
It's
I
not
also
possible.
was not financially available to do so at the moment.
I just have some trouble following your stories. That seems like they're not maybe truthful. Can you talk to us about what happened about the cocaine use?
I'm not,
We may need to go in executive session.
I'm just the circumstances.
Okay.
Not,
extremely personal. I'm willing to talk to whoever I need to talk to about that situation. It might not seem truthful to you, but what happens extremely personal and delicate. And I do apologize if I'm not able to discuss it with every single board member here, but as something that's extremely traumatizing to me, and I'm not willing to talk to 20 people that
Mhm.
I have never seen before. I do apologize for that.
We have the option of going into executive session. It would be all the members of the board as well as our council, but obviously nobody from
Absolutely.
the public.
Yes.
That would be an option that we have as a board. Some of the information is in the book. And I understand why he's concerned about his confidentiality. Ms. Galvin, did you want to make a comment?
The reason you can go into executive session would be for information that is protected under law, confidential health information. And I'm not sure that what I have read in the book would constitute protected health information.
I'm sorry, but I disagree with that comment.
Well, thank you, but I'm the attorney that
Mhm.
interprets the statute.
So I'm struggling with the story. Like, you were able to drive from Mexico to
With-
Phoenix,
for
right?
family members, yes.
With family member, but you couldn't find a car or somebody to help you to drive 1 hour or half an hour.
But that
within
that
Arizona.
was when I wasn't employed.
Okay.
So I was with family. Once I did get the employment with Dependable Staffing, I was able to go there. I stay there in a hotel that is provided by the company.
Thank you.
Can you speak to the reference made by board staff about not changing your employment on the board profile?
There's no was like reason for why I didn't do it. I just forgot. I was out of work for so long that the employment with Dependable Staffing happened so fast that it was something that went past.
I have a couple questions. So you mentioned that the occurrence happened in Mexico.
Yes.
Is there a reason why you were hesitated to provide us the documentation that you were abroad?
I don't know what kind of documentation I would be able to provide that I drove across the border to a
Just
family's
indicated
house.
that you were actually in Mexico during that time.
Like I said, I don't know how to provide that information when I was at a relative's house.
My other question is, have you ever looked at the at-home lab services that are provided by LabCorp or Quest?
I did not, when I looked for the testing situation, and when I went, it was made clear to me that I couldn't just go in and ask for a test. I had to a third party situation so they could provide an order number. So that's what I did. I went through a website that provides the order for the drug testing. That's why when the drug testing came back, I was the one that provided it via email because it came to me, to my profile.
I have a question. You must have passed a pre-employment drug screen to work for Dependable
I did.
Staffing, correct?
Yes, and the person that runs the company also said that they could provide that as if you guys needed to see that as well.
What was the date of that drug screen? Approximately.
Approximately the first week of May. Ish, around that time.
Wait, so I'm sorry, I don't understand. So Dependable Staffing did your drug screen the 1st of May, but this is when the other, or around that time frame, but this is when the other company was also doing it and that the other companies came up positive. What is the time frame in between the two?
About 2 weeks.
What's the company that
Aureus
had
Medical.
positive?
Aureus Medical. I was not employed by them.
Right, it's pre-employment drug screen, yeah.
Because I did hear that there was a contract that was canceled, but there was no contract in place with us, me and the company.
And you became Dependable after this?
Yes, I've worked with Dependable before, a couple years ago, so they reached out to me for the position that was available. And I took it, being that I hadn't had a place of employment for about a 3-month period.
Okay, so while you couldn't do our request, but you did do the one from Dependable, and that was after the initial one that's come back positive,
No,
correct?
that was before any of this happened.
So you took the test from Dependable on May 1st and then you traveled to Mexico. The incident happened during.
No, when I came back after May 1st to Phoenix, that's when I got reached out by the person that runs Dependable, and
I was able to go right away because I was in town, and then she provided me with employment right away, so I was able to find,
And
I
that
would
was
say go up there.
before or after your travels to Mexico?
that was after.
Okay. And do we have a copy of that drug screen?
I wasn't aware that one was done by Dependable
Okay.
until today.
Can I make a motion for legal advice?
Second.
I have a motion and a second. All those in favor? Aye. right, welcome back from executive session. Mr. Escajada, I do have a question for you. So you mentioned that you're working for the tribe as well as dependable staffing. Do you have multiple jobs, or are you placed at the Indian reservation through dependable staffing?
Yes, the dependable staffing, it's a travel agency, so they just place us in.
So you have
Oh,
one employer?
Yes,
And that's your current placement?
yes.
Okay.
I'd be in favor of getting a copy of the dependable staffing drug screen. Take a look at.
Yeah, my employer was, she called me before this and she said she's willing to provide it at any time if needed.
I also think that a substance use evaluation would be appropriate. We don't have anything that substantiates the claims that you've made that have happened, like a police report or anything that would help me understand your situation better and document your situation. So I'm not comfortable knowing whether or not there's a substance use issue that needs to be addressed.
Yeah.
Let me ask a clarifying question about that. Did you file a police report while you were in Mexico?
It's a very small town. Police is extremely corrupt. Any police report that I would have made, given the what happened, it's not something I take very seriously.
Okay. And did you go to the hospital?
I went to the hospital for treatment about the situation. It was extremely hard to get treatment because they don't provide those kind of medications to males.
Do you have any records that you could provide us from that
Um,
hospital visit?
It wasn't a hospital, it was a clinic. I was born in Mexico, so I have universal health care. They don't give you any paperwork after being, and I had to explain to them what medication to provide because they weren't very used to those kind of things, especially in such a small town.
So is there a way for you to request those medical records?
Um, I guess the best things to go down there and talk to the staff because it's
What we're trying to establish here is,
Yeah.
do you have any proof of what happened in Mexico? Right now we have your word, but we don't have any,
Well, it
we don't
wasn't
have any
something-
proof.
wasn't something that I wanted to keep as a memory.
I
It's
understand
not
that.
something that I wanted to talk to multiple people about.
Right, I understand, but where we're coming from as a board, and please anybody interrupt me, is there's a
I-
lot of
I understand.
circumstances here, and what we're charged with is making sure that we are looking out for the citizens of Arizona, but we want to make sure that we give you the opportunity
Absolutely.
to provide us the information so that we can make the best decision for everybody involved.
Absolutely. And I mean, if I could speak freely, I've never had an issue with any employment I've been at. If anything, I love what I do. I've done it well with every location I've worked at. This was an isolated incident that happened while I was unemployed. Whether it happened, what happened, the outcome of it was this. I understand the fact that we want to keep the citizens of Arizona or anywhere else I work at safe, but if I may, I wasn't working with anybody at the moment, and what happened was something that kept me from working as well.
Thank you. Board members, additional questions?
Madam Chair, this is Kevin. So knowing that the lab results from dependable staffing is approximately 4 months old, would you be okay for us to put in a request for another drug test today just to rule out the substance use?
I mean, at this point, I feel it's just we're going in circles because I already paid for a hair test and a urine test, and then the dependable staffing test, which I agree was 4 months ago. The urine and hair test was done. At this point, I just feel like being punished for something that happened that was out of my control.
Did you have another question, Mr. Dang? Ms. Galvin, you had a question?
Hello, where did you work prior to Winslow? Where were you placed?
I was at Valley Wise.
Okay, and why did that position end?
I was let go due to my attendance,
How long did you work for them?
a year and a half.
Were there employment records that documented your attendance issues?
Yes,
Were you ever drug tested at Valley Wise?
yes,
And what were the results of those tests?
negative.
Have you
And-
provided those to the board?
I have not, I never had a positive drug test screening before.
When was the last day of employment with Valley Wise?
It was, I believe, January 19th, around that time period.
23?
No, this year.
Okay.
So did I understand correctly, you would not be willing to provide a drug test today?
No, I would be willing to. I just feel it's redundant. The fact that, I mean, if you guys want me to provide a drug test every Friday, if you per se, I'm fine with that, but it's just, I feel like I'm being like just punished for something that was.
You
That
you have to
that-
understand, you've got a positive drug test for cocaine
Yes, sir.
and you've got irregularities in your stories. And
It's
we,
just-
so we've got to protect the public. That's our
Mhm.
duty. That's our mission. And we have to have some assurances to continue to allow you to have a technician license. It's a
Absolutely.
privilege.
I completely agree.
I don't think that a drug test would make me feel comfortable in knowing that there's not a substance use issue here. So I'll make a motion for a substance use evaluation.
Do I have a second or any discussion?
Second. The only concern that I have with that is he might be having financial hardship and he might not be able to fulfill a request.
I mean, that's the case for multiple people, and he can reach out to the board to see if there's any resources or if there's any resources in the community as well.
That's true. I mean, I am not disagreeing to that, but I think the simplest approach is to ask for another drug test. It's simple, one-time deal, and then depend on the
Well,
result, we can
And it's much less
proceed.
expensive than a
Exactly.
substance use evaluation.
And
How
then-
would that
Well,
rule out there being a
I'm also,
substance use
I'm sorry.
Hang on just a minute. Let us discuss here.
I don't think one drug test will rule out a substance use issue if there is one.
I would be satisfied with a drug test, but I would also suggest that we have some random test in the future so that to ensure that we don't have a long-term issue here.
To justify the monitoring that you're suggesting, I believe we would have to have a substance use evaluation.
We would.
We would.
Then I would still be happy with a drug test at this point.
If I may, I could do what you're suggesting. Go to the VA healthcare for all my anything so that they would be able to provide that evaluation for, I'm sure, for free.
I don't know. We require a board approved evaluator, which I don't know that the VA is one, but I don't know. That's anyone?
I mean, I'd be in favor of allowing that if that's something that is acceptable.
So I'm hearing two schools of thought, just to kind of try and wrap up to get to a motion. I'm hearing one side potentially wants an substance use evaluation to ensure there's not a problem. Another potential compromise is at least another drug test, potentially requesting the drug test from Dependable also was something else that I heard that was kicked around.
I did make.
Madam Chair,
You did?
there is a motion and a second.
There was a motion and a second. Okay. Any further discussion then?
Within that motion, should we address the change of employment issue that was identified?
He's gonna have to come back before us anyway with the evaluation, I would assume. Correct, Ms. Galvin?
Yes.
The complaint will stay open and we can address it then. Okay.
Dr. Gandhi, you want to do a roll call? I don't know how this is gonna play out.
I can, Madam Chair. Mr. Braswell,
On the motion that I seconded?
Consent agreement for a substance use evaluation is what we're voting on.
Aye.
Interim order for substance abuse.
Mr. Thorwald,
Nay.
Ms. Nair,
Aye.
Ms. Davis,
Nay.
Ms. Walmsley,
Nay.
Ms. Lehan,
Nay.
Mr. Dang,
Nay.
Mr. Al-Nassif,
Nay.
Mr. Anderson.
Nay.
Motion fails.
Do I have an alternative?
I'll make a motion to request for a drug test that has to be done today.
Second.
If I may, it would not be a request, but it would be an order that would be issued. And I don't know that the order can get out today, given that we're in the middle of a board meeting. And what sort of drug test as far as the type of specimen, a urine is only going to get you, maybe 24, 48 hours of what's in the system. Hair and nail goes back several weeks.
Excellent point. Since he has already done a hair test, let's try the nail test.
That'll give you about, the same information. And I'm not saying that a hair test isn't appropriate. A urine is probably inadequate. So I would specify urine and probably a hair.
But not the nail.
With an observed collection.
Observed collection. I do notice that at least part of his hair is colored, is dyed. So we may have to account for that. Because that can skew results.
Mhm.
And with chain of custody, with the results back to the board directly and not through you.
Yes. So in summary, we would like to have both urine and hair test done, Ms. Calvin, today? Or based on,
As soon as we can
as soon as-
get the order out, and we usually, give them
Would,
like-
would I have to pay this myself? Because it is over $200 as I've already done it. It's just financially a hitting point.
Is there any way we can check to see if the VA is certified in this? I would think they would be.
For
Test.
for urine and hair test, I would think. Yes, Dr. Gandhi?
I would think so. I think they would have the ability to do. Most hospitals will have it.
I would say
Do
yes.
testings.
That would be more certain than a substance use evaluation.
Mhm.
Can you go to the VA outpatient lab and have that done today?
I mean, I can go in and ask. I've never done it, so I'm not gonna tell you that it's gonna be a for sure thing. But I live next to the VA, so it's a small walk.
Do you have any connection to the VA? Are you a
I'm
former?
I'm a disabled veteran.
So when the board issued the prior order to get testing, you didn't explore whether you could get that done at the VA?
The reason why I did not go to the VA is because what happened and when the drug test came positive, is not something that I'm not a drug user, because it also not only jeopardizes my work here, but it jeopardizes my health care with the VA.
Do you receive financial benefits in addition to healthcare from the VA?
Yes, I'm a disabled veteran with a percentage rate.
So positive for cocaine would jeopardize those benefits?
Yes, that's why I don't doubt on that situation.
If we go this way, I'm most likely not in favor of it, but if we do, I would want to add a condition that if not done when specified, that we go to hearing.
I agree.
I modify my second to that.
Can we also modify the motion to include the dependable test?
I don't think that is, unless the board members think that is necessary, because in my opinion, that's 4 months old. I think having the test result now will be more prudent for us to make the decision.
If we get the dependable result and the negative result from July and a negative result now, it demonstrates a pattern and that the one positive test was a unfortunate aberration.
Fair enough.
Ms. Galvin, what do you think is an appropriate time period to have this done?
I'll get the order out.
Can have it for you in 10 minutes.
10 minutes.
I don't get paid until next week, so I do apologize.
That
for
is unfortunate and we hear that, but the board's mission is paramount.
But I thought you mentioned that all these labs are done at the VA for.
I said I
free of
could go and
charge.
ask if this could be done at the VA for free.
Okay, so do I need to restate my motion or?
I think we
everybody's
should,
fine?
yes.
Okay. All right, in summary, the motion is we would like to have the urine test, hair test done today or as early as possible. With also, or today, within 24 hours, along with the test result from dependable staffing. And if not, we're gonna go to hearing.
Okay, that's fine.
Second is modified to represent what was just stated.
I have a motion and a second. Any discussion?
Do we need to stipulate the chain of custody concern and those sorts of things as well?
The order will stipulate and require that the results be sent to the board.
Wonderful, thank you.
And I would just ask if you could stay for a few minutes till we get this signed and printed out for you. And I don't know if Jennifer, maybe you can help with that.
I have a motion and a second. Any discussion? Dr. Gandhi, roll call, please.
Mr. Braswell,
Aye.
Mr. Thorwald,
Aye.
Ms. Nair,
Nay.
Ms. Davis,
Aye.
Ms. Walmsley,
Nay.
Ms. Lehan,
Aye.
Mr. Dang,
Aye.
Mr. Al Nassif.
Aye.
Mr. Anderson.
Aye.
Ayes have it with 2 nays, Madam Chair.
Thank you very much. This concludes that matter. If you could hang tight, you can leave the table. Staff will meet you in the hall. Thank you. Do we need a bio break or do we want to take one more? Keep going? Okay, item 12, discussion and consideration of possible action regarding tribal-owned pharmacies operating outside of tribal land. I'm not sure who from staff wants to kind of tee this up, but it also goes into the next item, which is 13A.
I just like to mention something. I'm recused from 13A. But so any discussion include 13A, just need to let me know ahead of time.
Okay, I don't think the discussion in 12, I think it's tied to it, but it's not.
Okay, great.
And I
Yeah.
don't think 12 required
Yeah.
any action either, right? It's more informational.
Okay.
So, Mr. Hargraves, I think you did the evaluation of this. Do you want to just give your brief summary of what you found? Or would you like a member of staff to do it?
Pretty much everything is wrong.
And do we need to go into executive session for this? Yeah, that's true. He is in the middle, writing a board order. Essentially, Mr. Hargraves evaluated whether or not we have jurisdiction over pharmacies that are located, that are operated by tribally owned pharmacies that are outside of the tribal lands. Ms. Galvin, would you prefer that we do this in executive session since there's a legal analysis here? I'll make a motion for executive session. All those in favor?
Aye.
Aye. Are we ready? All right, welcome back, everybody. Thank you for participating in executive session, members. I do not believe any action is required after the legal advice, although it is relevant to our next agenda item. Dr. Gandhi, is that correct?
That is correct, Madam Chair.
All right, so we can move on to item 13A, which is resident pharmacy permit applications requiring board approval. Paskayaki tribe. Is anyone present for Paskayaki?
I'm just recused. Can I just?
Yeah. Hello, Mr. Castaneda. If you could give us a brief summary here.
Excuse me. Good morning, ladies and gentlemen of the board. Ben Castaneda, Compliance Officer. Paskayaki Tribe applied for a resident pharmacy in April of 24. There were some initial questions about the address that was listed on the application versus what was listed on the zoning statement. Currently, the address for location is zoned for commercial use in the town of Guadalupe. I reached out 2 times to the applicant on 6/7 and 6/18 requesting more information, and I never received an answer after substantive review was complete. The tribal representative reached out to a separate compliance officer and stated that based on their tribal 683 compact with IHS, the operation of this pharmacy will fall under federal rules and regulations and will not be subject to Arizona state oversight.
So just to clarify, they're asking to rescind their application because they don't believe that they are under the jurisdiction of the board.
They never stated that. I believe in the communication with the other compliance officer, that question was asked, but it was never fully answered.
Okay. Ms. Galvin, I see you reaching for your mic.
You may just want to close the application, given the statement from the applicant.
Board members, any questions or discussion?
So an appropriate action would be to take no action? Or we just
Close
No,
the
we need to close
application.
it.
close the? I'll make a motion to close this permit.
Do we need to close it without prejudice? Or anything like that? Okay.
Just close the app- I
Second,
guess clarify, I need to make a motion to close this permit application.
second.
I have a motion and a second. Any discussion?
I do have a comment,
Yeah.
Madam Chair. And Ms. Galvin, Mr. Hargraves, this matter is still being discussed with the Supreme Court and could be overturned where we could have jurisdiction in the future. Right. So closing this application, allowing them to proceed may be temporary. I think they need to keep tabs on what the Supreme Court does in the future.
There is no pending matter before the court.
Not
that I'm
pending, but
aware
I
of.
think it may be considered again at some point.
It's fluid, I think is a fair assessment.
That's a fair statement.
Okay, noted. Any further discussion? All those in favor to close the application?
Aye.
Any opposed? Hearing none, motion carries. 13B, Cover My Meds Pharmacy LLC. Welcome, Mr. Morris. If you guys could please take a seat and introduce yourselves for the record, and then we'll be back to Mr. Castaneda.
Richard Chen. I am the pharmacist in charge.
Roger Morris, Quarles Counsel for Cover My Meds.
Go ahead.
All right, Ben Castaneda still, Compliance Officer, Arizona Board of Pharmacy. Cover My Meds applied for a change of ownership permit application. They notified the board on 1/31 with an effective date of 3/1/24. Cover My Meds will maintain the same business model as its predecessor as a non-dispensing site. And there will be no changes to the permitted space, which is roughly estimated to be 130 square feet. Cover My Meds also filed for a deviation for the square footage requirement, pharmacy equipment, sinks, and counters.
Mr. Morris, would you like to add anything?
Sure. This pharmacy has been in operation for 20 years. I have been in front of the board 6 or 7 times renewing these variances and requests. This is simply a corporate structure change within the McKesson organization where they changed the corporate owner of immediately of the pharmacy. Everything else remains the same. So we're just asking to get the permit approved and continue the variances that were there. While I'm here, though, I'm going to ask, we'll see if it's the board's policy to only do variances for 2 years, but it's not a statute or a rule. And their size is not going to change. They're a non-dispensing pharmacy. They're never going to need mortars and pestles and graduates and refrigerators. Do we really need to come back every 2 years?
I totally agree with you, Mr. Morris, and I think we're trying to fix that in some of the rule-making discussions that we've been having to remove some of the specificity of the bright line regulations.
I thought that it had already been approved.
Well, to be clear, this is not a regulation or statute. This is simply policy.
No, the size and the specificity of the
correct.
equipment and some of those kinds of things, that has not been moved
Yeah,
yet.
structural stuff, we don't expect you to come back every 2 years. That's hard to change, right? So.
But
some
we
of
were
the-
looking at changing that rule. I don't think we've gotten,
yeah,
it's
we
not
are.
been noticed yet, though.
No,
Not yet.
Okay. So we're happy to come back every 2 years until it gets changed.
Do we have the ability to approve it longer for Dr. Gandhi?
Yeah, it is not. It's just a policy for operational stuff when they want to try something different. But as far as structural and their business model as a whole, that doesn't change or hard to change. I think you can do what you want.
Yeah, and we have a number of those on this agenda, so I would be in favor of looking at doing that rather than having people continue to come back before us.
I think some of the applicants and permit holders coming back is because of a change of ownership, and that doesn't carry over to the next. That's the other one.
That makes sense.
It's noted here that there was a discipline in 2016. Can you tell us about that?
I believe that was a corporate discipline unrelated to this particular entity. And it was a disclosure issue that they referred back, but it's within the corporate entity and not this pharmacy.
I'd like to make a motion to approve the change of ownership and extend the deviation request until there may be a change in a business model, in which case you'd need to come before the board again.
Second.
I have a motion and a second. Any further discussion? All those in favor?
Aye.
Any opposed? Hearing none, thank you so much. 13C, Redirect PBM LLC. Welcome. If the parties could please introduce themselves.
I'm David Berg. I'm with Redirect PBM.
John Love, also with Redirect PBM, Director of Strategic Projects.
And Roger Morris, counsel for Redirect PBM.
Thank you. Mr. Jacobson.
Yeah, good morning, Board of Pharmacy members. Max Jacobson, Arizona Board of Pharmacy Compliance Officer. Redirect applied for a resident permit with this board. And during the April board meeting, this permit application was reviewed. This board decided to table that application for more information. At the time, the concerns were around the deviation request for no physical space, no continuing quality assessment requirements, and just the overall business model of this operation. Redirect PBM is acting sort of like a transfer hub to transfer prescriptions with no intention of filling them. As of late, Redirect PBM did acquire counsel, and in the most recent communication from counsel, an updated deviation request was received by the board, and that is on page 2473 of your board book. The updated deviation request includes not a deviation from any physical space, but a deviation from the space requirements. They are going to have a small office to house the servers and any other record-keeping requirements that they might need. And they're no longer seeking a deviation for the continuing quality assessment part of it.
Thank you, Mr. Jacobson. Mr. Morris?
Yeah, the proposal that you heard in April has been scrapped. They have a physical facility. It's going to be a traditional non-dispensing pharmacy. They'll receive prescriptions. They will look at pricing information for them, and then the prescription will be transferred at the patient's request. It's consistent with all of the other requests. The deviations are no mortars, no pestles, no refrigerator, no graduates, no things like that that you don't need if you don't have drugs. But they will comply with every other aspect of Arizona law.
I do have a question. I asked this before, but I'll ask you. How is this not steering patients? So what's the assurance that you're not steering a patient to someone who's signed up for this service only? Because I assume that they're only going to use pharmacies that have signed up to be part of this service.
Sure. So I mean, I promised them I would try and limit their talking, but they're welcome to talk if they want. They're looking for the best price. And they're going to look at all kinds of pharmacies and all kinds of issues and information for them. But ultimately, it's the patient's choice. Patient absolutely does that. Patient will be told directly that they can choose any pharmacy that they want. They're simply giving them some pricing options.
I'm sorry, go ahead.
I was just going to say, how is it a PBM?
The name is Redirect PBM. There's a separate business that's a PBM. This is just a pharmacy. They just happen to take the name as Redirect PBM because that's the business ownership.
Oh,
So, do you mind just to walk me through the workflow from A to Z?
So from a pharmacy,
Yeah.
I'm going to answer it real quickly.
Yeah.
You're going to have a prescription that will be electronically, faxed, orally, theoretically mailed in, but I assume most of them will be electronic scripts because that's the majority of it now, that will come into Redirect. At the patient's request, they will have asked their provider to send it to Redirect. If they ask to send it to any other pharmacy, the provider will send it to any other pharmacy. Redirect PBM will get it because it's offering a service. The pharmacy, Redirect PBM pharmacy, it will do a variety of algorithms to try and identify multiple prices for the patient and will identify anywhere between 0 and 100 pharmacies, depending on the locale that the patient says, here's what I want. Do I want mail? What's my pricing? And give them that information. At which point the patient will say, please send it to A, B, or C, or D pharmacy, or any other pharmacy they want, and they'll transfer it off.
Okay, so they will receive the electronic prescription and they put it on hold, basically, right? And then they transfer it to another pharmacy, correct?
Of the patient's choice.
Of the patient's choice. So I asked this question before, but I didn't get that straight answer. So who paid for this service?
The service is, you mean the prescription coming in and
for
why
the
they set it
company.
up?
Yeah.
So
who's
the
paying
idea is
it?
that this will reduce costs to the patients. And I don't know.
Yeah, but
John?
how are you making your money out of this service?
Well, let me try.
Yeah.
Push the button. Go
As
ahead.
I do. So,
It's off.
Your mic's not on.
our clients are,
It'll solve
Yeah.
that.
our clients are self-insured companies, so they have plans, they have health plans, and they hire us to help them manage their programs, their plans. One of the services that we do for them is to help their employees understand the pricing before they pick the location of their services. So that instead of just picking the location and going to the pharmacy and the price being what it is, they get to see the price and the location. So the member, the patient, the employee, they can pick whatever location with the price at the same time.
Yeah, but again, like who's paying you guys?
So the
PBM paying
client,
you or
so the employer is
the
paying us to
employer?
do this service for them.
So it's
And it's not
okay,
related to any
self-insured,
prescription. And it's not related to
employer.
any particular prescription.
Yeah.
It's per employee per month for running the entire program. And this is one part of the program.
And what about Schedule 2? That you can you transfer those control medications?
I am not sure. I don't believe we can, but we do have a pharmacist who would know the rules. of that.
What if happened you received a control prescription?
I believe you
and
controlled out
so,
of this.
Yeah, I believe so.
That
but
Redirect-
I mean, yeah, but the doctors would not know, patients would not know. I mean, I cannot tell my doctors, okay, send 3 prescriptions to my pharmacy in town and this only one, you know what I mean? Like, I cannot like pick and choose.
Well, but
Patients,
there are other pharmacies that don't do controls, and theoretically an electronic could show up at that pharmacy. The pharmacy would refuse it and send it back, just like this pharmacy will.
Call the prescriber. That
Mhm.
is I would see how it was handled.
yeah, I mean, like, so the pharmacy will not be able to receive electronic prescriptions like for control medications, right? but will the provider receive rejection? Will the provider know, hey, you have to send it to somewhere else? And that might cause, and this is what I'm struggling here. It's patient safety, and the system is complicated enough for our citizen. I don't know, it's just adding more things and more for patients to understand. It is very hard. I know, and I know there is many third-party companies try to get into this business, starting with the providers, like giving flack to providers, say, oh, this is cheaper there and cheaper here. Most of them did not do great job there. And many providers and health centers turn off this service. And then they try to do it in the pharmacy level. Now I see they're trying to do it in the PBM level. So plus if I have a concern about patient safety here, if this pharmacy doesn't have any record of this patient, no medical conditions, no allergy, nothing. And then the patients call the actual pharmacy to do transfer, I believe most of the pharmacists will assume this prescription is already verified and clarified by another pharmacist at your company.
But to be clear, and
Yeah.
when a prescription is transferred under Arizona law, the receiving pharmacy has to do all of the pharmacy functions. That pharmacy that's filling the prescription has to get the medical conditions, has to get the allergies, the other indications, the things and everything else. That's what their obligation is. They can't rely on the pharmacy that sent it.
Correct, unless something happened and then we come to us, say, you know what, I assume that happened. You know what I mean? I agree with you. It is responsibility of the pharmacist and for any pharmacist filling this prescription, but still I don't see how it is helping our people there.
Our goal is not to change anything that's happening today, except, this is our goal, except that we want people to understand the price differences at the different facilities and then let them choose where they want to go. That's our intent.
Yeah, but
We
I
don't
see the
change.
PBM responsibility to let their members, hey, this is our preferred pharmacies and done deal.
This is a different kind of PBM, but regardless, this particular pharmacy application, other than the deviations we're asking for, is going to be in complete compliance with all Arizona laws.
So Mr. Morris, as a follow-up to Mr. Nassif's question. So if a prescription is received and the dose is prescribed totally in error, is your pharmacist taking action and consulting that prescriber, or are they just keying what they see from that prescriber and transferring that to that pharmacy? Are they being pharmacists, looking at therapeutic appropriateness and reviewing that prescription for contraindications, et cetera? Are they doing those sorts of tasks?
That is their obligation to do so. And frankly, we used an example. Suppose a prescription that came in and said, take 10,000 Lipitor today. Obviously, that's not a prescription that you're going to fill and be able to work with and use that. They have that obligation. Similarly, when it gets forwarded, the receiving pharmacist also has that obligation. And they'll have to assign a prescription number to it as transfer. But this isn't any different than any other non-dispensing pharmacy.
So the pharmacist at Redirect PBM will assume that responsibility as well. They're
The
not.
pharmacist will fulfill their pharmacist responsibilities, correct?
So in theory, we're having a second set of eyes, which
Mhm.
would also in theory make it safer.
Yeah. I like that.
So this is similar to GoodRx, except the actual physical prescription is being sent, correct?
Very similar principle in place.
Yeah.
I believe the pricing will be better. I believe that it'll be more
Is it
convenient.
for only pharmacies that are within your PBM network?
It will be, but we're going to rent a network that is quite large. And it'll be a network that is consistent with what is already being used by the self-insured companies too. There won't be any changes there.
And if I
So-
recall,
I'm sorry.
if I recall from the April meeting, this has not been approved in any other state yet. And this is the first attempt to have Redirect PBM have a physical pharmacy.
Yes.
Redirect is an Arizona company. They're based here in Arizona.
And can you assure us there is no way to get reimbursement or kickback from any pharmacy, just you pure trying to help patients? I mean, how you can assure that to us? I mean, if you have any statement about that, because it's still, I don't see the concept of the business there.
So there
I'm-
will,
yeah.
there will be so it'll be the cost of the medication,
Yeah.
and there will be a transaction fee somewhere in the neighborhood of $1 to $2. That's normal, that the employer will ultimately pay out of the self-insured claims bucket that it's a
Yeah.
normal way of doing it. I might be characterizing it somewhat incorrectly. The normal way of doing is how we're going to be doing it.
So the employer will pay fee on behalf of their employees to you
Correct.
guys, and you mentioned something about drug there. What do you mean? Like
Yeah, so
there
it's
is,
not so the cost of the drug is the cost of the drug, no markup in the cost of the drug.
okay, so this
There's just a transaction fee.
yeah,
somewhere
this
in
is
the
like
neighborhood of
50 cents or $1,
I think it's
whatever.
$1 and something cents. I
So
don't know the number
it's
exactly.
gonna go out of the employer, basically from the employee. I mean, like there's a fee there.
It'll be coming out of the
From people.
from the
Yeah.
well, the employers, most of the employers, well, there is a contribution from employees, but
Yeah.
most of the contribution is from employers. So this is an employer health plan that is funding it, and this is a way to help them make the cost, the out-of-pocket costs to their employees less, but also the out-of-pocket or the cost to the employer less.
So the claim through PBM will not show like, it shows like acquisition cost or whatever price plus direct PBM fee. It doesn't show in the claim. We'll show it.
Just to be clear, we're talking about PBM functions, and then we're talking about pharmacy
two
functions.
different
And
things.
most of your questions are about PBM. That's okay.
Yeah, but because the name is redirect PBM, and they are trying to like resend prescriptions.
But that happens every day in this country with PBMs. I don't
Well, it
quite
already
frankly
happens in
think
their
that
PBM.
I don't think that that's within our purview. I
Yeah,
mean,
but they're holding it. I mean, they put it on hold, right? And then they redirect.
how is that different than what happens with other PBMs today? I mean, they're here for a pharmacy permit with 2 deviations. I personally am satisfied with the changes that they've made, and I think the PBM piece of it is kind of irrelevant, and I think we could be potentially treating them differently than we are treating other pharmacies that are owned by PBMs. By some of the questions. That's my own personal opinion.
The only difference that I can think of comparing the two different PBMs is that currently the doctors send the prescription directly to a pharmacy. And then the pharmacy will then bill the PBM for that prescription. They are basically, they're the middleman. They're pick and choose which other pharmacy they're going to send.
Every single non-dispensing pharmacy is a middleman because they don't dispense.
Ultimately, their goal is to save costs for the patient. So I don't know why we would want to stand in the way of that. The PBM business is not for our discussion as a board. We don't regulate PBMs, and we all probably have our own personal opinions about them. I know I certainly do, but that's outside of our.
Yeah, I agree with
jurisdiction.
you. Yeah, I agree with you. But I would like to understand from A to Z what's going on. You know what I mean? Like before we approve anything. So I believe questioning, like
No,
all
it's
this.
fine. But what's going to happen is all of this already happens. It's just redirect PBM pharmacy is going to give the patients more options to reduce cost with it so that they understand the pricing. Everything that we're talking about here otherwise already exists. It's just which pharmacy the prescription is going to.
As I mentioned before, I see some similarities to GoodRx. I'll make a motion to approve.
I'll second.
I have a motion and a second. Any further discussion?
Do we want them to come back with any sort of anything before, or
It's-
just the standard 2-year deviation request period?
It's space and equipment, so I don't care about a time frame on it. We'll have the inspector in there for routine inspections and for an opening inspection, so I don't see a reason there has to be a time frame.
Fair enough.
Motion and a second. Any further discussion?
No.
Do we want to do a roll call, or are we good? All those in favor?
Aye.
Any opposed? Hearing none, motion carries. Thank you very much.
Thank you very much.
We are going to take a 10-minute bio break, and then we're going to go out of order on the agenda after that. I'm gonna start keeping a demerit sheet for people that are tardy, even though I was almost tardy this morning. Before the record, we did start on time. Do we want to go ahead and get started? We're missing Miss Snare, but we'll go ahead and get started. We are going to move forward to conferences based on a request for a flight. So we're going to move to conference 25A, complaint number 24-0008. Can the parties please introduce themselves, and then we'll move to Mr. Wagner.
Good morning, Madam President, members of the board. I'm Michael Rain from the law firm Bozen and Snow, and with me is our owner, Mark Bozen, and members and former employees of Civic Center Pharmacy. And I'm going to turn it over to Erica Luton, who will introduce her team.
Hi, my name is Erica Luton. I'm the Vice President of Operations at Civic Center Pharmacy and the current pharmacist in charge. This is Kathleen Jackson. She's our Chief Compliance Officer, and Tennille Davis, who was the former pharmacist in charge at Civic Center and is currently the Chief Advocacy Officer for the Alliance for Compounding Pharmacy.
And with that, Ms. Luton did have some opening remarks, and I would turn it over to her when you're ready.
Just point of clarification. I do know Miss Luton. I don't believe she's named in the complaint. She worked for me in a previous capacity. It won't predispose my judgment in participating in the case, but I want to give you the option if you would like me to step aside to do so.
You're fine.
Okay.
No
Mr. Wagner, if you want to give us a brief summary, and then we'll go to Miss Luton.
I'd be happy to. The complainant alleged that a compounded prescription named Trimix didn't work. The prescription dispensed on October 20th, 2023 was labeled with the beyond use date of November 18th, 2023. When the patient called on November 27th, 2023, it was replaced with a prescription labeled with a beyond use date of March 22nd, 2024 at no charge. The complainant alleged that this prescription also didn't work. Due to a lack of effect, the pharmacy contacted the prescriber for another compounded prescription with an additional ingredient, Quadmix. When informed that the new prescription was compounded to order and would take a few days, the complainant requested to refill his previous prescription for Trimix. When the complainant arrived to pick it up, he was not happy that he would be charged and asked for the lead pharmacist. The pharmacist in charge informed the complainant that the medication would require payment or they would be happy to transfer the prescription to another pharmacy. According to the written statement from the pharmacy staff, the complainant became argumentative and threatened to report them to the Board of Pharmacy. The pharmacist in charge replied, "Go ahead," and indicated that she was on the board. In retrospect, she knew that it was not an appropriate thing to say.
Thank you, Mr. Wagner. Miss Luton or Mr. Rain?
Thank you for the opportunity to come and speak with the board today. I look forward to being available to answer any questions you might have about this incident. I want to reassure you that Civic Center has taken this matter very seriously and has thoroughly reviewed our compounding activities and customer service protocols. In reference to the latter concern, we have implemented immediate corrective action in the form of staff training in de-escalation techniques and best practices for resolving customer complaints. I did want to take a minute to present some information about the product at the heart of the complaint. Trimix is a compounded medication that is used to treat erectile dysfunction. It's a combination of 3 medications administered by intracavernosal injection to increase blood flow to the penis. It is a common treatment modality for patients who have failed or not tolerated commercially available options such as PDE5 inhibitors. When initiating Trimix therapy, careful dosage titration is recommended to find an individualized dose that maximizes effect while minimizing risk of priapism or other complications. It is common for this process to be trial and error, with many adjustments in product strength and injection volume used. Providers will frequently bring the patient into the office for a teaching session to show how to administer the medication because improper technique often results in a lack of effect. Like any medication used to treat erectile dysfunction, results from Trimix can be inherently variable based on physiological and psychological factors. Additionally, if the medication is not injected precisely into the intracavernosal space, the effect can be limited. Upon receipt of the complaint, Civic Center undertook a thorough review of our compounding practices for this product. In the committee, a question was brought up regarding the beyond use date applied to the product. In our original submission to the board, we included Tristel's study on stability of Trimix preparations, which supports the use of the 180-day frozen beyond use date. The product was provided to the patient in the frozen state with an ice pack for transport to keep it cold. We completed all appropriate sterility testing as required for dispensing this product, and those records were also included in our submitted documentation. We are strongly confident in the high quality of the product provided to the patient. In summary, Civic Center is not aware of any concerns regarding this complaint other than the evidence-based approach to beyond use dating of the product. I hope my comments have addressed that concern, and we look forward to answering any other questions the board may have regarding this incident. Thank you.
Thank you, Ms. Luton. Board members?
Madam Chair, I'm just curious as to why was the initial prescription was expired?
Well, and please supplement if you need, but it's my understanding that the prescription wasn't expired when dispensed. It had a sufficient amount of time before the expiration date consistent with the prescriber's instructions to be used in full. The patient came back, I would estimate, about 30 days after the dispensing, and it was expired by that time, not at the time of dispensing.
Thank you.
I have a couple of questions about the exhibits that were presented. So referring to respondents exhibit B1, the sample labels that I assume are affixed to the vials at the time of preparation, the digital zoom makes some of the lettering blurred. Can you confirm that the label includes store frozen, expires in 60 days if refrigerated, discard 28 days after puncture, and used by 3/11/2024? Is that what that says?
That's correct.
Okay. And then talk me through exhibit B6. So which label is affixed to the vial for dispensing, and what BUD is placed on that label?
So B6 is like a printout of the sticker that goes on the dispensing unit. So it has the patient's information on it. The little line at the bottom that says use by is where we indicate the beyond use date of the product as stored frozen. But we do have the auxiliary labels that say to after thawing, do not refreeze and refrigerate after opening for use.
So pharmacists would physically put that 3/11/2024 on that label.
Correct, at the time of dispensing.
Okay. So then your response indicates your stability study, right, and your references from Tristel, published in June 2004, some 20 years ago. You provided the board with a copy of that study, and it supports the 180 beyond use date frozen at -20 Celsius and 30 days when stored refrigerated. So I have some questions on that study. So Tristel used all commercially available sterile injections pooled into an open sterile container for his study. And your formula uses non-sterile API powders, excipients, and sterile water for injection. Can you share with the board what evidence you have to extrapolate the stability data from Tristel's study to your compound when your formulation is prepared so differently?
It's an excellent question. Let me help with that. As you know, Arizona has not implemented the new November 2023 USP Chapter 797, which would have required a stability indicating method assay. We are currently under the previously published 797 that describes how compounded medications beyond use dates can be assigned. And they allow tremendous pharmacist discretion in similarity. And I'll quote from you. Beyond use storage dating. This is Chapter 797 that was published prior to November 2023, page 25. BUDs for compounded preparations are usually assigned on the basis of professional experience, which should include careful interpretation of appropriate information resources for the same or similar formulations. See stability criterion beyond use dating that's found in Chapter 795. It goes on to provide additional information. Trimix is one of the most commonly compounded sterile injectables in the community setting. I would venture to guess that almost anyone who's worked retail community pharmacy in a sterile compounding has experience working with Trimix. We have relied on the Tristel study as well as bracketed studies that have been published by the International Journal of Pharmaceutical Compounding to help us understand the stability and suitability of these medications. And it is common for you to assign, with frozen conditions, a 180-day expiration date based upon the professional experience. I would argue that's the professional standard of care that currently exists in the state of Arizona.
So you bring up the bracketed study. So there's different trimix formulations, as you mentioned, and this study was not a bracketed study from 20 years ago. So bracketed study designs enable a bit more reproducibility in their when concentrations range, because the study from Tristle from 2004, the concentration of alprostadil is 12.5 micrograms per mil, piperavine 4.5 milligrams per mil, phentolamine 0.125 milligrams per mil, and bacteriostatic NS. And your trimix concentration is alprostadil 10 mics per mil, piperavine 30 milligrams per ml, and phentolamine 1 milligram per mil. And these are significantly different concentrations. So here you've got significantly different starting points with non-sterile API powders. You're adding excipients, you're adding preservatives, and that's my next question. So I didn't see any evidence submitted in the packet of any USP 51 antimicrobial preservative effectiveness testing, which is required for aqueous CSPs, to give it a 28-day beyond use date after puncture. Can you share with the board what evidence you have to make that claim on your label?
The requirement for 51 is under the new chapter. This board doesn't have jurisdiction over that yet.
You submitted it in your evidence. You submitted this.
We
in your evidence.
submitted we didn't reprint 797 as it currently exists.
No, you submitted.
But it is the
Mr.
same
Bozeman.
or similar formulations and based upon professional experience.
So
It is consistent with good compounding practices as found in R420, R423, 410, and USP 797 and 795 as it's currently published. And it is consistent with professional standards of care in community pharmacies that dispense trimix compounds. There is a 180-day expiration date on it because they're similar formulations. USP doesn't describe any limits to similar, but relies on professional experience and similar formulations. And another piece of evidence is that no other patient who received this batch reported any adverse events or lack of efficacy.
And it could be because it's a sensitive medical condition that you don't want to bring up. So I commend, the patient for filing this complaint because it is a sensitive medical condition. And to follow up on the USP 51 comment, during the development of any multi-dose parenteral product, the pharmacist makes a decision as to which preservative and what concentration will be utilized in that drug formulation. And interactions with the preservative, with drug products must be considered. And the preservative must also remain effective and not just present or measurable. So you've presented no evidence of that in what you've submitted in the board book. I also am curious, you presented an assay result for phentolamine showing 99% stability 22 days after compounding as part of your quality assurance. However, curiously, your reference study, Tristle, reports that in his results, alprostadil proved to be the least stable of the three drugs, which is the rate limiting factor for the stability of trimix. So knowing this, why are you assaying phentolamine instead of alprostadil?
I have some comments. I'm 99% certain we have USP 51 stability testing on all of our trimix formulations. Additionally, we've dispensed, I asked Erica to run the numbers, 20,000 vials since January 1st, 2020. This is the only complaint that's come to the board, but it's one of the only complaints that we've had, period. Every once in a while there's strength changes. We have to contact the doctor and get a higher strength or a different volume of injection, but it's not a systemic issue by any means. Also, we're not required to do potency testing every time, but we do potency testing randomly, and we do have alprostadil test results, just we didn't happen to do it on this particular batch when we sent the original test results. We would typically do a aqueous product once a year. We would choose one of the APIs to test to make sure that our process is sufficient.
So have you assayed alprostadil and what's the stability of it? What results have you found? Because you didn't submit that.
We have alprostadil's assay, just not on this particular lot that
Well,
we submitted.
in the lot in
information
the
on.
past, what has it been?
It's been within spec, the plus minus
Yep.
10% of expected.
Was it at 22 days after compounding or was it at later dates in compounding? Because we're concerned here of the beyond use state. And your assay for phentolamine, which is not the rate limiting product in the compound, was done at 22 days, 99.4% stable, great. But we're looking at alprostadil. You didn't submit any evidence to alprostadil, which makes me believe that you may have done it in the past and it's not stable at a later period in time because you didn't submit it. But I don't know because you didn't present that evidence. So if that's the chemically active therapeutic product for this patient and it's degraded to such a point that he's not getting any effect, perhaps it is based on stability and confusion with the beyond use stating that is pretty confusing on your label.
I understand what you're saying, except that I would also expect that if that was the case, we would have heard, or they would have heard that they would have kept track of other complaints and concerns from other people, even due to the nature of, variability per person.
And I totally understand that people can vary in their therapeutic response, but and to your point, Mr. Boson, there is a bracketed study in 2021 that was published in the same journal you just referenced for Trimix that has a beyond use date of 60 days. So why have you not revised that or in 2024 and critically evaluated the more contemporary literature for your beyond use states to determine that safe and conservative beyond use date?
The 60-day bracketed study was for refrigerated medication.
Correct.
Storing it, there's additional data that's peer reviewed by Lawrence Trissell that has validated that it's stable for 120 days under frozen. And the basis that this board uses to evaluate whether a compound is made correctly is based upon USP 797 as it existed in pre-November 2023 that describes the basis of the professional experience. And there are different people in this profession who are going to have different experiences, and you and I are going to disagree about that. And I'm sorry.
So just to go back, you guys have dispensed over 20,000 compounds, you said, of this product. Have you had any other claims of ineffectiveness that have been tied to the beyond use date or the preparation of it, to your knowledge?
The complaints that we do get are usually resolved by counseling points, again, on discussing administration technique or adjusting the dose going forward on that. But we haven't had any solely effectiveness complaints that I'm aware of.
Thank you.
So the label is just very confusing. Again, it's good. I would argue without the USP 51 testing, the 28-day beyond use date for after puncture, you can't claim. And Dr. Davis says that you do have that data, you just didn't submit it. Taking that off the table, you're still giving somebody who a beyond use date on the label that is way beyond what you're saying is supported 30 days when refrigerated from Trissell study that you're referencing. So they obviously can't inject a frozen product. They have to defrost it. So once it's defrosted, it's 30 days from Trissell study. And that's a study you referenced and hung your hat on. And you're giving beyond use dates beyond that. So it's very, very confusing to the consumer.
Trissels? I don't know.
So my understanding is that the 60 days refrigerated is the takeaway that we had from the study, and that is indicated on the vial label that's dispensed to the patient. So they receive a plastic vial with the medication, the injection vial inside, and on the injection vial, it indicates the beyond use date if stored frozen, and then an auxiliary statement saying 60 days refrigerated. And then part of our counseling point to the patient is it should not be used 28 days past puncture. We do have somewhat limited space to fit all of that information on there, but we do have both the refrigerated and frozen storage indications.
So what you're saying is that you instructed the patient via the use of auxiliary labels based on your stability studies. So even though it's not on the printed label that we have a copy of, it was included as an auxiliary label.
Right, which was the label, Mr. Anderson, that you were asking about initially. To clarify, that was difficult to read. That sticker that's on the formulation record is what goes on to the actual injection vial that's dispensed.
So why have you not commissioned your own stability test on this product?
It's very, very, very expensive to do so. It is something that we're working on, bringing our sterile compounding into compliance with the updated guidelines and adjusting from there, but it's not something that we have chosen to move forward with for the stability standpoint.
So I think the information that was provided and all of the points in discussion were good, and it gave you opportunity also to look back on things as to kind of learn some things and look at it. But from what I'm seeing and the documentation that's been provided, I don't see a violation in pharmacy law in this here. So personally, I am in favor of dismissing the complaint. And I'll make that my motion.
I'll second.
I have a motion and a second. Do I have any other discussion?
My concern is clearly the labeling of the product and how that beyond use states are labeled and how confusing that is for that patient. And potentially the internal staff reading some of the communication. Some people don't even know when that product is going to expire. And I do believe that an internal commissioned stability study would show you a better beyond use date that you could place on your label versus relying on a 20-year-old study when USP 797 wasn't even in existence. I hope you're doing these antimicrobial effectiveness testing with these multi-dose vials that you're making, because that's the standard, and you didn't present that in your evidence. So I will take Dr. Davis on her word that they are being done because you can't label multi-dose vials without that. And otherwise it's a single dose product and the patient uses it the one time and the balance is discarded. So in the absence of that USP 51 antimicrobial effectiveness testing, you can't make that claim on your label. And overall, I just do believe your label's very confusing.
I just like to add one thing, like, it's very complicated. I understand for patients to understand the expiration date, but I'll give you a very simple example, very simple, not a compounding. When we dispense multiple dose vials in the community, so the label by default says 1 year expiration date. That's how the default, right? Assuming, but we tell patients when you unseal the vial is only have 28 days and should be expired. We don't know when the patient gonna unseal or open the vial. Nobody knows, right? We cannot put 28 days assuming they're gonna do it today. So we count on our pharmacists to have discussion with the patient and educate them. You know what I mean? And that's all what we need pharmacists in our pharmacies to talk to have this discussion. So I see your concern and I understand it, but it's really difficult to have a label has everything with every specific date. So I will agree with the motion for dismiss.
I also would be concerned about the labeling, and I don't see it as that big of a problem. Shelf life. date. Expiration of the product opened. I don't see that as a big problem. I think it should have some changes to show that and make it much clearer and more concise.
Before we vote, I also want to bring up something. So Ms. Davis is also named in the complaint. Ms. Davis, I have a question for you. So there was a statement made that you were a board member. What was your intention in that statement to the patient? I understand that that seems like it was perhaps a little bit of a difficult conversation with the patient, but what was your intention in making that statement to the patient? It looks like you're remorseful about it after the fact, but I'd like to hear from you on that.
Yeah, I definitely was not intending to be threatening or by any means inappropriate. I was more confident in our product, and I was like, yeah, go ahead, make a complaint. I know the process of the board. I believe I know what will happen with the complaint because I have confidence in our product. And so, I invite you to do that. Go ahead. I regret anyway, it may have been taken differently than that, but that was my intention in making that statement.
More just so that it was the patient's right to do so and that the board would look at it like
Yes.
we are today.
Yes.
Additional questions, board members? I think we would need to clarify the motion if that was the case. If it was for both parties, both Civic Center and for Ms. Davis, if we for the dismissal.
Madam Chair, Member Thorwald, could this motion contain something to try to adjust the labeling and to be more clear and concise?
I don't know that the labeling isn't clear to the patient. Perhaps the patient didn't understand it in this particular circumstance. I can think of other products that perhaps if they're stored in different conditions, I mean, you would hate to put an expiration date on a product that was shorter for a patient. So for example, if the patient did keep it frozen for 60 days, why would you want the patient to think that that product wasn't good? Then they would perhaps discard it if it wasn't necessarily correct. Unfortunately, it's different stabilities based on how the product is stored, but I would want the patient to be able to take full use of that product. Perhaps the counseling wasn't clear enough. Perhaps the labeling could have been better, but I don't know that we know today, from my perspective, that it wasn't clear. Clearly, there was some miscommunication with the patient, and perhaps that's a learning lesson, but I don't know.
In the reverse, though, if it's already punctured, you wouldn't want them to use it past a certain date either. So depending on how you look at it, it can be either way. Obviously, you would like them to get the maximum use out of it if it's frozen, but you also want them to get the maximum amount use out of it and not think it's going to be a longer period than what it really is once it's been opened.
I agree.
I think I'd like to ask for legal advice. This is the first time we've had a board member in front of the board, and I'd like some legal advice.
I don't know that that's true, that that's the first time ever, but perhaps for the first time with all of us as board members. I have a motion for legal advice. Did I have a second? All those in favor? Aye. All right, welcome back, everybody. Dr. Gandhi, are you good?
I am.
Okay. Let's start by clarifying the motion on the table. I think it was you, Ms. Lehan, that made the motion. Is that correct?
Yes.
Yes, it was you. It was dismiss. Was your potential motion to dismiss the complaint against the permit holder and Ms. Davis, or would you like to take those two separately?
I think that we could take them separately because there's maybe some questions still on the labeling of the product itself. So I guess I'll make
Or would you like to rescind your
I'd
motion?
like
and
to
we'll start
rescind my
over?
motion, so we can have a little bit more discussion.
Okay,
I'll rescind my second.
okay, let's discuss more.
I will also make a motion to dismiss the complaint against Ms. Davis.
Do I have a second?
I'll second that.
Do I have any further discussion? All those in favor? Aye. Any opposed? Hearing none, motion carries. With Civic Center?
Madam Chair, with all the factual information presented to us, I'm leaning towards deeming that the product is being mislabeled according to the law book.
What, can you go into a little more detail of why you think?
Well, the
that?
expiration date stated on the product is not clear to the consumer. I think the pharmacy could have done a better job with the labeling to prevent that confusion.
I also feel that way.
So saying that, do you have an alternative motion?
If all members of the board agree that this product is fits in the definition of mislabeling, then obviously the pharmacy had violated the board pharmacy law book.
I just like to ask our compliance officer to any of them to have comments on this because I'm not sure. That little bit scare me because can we put anything under mislabeling title? Because our community pharmacies has a right to know about what is mislabeling, what is not.
I agree with you. I personally don't see
Yeah,
a violation. Mr. Wagner, do you want to opine on your thoughts?
I did not see a violation at the time of the investigation.
Thank you.
Madam Chair, I don't see it a violation, but I do see it being confusing and problematic for the average person. And I think it needs to be changed to make that clear and, as I mentioned before, more concise.
Yeah.
I agree with that.
You would have the option of issuing an advisory letter with respect to the labeling, not necessarily finding a violation, but advising them that perhaps they would want to take efforts to make the label more clear.
I like that idea.
Yeah,
It's just an option.
I can make this my motion as advisory letter to the permit holder, and regardless like labeling at expiration date.
Second.
I have a motion and a second. Any further discussion? Do we want to do a voice vote or a roll call?
I would prefer a voice vote. I'm sorry, roll call.
You prefer a roll call?
Mr. Braswell,
Aye.
Mr. Thorwald,
Aye.
Ms. Nair,
Aye.
Ms. Walmsley,
Nay.
Ms. Lehan,
Nay.
Mr. Dang,
Aye.
Mr. Al-Nasir.
Aye.
Mr. Anderson.
Aye.
Ayes have it, Madam Chair, with 2 nays.
Thank you very much. This concludes the matter. Thank you for your time and attendance.
Thank you, Madam President. And just for the record, Civic Center does understand the labeling concerns and will follow up with the board about any changes.
Thank you. Appreciate that, Mr. Rain. All right, let's see. Let's go back to,
Madam Chair, if I can make a request.
Yeah.
There was one that I had informed would be heard before lunch, 18A.
Okay, let's go ahead and take that one then. 18A, Avanos Medical Sales. Welcome, Mr. Meza.
To the board, nice to see everyone. I do believe we have a few representatives on the phone. Hopefully they're about to join.
Do you want to start by introducing yourself and then if they join, if
And
they
my
would like
name
to?
is Nick Mesa, counsel for Avanos.
I'm Amy Weingarten, Associate Director of Regulatory Affairs for Avanos.
Anybody else you're expecting?
We were expecting Clark Wilson. I just shot him a text just to see if he may be
He
able to
just
come.
jumped on. I just
There we go.
admitted him.
Okay.
So fast. Mr. Wilson, if you're present, if you could please unmute yourself and introduce yourself for the record.
Hello, my name is Clark Wilson. I'm lead counsel for Avanos Medical based in Alpharetta, Georgia.
Mr. Avanos, what is, are you barred in Arizona, or are you serving as a fact witness for the company?
I am serving as a fact witness. I'm in-house counsel for Avanos. I'm licensed in the states of Georgia and Florida.
Ms. Galvin, Mr. Hargraves, so good.
That is appropriate.
Okay, thank you. Mr. Jacobson, if you'd like to give us a brief summary.
Good morning again, Board of Pharmacy members, Max Jacobson, Arizona Board of Pharmacy Compliance Officer. Avanos Medical Supply applied for a non-residential virtual manufacturer permit with this board. During the substantive review, it was discovered that there was a change of ownership occurred at effective October 31st of 2022, but the board was not notified until 2024. Furthermore, 2 facilities were listed as third-party logistics, 3PLs, in the application. However, these facilities hold a durable medical equipment distributor permit and a medical gas permit, respectively, not a 3PL permit with the Board of Pharmacy. And finally, a list of products that was directed or shipped into Arizona during the time of the CHOW and the notification to the board is on page 2562 of your board book. And in communication with counsel from Avanos, there appears to be 490 shipments into Arizona prior to the permit being applied for.
Thank you. Mr. Meza, would you like to make a
Sure.
statement?
Yeah, members of the board, I think it'd be helpful to kind of set forth the timeline for this particular issue. As noted, we're here for a virtual manufacturer permit for Avanos's Alpharetta, Georgia facility. The prior entity, Cool Systems DBA Game Ready, was actually issued a manufacturer permit for the Georgia facility in 2018. Fast forward to October 31st, 2022, there was a change of ownership that is not in dispute. Shortly after that, in August of 2023, Avanos obtained DME supplier and distribution permits for the Georgia facility, the facility that's at issue right now. At that time, Avanos believed that the activities that it was engaged in would be covered by the DMA permits, the wholesale permits and the supplier permits. It's important to note that at no time during 2022 and forward has there been any physical distribution inventory from that Georgia facility. Fast forward again to October 2023, staff and representatives from Avanos began to engage in multiple discussions with the board. Deputy Director Kiana Vong was among those who had discussions with the board. Some other facility permits were issued for other locations. At that time, Avanos became aware that their activities would be better covered under a virtual manufacturer permit. And so in April of 2024, after multiple staff turnover, particularly in the licensing side of the house, Avanos applied for this virtual manufacturer permit. So in communications with the board, inspector, after submitting this application, we did determine that there were approximately 490 shipments of a single product directed into Arizona from Avanos's contract manufacturer. During the time when this initially came to light in October 2023, a lot of the focus of the board was ensuring that contract manufacturers were appropriately licensed in Arizona. Avanos has moved forward to ensure that all contract manufacturers are licensed in Arizona. The product at issue is it's like a cold compression and heat compression device for athletic recovery. And so again, after review of records and the like, 490 shipments were made in, but I think again, it's important to note, one, the staff turnover during that time. Two, the fact that this facility and this location was actually permitted as a DME wholesaler and supplier since October 31, 2022, notwithstanding the fact that the CHOW was not provided notice of. But that the folks at Avanos at that time understood that these permits would cover the activity. So we're here to help clean up the appropriate licenses that are needed for this facility. And again, are happy to answer whatever questions the board might have.
Thank you, Mr. Meza. Board members, questions?
So how many items were shipped into Arizona without an appropriate permit?
Approximately 490 shipments were made that contained, these items go together. We provided this information to the board. They're compression sleeves that come with kind of a device that also circulates cold water or heat throughout the sleeve itself. So there are 2 or 3 items that come in a package together, and approximately 490 were sent in or directed in.
So under the DME permit, you wouldn't be able to ship into Arizona?
So
Just want to make sure I understand.
So the DME permits that were issued to this particular entity, they're not doing any type of physical shipment into Arizona from this particular facility. The arrangement really is a virtual manufacturer arrangement where Avanos in Georgia has arrangements with contract manufacturers unaffiliated in other states. I believe the entity that we're talking about here, the contract manufacturer, is actually in California. They're doing the physical shipment. They're doing the actual physical manufacturing and distributing to appropriate customers within the state of Arizona. So I think the intent was right. They wanted to get the right permits back in 2023, but again, just understanding the business model and in communications with the board in October of 2023, it was determined that the best license to have for those activities was the virtual manufacturer license.
Just out of curiosity, why didn't you reach out to the board prior to shipping these items to Arizona?
Well, just to clarify, again, the facility did not physically ship. It directed through its contract manufacturers. Again, Dr. Dang, the entity itself in Georgia believed that starting August 2023, it had the appropriate licenses in place. So Avanos has been very transparent with the board and having informal meetings with staff to understand what type of license was needed. That was all triggered due to additional facilities that submitted applications, one in Tucson, one in California, which have been and are in good standing right now. This all came to light during those times. So again, there was a good faith effort to obtain the appropriate licensure. Unfortunately, the entity did not obtain the appropriate licensure in August of 23.
Thank you.
Thoughts, questions?
Madam Chair, just based on my recollection, in the past, the board has imposed civil penalty to pharmacies that ship items to Arizona without proper license. So to maintain consistency, I don't recall the dollar amount that's tied into each of the item, but
I
we should-
believe, I believe we've done non-disciplinary $10 per item or allow the staff to negotiate a consent agreement. That would be disciplinary.
Mhm.
If
Is it
the amount is
$100?
high.
Is it $100 per
Yeah,
item? or 10?
non-disciplinary was $100.
$100 an
We
item.
do- We do
$100.
need to revisit that during our next committee, but that is what it is today.
So 400, you said 490 items were shipped to Arizona.
Correct.
Multiply that by 100.
49.
Yeah, $49,000.
Non-disciplinary, right?
Or allow
Or
the
you
staff
can
to negotiate.
Was that a motion?
We have to maintain consistency for
Yeah.
the time being. So yes, so that will be my motion.
I second.
So for clarification, it's a non-disciplinary civil penalty of,
They took it out with staff.
They can do one or the other.
was that your motion, Dr.
Yeah,
Dang?
so my motion for now would be non-disciplinary with the civil penalty of $49,000 for all the products that were shipped to Arizona without the proper license.
If you're trying to be consistent, what we had them do before is to negotiate with staff if they wanted to pick either option.
Yeah, so the other option would be disciplinary action, but you can negotiate the fine with our staff. So can be like 49,000 non-disciplinary, or disciplinary was negotiating the fine with our staff here. But we have a motion now for non-disciplinary 49,000 and I second.
Okay, then I'll rescind my motion, then if I may make a new motion. The new motion is to allow them to negotiate with the board staff.
Did we need to address the chow? That wasn't,
Non-reported.
We also need to address the permit,
That too.
or we could wrap it into one motion.
So basically the motion is
Yeah.
giving the option, those two options, right? Non-disciplinary 49,000 or negotiate with the staff.
So no,
yeah.
just simply negotiate with
With the
the
staff.
board staff.
Okay. I, yeah, I'm good.
Related to shipment and the chow.
Yes.
Yes.
Okay.
related to shipment and chow.
Okay, I second this.
So just,
We also need to address the permit.
Accept the permit or approve the permit upon payment.
Yes, of course.
and this would be all disciplinary now because it's being negotiated. It's either non-disciplinary at 49,000 or disciplinary if it's a negotiated payment.
It's open-ended, so it can be either or. So we'll figure that out behind the scenes.
Okay, do we need a roll call for that? Yes, because it might be discipline.
Mr. Braswell,
Aye.
Mr. Thorwald,
Aye.
Ms. Snare,
Aye.
Ms. Davis,
Aye.
Ms. Walmsley,
Aye.
Ms. Lehan,
I,
Mr. Dang,
Aye.
Mr. Al Nassif,
Aye.
Mr. Anderson.
Aye.
Ayes have it, Madam Chair.
Thank you very much.
Thank you.
All right.
Just a
let's-
little note, Madam Chair, the folks
Yes.
in the back of the room are having a hard time hearing us, so if we can maybe scoot to the mic and,
Get the mics a little closer.
yeah, please.
Okay.
Thank you.
Dr. Grundy, if you want to direct, we want to go back to 13A. I'm sorry, 14A.
Yes, Madam Chair.
14A non-resident pharmacy permit application requiring board review, Santa Cruz RX Texas Pharmacy. Is anybody present for Santa Cruz? Dr. Gandhi, do you see anybody online for them?
I do see them, Madam Chair. I think they're coming off of mute right now. I don't see a microphone next to their name. I'm not sure if they have their mic on, Madam Chair.
Do you know who we're looking for?
It says Santa Cruz RX.
If Santa Cruz RX is present, if you could please unmute your microphone and introduce yourself. All right, in the interest of time, let's move on. And if somebody can try and get a hold of them,
I will reach out.
message them. We'll go to 18B, BLA Enterprises doing business as Green Mountain Pharmaceuticals. Is anyone present from Green Mountain Pharmaceuticals?
Yes, I am here. My name is Michelle Violi.
Thank you. Hi, I'm sorry. If you could please introduce yourself for the record.
Absolutely, yes. I'm Michelle Violi. I am the Director of Compliance for Belmar Pharma Solutions.
Welcome. You left and you came back. Mr.
did.
Castaneda, if you could give us a review, please.
Gladly. Okay, so this is a non-resident manufacturer permit application for BLA Enterprises, DBA Green Mountain Pharmaceuticals. During substantive review, I discovered that the facility had been inspected by the FDA in 2021. And that inspection resulted in a 43 issued with the following 5 observations listed in the summary for you. Also, it was inspected in 2019 although there are no 43s issued for that inspection, there were some concerns that were noted during the closeout meeting. It appears that there are some duplicates from the 2019 concerns and the 2021 483 issued by the FDA.
Thank you, Mr. Castaneda. Ms. Fioli, would you like to make a brief comment?
Sure. BLA Enterprises LLC is registered with the FDA as both a food facility for some supplement activities and then also as a drug establishment for API manufacturing. And so the inspection in 2019 was based on the food facility activities, whereas the inspection in 2021 was based on the drug establishment activities. So if the observations were similar or overlapped, they were separate operations at the facility. And I will say that we did, we responded to FDA timely. We fixed all of or addressed all of the observations. Everything has been addressed now. FDA did close out both of the inspections, so they considered our response adequate with regard to their observations.
Have there been any follow-up inspections by anybody since?
Yeah, we have had Colorado, the state of Colorado, into the facility. I believe it was 2020, 2021, and 2022. And those inspections show good results, no violations.
I feel okay to approve, so
Yeah.
I move to approve. Okay.
Second.
I have a motion and a second to approve. All those in favor?
Aye.
Any opposed? Hearing none, motion carries.
We have one recusal, correct?
Yes.
I didn't hear that on the record. Okay.
Yes.
thanks.
Were we able to get 14A back online? Still no?
You can try
Santa,
them. I still see them online, but
Santa Cruz RX, are you able to unmute? Going once, going twice.
still can't hear them.
All right, we'll go to 18C, Pilnova Pharma Inc. Pilnova Pharma.
Yes. Good afternoon to all the Arizona Pharmacy Board members. This is Seshu Akula. I'm the designated rep and the president for Pilnova Pharma.
Hi, welcome. I see Ms. Sutcliffe approaching. If you could give us a brief summary.
Good morning, Sandy Sutcliffe, Compliance Officer. Pilnova Pharma applied for a non-resident virtual manufacturer permit with the board. Their contract manufacturer is Shilpa Medicare Limited, which is located in India. Shilpa Medicare had an FDA inspection in 2020 with 15 observations and then an additional warning letter concerning 2 responses to those observations. Shilpa Medicare then had a reinspection in 2023 that resulted in 10 observations.
Thank you, Ms. Sutcliffe. Would you like to make a statement on behalf of Pilnova?
Yes, sure. So, we are actually a company that specialize in the manufacture of certain cancer medications, both including the finished products as well as the APIs. So endeavor is actually to distribute these products. It is true that, FDA has, they have done a re-inspection in 23 and they have made observations which we're addressing and they're getting, addressed as we speak. And we also would like to point out that they have also given about exemption for about 3 products, and one of them azacitidine, which is an injectable. So that product is exempt, and the endeavor is to actually sell. We are actually one of the largest manufacturers of this product, and we are trying to address some of the shortages that have been coming from time to time. So there are certain very important, I think, life-saving medications. One of them certainly being azacitidine. So our intention here is to dispute these products that are already exempt from the same facility, while we keep waiting for the other FDA issues to get resolved.
Thank you. Board members, questions?
Madam Chair, there's no import alert on any of these products and no recall that was ordered by the FDA, correct?
Yes, there is no import alert on azacitidine. They have given us clear exemption to sell this. Yes.
I believe I move to approve their application.
Second.
I have a motion and a second. Any further discussion? All those in favor? Aye. Any opposed? Hearing none, motion carries. 18B, Mullen Pharmaceutical, Inc.
Hello.
Hi, if you could please introduce yourself for the record.
Yes, this is Marina Malik, and I am the Chief Compliance Officer and designated representative in charge of Mullen.
Thank you. Welcome.
Thank you.
Hello, Mr. Hyber.
Good morning, Board. Steve Hyber, Compliance Officer.
You could go ahead with a brief summary.
Yes, ma'am. All right. Mullen Pharmaceutical Inc. Okay. IT department. Mullen Pharmaceutical Inc. is a virtual manufacturer, non-resident. They're located in Pasadena, California. It's a Chow application change here. And one of the firms, when we did the review of the permit application, one of the CMO firms, contract manufacturer organizations located in Hyderabad, India, hope I pronounced that correctly, was inspected by our FDA for about 11 days back in July of 23. During that inspection, they found some incomplete laboratory records, which resulted in some 483 observations. The applicant was kind enough to put us in contact with the CMO, and we received their responses, and we also received a copy of the FDA 43. They're included within your packet for your review.
Thank you, Mr. Hyber. Would you like to make a comment on behalf of Mullen before we proceed with questions? Miss, I'm sorry, I didn't catch your name. I couldn't hear it when you originally introduced yourself. If you'd like to make a brief statement on behalf of Mullen before we proceed to questions, you're able to do so now.
I'm sorry, can you hear me? Are you with me?
Yes, I was asking if you'd like to make any opening statements before we proceed with questions.
Yes, I can provide some explanation about Gland Pharma. So we are in a initial stage with Grand Pharma. We only have the master agreement with them, but they are not yet our qualified CMO. We are going to audit them. The plan is in August, and no product production yet. And we haven't distributed any prescription products in US, and we haven't used our Arizona license yet. So no products in Arizona too.
So what I'm hearing is that you're not using them currently as a CMO and you're going to audit them before you start to use them as a CMO and distribute products if we issue.
Right.
Okay.
Right.
Board members, questions?
I'll make a motion to approve.
Second.
I have a motion and a second. Any further discussion? All those in favor?
Aye.
Any opposed? Hearing none. Thank you very much. We appreciate your attendance today.
Thank you.
Dr. Gandhi, I think the signal was we're back to Santa Cruz.
Yeah, they said they resolved the issue.
Okay.
They just phoned me. Hopefully it worked.
We'll go back to 14A Santa Cruz RX Texas Pharmacy. Is Santa Cruz online?
Yes, can you hear me now?
Yes, we can. Welcome.
All
If you could
right.
please introduce yourself.
Hi, my name is Sybil Scher. I'm the PIC here at Santa Cruz Texas Pharmacy, and we're applying for a non-residence license for our, we are strictly a veterinary pharmacy. We do online sales as well as local sales.
Thank you. Mr. Castaneda, if you could give us a brief review of the application.
I'd be glad to. Ben Castaneda, Compliance Officer, Board of Pharmacy. This is a non-resident pharmacy permit application for Santa Cruz RX Texas Pharmacy. During substantive review, I found a link on the website to prescription veterinary forms bearing the pharmacy's logo. Excuse me. I did send the applicant an email referencing Arizona Revised Statutes 32-1901.01 in our description of unprofessional conduct. The applicant responded to me saying that the forms had been removed. However, when I went back to the site 2 times on 6/18 and 7/10, they were still active under the resources tab on the website.
Thank you, Mr. Castaneda. Ms. Scher, would you like to make a comment on that? I think we reviewed that again this week and it's still present.
I looked at it because we're making some changes on our website. They initially removed it from the pharmacy tab, and it was also on the resources tab. The form that I looked at yesterday was the customer form. It's just a form if they want to do it in a written manner versus online or call, that type of thing. So that's not something that is a veterinarian form. It's just a customer form.
The form that I see in our board book has a California address. Is San Juan, California licensed in Arizona or just Texas?
Yes, we have two locations or 2 pharmacies. They are, the other California pharmacy is in Paso Robles, and they are licensed in Arizona as well.
So the form I see doesn't have a Texas address on it. It's for the California location.
To open a complaint on the California location because it's now advertising prescription blank on their website.
If I may interject, please. When I Googled Santa Cruz RX Texas Pharmacy, it brought me to that webpage, which then had the link under resources down below.
I checked last night when I was reviewing the board book and I saw it was still there. Is there, this may be atypical, but can we pull up the URL on the screen for the board?
Ms. Kianavong?
And then at the bottom was where I saw the resources link. Ms. Scher, it still appears to be on the board on your public website.
Okay, I did alert them that it was on the resources tab, but I did not see it, that link there on the bottom of the page. So I will, I can definitely get with them to remove that.
This is to gain a permit to be able to ship into Arizona, correct?
That is correct.
It looked to me that on your same site, there's a map and it looks like Arizona is already included as somewhere you can ship to.
It's via their California license.
Correct, the California
California license.
So they share, it looks like you share a common website between the two pharmacies.
That is correct.
I see.
So to your point, we perhaps need to open a complaint on the other permit.
Correct. So I think we should open a complaint. I think Mr. Castaneda placed that permit number in his review. It's permit 5929. So a complaint needs to be opened for that, for unprofessional conduct. And then table this application until they get this fixed. Can we do that?
Is it possible to approve the application pending board staff confirming that it's been removed from the website?
That is an option. It is not dealing with the underlying conduct that it appeared on the website and has for several months.
Even after notice twice by a compliance officer, knowing that that form has a California pharmacy that's licensed in this state. Ms. Scher, did you let your peer know as PIC in California that you were contacted by the compliance officer in Arizona that this is non-compliant with Arizona rules?
Yes, because I responded to him after they removed it from the resources tab. I checked it the following day. Again, I see that it's on the bottom of the website. So we definitely can address that as well. My concern is I did not receive another notice that it was still on there. I thought that it had been resolved. Obviously, I'm learning that it has not. So I can forward that information to them.
Who would you have received that from? Just curious. You said you didn't receive notice that it was still there. Who would you have received that notice from?
Mr. Castaneda, I received that email and I did respond to it, thinking that had already been updated throughout the website. But I didn't realize that was still an issue.
I don't think we can take action on the permit application today until it's fixed. And then I think we need to take action on the California. I find it unfortunate that they have not taken action.
I agree.
If what I'm hearing, there's a potential motion on the table that nobody has made yet to table the application and open a complaint on the other permit.
Correct.
I'll make that my motion, Madam Chair.
Second.
I have a motion and a second. Any further discussion? Ms. Cannavon.
Would you like staff to bring the application back to a future meeting, or would you like us to, how would you like us to address it?
Can we address it in the complaint for the California one and do both in that complaint?
Will be any issue to like for time frame for application? Like is it like 60 days we have to approve it or reject it, or is that right?
They do have timeframes within which to approve applications, but I don't believe that they just received this in June of 2024. So
We're still okay. All right.
So motion stands. All those in favor?
Aye.
Any opposed? Hearing none, motion carries. Thank you for your attendance. The compliance officer will be further in touch with you.
Thank you for your time.
Thank you. 18E Vantiv US Healthcare LLC. Is anyone present for Vantiv?
Yes, hello. Can you hear me okay?
Yes, I can. If you could please introduce yourself.
Yes, my name is Robert Hancock. I'm a director of quality at Baxter Healthcare, speaking on behalf of Vantiv. And I'll give a little bit of background to explain while I'm representing Vantiv. I also have some colleagues on the line from Vantiv as well.
If they could please introduce themselves for the record.
Yes.
Hello, my name is Wendy Holden. I'm with Vantiv in our Canada Quality and RA organization.
Hello, my name is Beatriz Miranda, Director for Rega First Family Organization.
Mr. Hancock, is that everyone?
Yes.
Okay. Mr. Castaneda, if you could give a brief summary, and then we'll go back to Mr. Hancock for additional background.
Yes, so this is an application for a non-resident manufacturer. It's actually a change of ownership. Vantiv US Healthcare split off from Baxter in about July 2024, I believe. We did receive notice of the change of ownership in December of 23. During substantive review, Vantiv provided a list of products shipped in Arizona prior to having a permit totaling 198 prescription-only drugs or devices.
Thank you, Mr. Castaneda. Mr. Hancock, would you like to add anything?
Yes, I would. Thank you. As mentioned, last year in early 2023, Baxter publicly announced our intention to separate the renal kidney care business from Baxter into its standalone company, and that is what will become Vantiv US Healthcare. The split or the separation has not been finalized yet, but it's certainly in the works. On February 1st of this year, that was a milestone for the project when the Vantiv US Healthcare legal entity went live. I want to know, though, it still falls under the Baxter umbrella. So this was really just the first of a multi-phase process in order to separate the companies. As mentioned before, too, we're aware of the state's child notification requirements. We submitted the application in December prior to this February 1st date. And then, this was mentioned to bring and to attend this meeting to help explain the situation. So, the main point is this was just a first part of the separation. The Vantiv legal entity still falls under Baxter. The products are the same. Everything is the same. And since the February 1st date, we still have an active license for this facility under the Baxter name, and we've been continuing to use that license. So that's kind of the story there.
Mr. Castaneda, can you verify that there is an active permit at that Largo, Florida address for under Baxter?
Sure, just give me a minute.
I have the number if that would help.
Yes, go ahead.
Yes, that'd be great.
M000489 is what I have.
I can confirm there's an active permit there.
They didn't ship without a license. They're still just undergoing the CMO, the change of manufacturer, and the change in ownership, it looks like.
That's correct.
Okay, so it appears to be that there's no violation here, as we had originally believed. So I'll make a motion to approve.
Second.
I have a motion and a second. Any discussion? All those in favor?
Aye.
Any opposed? Hearing none, motion carries. Thank you all for being present. We appreciate your time and attendance.
Thank you very much.
Let's go to 21A, Dr. Pharmacy RX. Is anyone present from Dr. Pharmacy RX?
Yes, I'm present.
Hi, if you could please introduce yourself for the record.
Hi, my name is Shivam Banvadia. I'm the owner of Dr. Pharmacy RX.
Welcome. Thank you. Mr. Patel.
Thank you, ladies and gentlemen of the board.
This is in regards to board case number 21A. In front of you, we have a remote dispensing pharmacy application, which has indicated that the owner of the remote pharmacy is a medical practitioner. As you might know, that ARS 32-1930 prohibits a medical practitioner from receiving compensation, either directly or indirectly from a pharmacy, as a result of the practitioner's prescription orders. This medical practitioner owner has provided an attestation letter confirming that he will not send any prescriptions to the applicant pharmacy or the supervising pharmacy. The medical practitioner already owns the supervising pharmacy since 2022. And on a side or important note, the medical practitioner was not a medical practitioner at that time. He was a medical student owning that supervising pharmacy in 2022. So this application is before the board for your consideration.
So they own pharmacy, right? Before, like previously they have a pharmacy, now they're applying for remote dispensing pharmacy based on the other pharmacy, and the owner wasn't a medical practitioner. Do we audit those usually, like when we go to pharmacy, because they have the station, like they never send prescription to this pharmacy? Do we do audits?
We don't necessarily audit that part unless we get information that this person is a practitioner now, and then they can't be sending prescriptions to that pharmacy.
Yeah, because many cases we did not allow like practitioner to own pharmacies, and unless they sign this agreement, I wonder if we can follow up with this, because we want to make sure because it's going to be an issue if it's not compliant.
He has signed a letter of attestation, and that's on board book page 3238, the next page.
But he signed it, but I don't know if he's compliant with that. I'm just curious.
Yes, if you'd like to make a statement.
If I may, please, I don't also mind to give you guys my dispensing records as well. I haven't filled a single prescription for anything that I do. I actually practice far away from my location, so none of my patients actually have it accessible to even use the pharmacy, and I don't dispense those types of medications as well. So neither of those things would be applicable. I don't mind to even give those records as well. I mean, we're coming up on our 1-year inspection anyways, so that's not a problem for me to give those records as well to further that. But I did have the attestation. This was something that I had discussed when we opened the pharmacy too, with the inspecting officer as well. I told her that, I am a medical student. I don't have a license. But, eventually I will graduate and become, a resident physician. I still don't have an independent license either. I actually practice still underneath the institution. So I don't even have a license of my own. But this was things that I did disclose, and it wasn't an issue at that time because I didn't have a license. That's why. But going forward, kind of to that point, I still do have that attestation. I mean, also on the inspection, I was warned that, this will be something that whenever any compliance officer does come to inspect our site, that is records that they will be looking at to make sure that I don't dispense my own prescriptions, of course. And that is something that, I have those records as well. But it is something that, we follow strictly. My staff is trained that if there is any prescription with my name on it, we are not allowed to fill. Of course, due to legal reasons as well as state law. And so that is something that we have been complying with.
Great.
I'm comfortable with the fact that you have a good understanding of what's required. And because you've written this attestation, I'll make a motion to approve.
I have a motion. Do I have a second?
I'll second.
Second.
Any discussion? All those in favor? Aye. Any opposed? Hearing none, motion carries.
Thank you very much.
Thank you very much.
We have 3 minutes, Madam Chair.
All right, I'm gonna get crazy. We'll go 22A. Novatum Pharma LLC.
Novatum is for tomorrow.
Oh, it's for tomorrow? Okay. What can I still do then? 24A? That one's probably going to take a little bit longer. Let's go ahead and break for lunch. Come back at 1 o'clock. Sound good?
Sounds good.
Thank you. Welcome back, everybody. Dr. Gandhi, do we need to do roll call or are we good? Everybody can see us.
Yeah, I think we're good, Madam Chair.
Okay, very good. We had a couple of requests to take some items early. If you could direct me where we're going, 29B as in boy, 29B, which is Raymond Alan Chavez. Welcome, gentlemen. If you could please introduce yourselves.
Hello, board. Thank you for having us. My name is Raymond Chavez, license holder in Arizona and member of the PAPA program.
Hello, board, and thank you for your time. My name is Ryan Grease. I am the current steering committee chair for the PAPA program and also part of the AZPA board of directors and a PAPA graduate. Thanks for having me.
Good to see you again, board members. Jim Corrington. I'm a licensed clinical social worker, and I ran groups for the PAPA program from 2000 to 2019, and also for the Arizona Medical Board Impaired Physicians Program for the same amount of time. And so I'm semi-retired now, so I get to come back and do PAPA groups, which is I really love. So I'm here to support Ray and give you confidence that he's in good shape and ready to go. Thanks.
Thank you. I see Ms. Mitchell has joined us. I believe the request before us today is to lift the probation for Mr. Chavez.
Yes, I'm here today to request a discussion for potential removal of my consent agreement with the board and with my monitoring program through PAPA.
Thank you. Ms. Mitchell, is everything in order with his current consent agreement?
Yes, staff has no concerns with the request.
Terrific. Mr. Chavez, can you tell us a little bit about what you've learned through your journey?
Yes, I'd be glad to. I've been in active recovery since December 16th of 2016. And to answer that question fully in 5 or 10 minutes is impossible. And I think it can be summed up in a couple of different, key words is patience. I learned a lot about through my journey in recovery and all of the associated things I learned about myself, that having patience and a delayed gratification was something that I strongly needed. And then second word is just acceptance. There was things that as I went through my journey and I evaluated, there's things outside of my control and things within my control, and choosing to focus on those things that I had control over has really given me the ability to really change my life. I've since being sober and in recovery, I've happily marriage, we just celebrated our 4-year anniversary. My relationship with my oldest daughter, who's 13, has, gone through the roof. We've, have a 2-year-old daughter. And, the relationships that I have with my friends, with my family, and then obviously a work relationship has all vastly improved because of my state of mind.
I'm glad to hear that you're doing well. Board members, additional questions or comments?
I don't have a question, and obviously there's no concern from my end. I don't know if the state see any concern. No. Okay, so I move to approve the request to terminate his probation.
Second.
I have a motion and a second. Any further discussion? All those in favor?
Aye.
Any opposed? Hearing none, thank you very much for being present and best of luck to you. I'm glad to hear that you're doing well.
Thank you.
Next request was 29D as in dog, correct, Dr. Gandhi? Okay, 29D for Daniel Peter Hayes. Is Mr. Hayes present? Mr. Rain, you're appearing for this one? Okay, please.
Present.
Yes, Mr. Hayes is appearing virtually.
Awesome. Mr. Hayes, if you could please introduce yourself, and we know Mr. Rain, so I think we're good there.
Hi, I'm Daniel Hayes. Have been a pharmacist for ages, and nice to meet everyone. Thank you.
Thank you, Mr. Hayes. Ms. Canavong, were you going to provide some sort of comment on this one? Or another member of staff?
I can do that.
Okay.
So on June 24th, 2021, Mr. Hayes' consent agreement for probation treatment, rehabilitation, and monitoring became effective. And the terms of that consent agreement are outlined in your board materials. On July 12th of this year, Mr. Rain submitted a request to appear before the board to ask for modifications of the terms of that consent agreement or the termination of Mr. Hayes' probation. His request is included in your materials, as is an email from Ms. Fine at PAPA, as well as a copy of Mr. Hayes' contract. Staff has also included correspondence from the Nevada Board of Pharmacy regarding his current license in that state. This year, the Nevada Board of Pharmacy did reinstate Mr. Hayes' license to an inactive status. So the letter from them is in your files. There's also an email from 2021 from Mr. Bozen, who represented Mr. Hayes at the time, indicating Mr. Hayes' willingness to participate in a 5-year monitoring program.
Thank you, Ms. Canavong. Mr. Rain or Mr. Hayes, would you like to make some comments?
Yeah, I'll just lay out a couple quick bullet points, and Mr. Hayes has a written statement that he'd like to read for you. And I know that the materials are there in front of you, so I'll just be as brief as I can and note that this was conduct that occurred in the state of Nevada that led to the probation that Mr. Hayes is currently on, and that occurred at the beginning of 2020. 2021, the Nevada board revoked Mr. Hayes' license for that conduct, which involved the diversion of some medication from a hospital pharmacy. That was March of 21 when Nevada revoked, and then Arizona had its reciprocal case here for that same underlying conduct, which you've heard resulted in Mr. Hayes agreeing to a 5-year term of a PAPA contract. In recent months, the Nevada board has chosen to reinstate Mr. Hayes' license. The inactive status, honestly, Mr. Hayes may educate you more than I can on that, but it's my understanding Mr. Hayes doesn't intend to return to Nevada or practice there at all, nor does he really plan to live and practice in Arizona. And staff had some questions why he wanted a license, and why not just turn your license in Arizona if you don't want to be here. And he doesn't know what the future brings, but what he knows currently is what he wants to do with his life is to move to the European Union. He has a path towards German citizenship as a descendant of a Holocaust survivor. And that's what he'd like to do with his life. And so the thoughts are twofold, really. One is that, compliance with the terms of a PAPA monitoring contract would be quite difficult from abroad. But I think, as Mr. Hayes may discuss with you in detail, he considers himself rehabilitated and well in terms of his mental health, the issues that led to the conduct that led to where we are today. For some time, he's felt well and healthy, and he has the support of PAPA in that feeling that he is in a good place and fit to continue practicing. And the continued work that goes into compliance with a PAPA contract, I think, as Mr. Hayes, again, will have more color to share with you on that. It's becoming more of a negative aspect to his life, a reminder of the past, things that he's doing now, not necessarily for his own mental health, which he feels, well positioned in currently, but just because he has to. And so it's also this negative continuing part of his life that I know, putting everything aside, he'd just like to now move forward. And so with that, his contract was 5 years. This board historically used to do 5 pretty much every time, as far as I understand. Sometimes now you might see a 3 or a 1, different year terms. But it's my personal impression that the 5, it's not clinically based. It's more of a routine. And so the request here would be He has been under his agreement for over 3 years. He's had no instances of any concerns or violations along that, throughout that time. And so the request, I think, number one would be to consider the early termination after over 3 years, which is the sort of terms you might offer someone in the present day, rather than have him conclude the 5 years. If that is something the board is not comfortable with at this time, then, you know, the thought would be maybe we could modify the agreement or reach some understanding that he would be living abroad and find a path where, you know, the board could be both comfortable and he would not have to fear that he's going to violate a probation because of his life circumstance if he moved. So with that, I spoke way too much. I would definitely like you to hear from Mr. Hayes. Yeah.
Thank you, Michael.
Just one
Mr. Hayes, just let Ms. Nair ask a question really quick.
real quick, Mr. Grace. Actually, it isn't my understanding that at 5 years, the reason why that was chosen was for a clinical reason, being that it increases the amount of recovery time probability to as high as 80% is what I recall. Can you comment on that?
Absolutely. So Mr. Hayes' situation is a little bit different than most of the people we have in the PAPA program, that he's under the mental health arm of it and not the substance use. So there would be a potential different, I don't have that literature in front of me from a mental health standpoint, but you are accurate from the substance use component.
Mr. Hayes, if you'd like to go ahead.
Thank you. And so, dear members of the board, I'd like to thank you for the opportunity just to even speak today. I'm here respectfully to request a reconsideration and moderation of my probationary term from 5 years to 3 years. For over 20 years, I've been dedicated to the pharmacy profession, and it's been my privilege to train numerous practitioners and contribute meaningfully to the field. Despite facing personal and professional challenges, my commitment to the profession has remained unwavering. The circumstances that led to my probation were rooted in personal hardships and mental health challenges, including a diagnosis of, adult onset narcolepsy. These challenges were further exacerbated by significant personal losses and an unhealthy relationship, which profoundly affected my judgment at the time. I fully acknowledge all responsibility for my actions and since have engaged in extensive mental health therapy. I've worked diligently to rebuild both my personal and professional life, and I fully adhered to all conditions of my probation, including completing the 400 hours of voluntary service. I'd like to highlight that my current probationary status imposes significant limitations on both my personal and professional prospects. I've applied for German citizenship and I'm waiting for the finalization. It's not only a chance for me to reclaim my family's history, but also to expand professional opportunities within the European Union. However, the continuation of my probation could potentially hinder this opportunity. My rehabilitation efforts have been recognized by my healthcare providers and are supported by the Pharmacist Recovery Program, PAMPA. In May of 2024, my Nevada license that was revoked has now been reversed after a thorough review of the work that I've done and the positive progress that I've made. And Michael was right. I did not choose to keep the Nevada license active. I do prefer to have an active license, but that one is currently inactive. So in light of the Nevada reversal, I'm respectfully petitioning for an adjustment to my probationary term in Arizona. I've successfully maintained compliance with my probation, my agreement with PAPA, and as Ryan said, they do support this petition as well. And my request is that the board consider reducing my probationary term to 3 years. I believe this adjustment would support my ongoing commitment to upholding the highest standards of our profession while allowing me to continue my professional development and community service. I sincerely appreciate your consideration of my request, and I hope for a favorable resolution that acknowledges the progress I've made in my rehabilitation and contributions to the profession. Thank you for your time.
Thank you, Mr. Hayes. Dr. Gandhi?
I just want to draw your attention to page 5176, Madam Chair. It's a letter from the Nevada Board of Pharmacy. And in paragraph 2, though Mr. Hayes's license is inactive, reversed from revocation, so it was active then inactive, it was based on our action of putting him on probation and being monitored. So I do want to point that out. So it wasn't clearly that Nevada thought he's on a good path now. Let's reinstate him and then let's put him in active status. He knew we were monitoring him.
How long has he been on monitoring? 3 years?
About 3 years now, yes.
Is the last evaluation he had from our evaluator, this one from Dr. Jaffrey in 2021? That's in the book.
As far as I know, it is.
Based on the evaluation, I think I'm personally comfortable. Without going into the substance of the evaluation, it's on page 5214. It looks like Dr. Jaffrey recommended 2 years of monitoring. If I'm reading it correctly. Do others see it the same way?
Do we have an option to lift the probation, and with the, an order that if he returns to the US, he comes before the board again?
I don't know. I mean, we might need legal advice because I don't think that the consent agreement was modifiable, right? Is the only thing that I'm thinking here. Or can we always modify it? Do we need legal advice?
You have the discretion to modify.
But we would need to issue a new order. I don't know what that would look like.
Depends on what you want to do. So if you want legal advice, we could do that.
Okay. Additional questions, anybody, or do we want legal advice?
Dr. Hayes, has a letter of support by your current medical provider been provided to the board? I didn't see that in the book. Dr. Hayes, do you have endorsement by your current medical provider?
By my psychologist, Dr. Barbara Digman, she did send in a letter of support.
What was the name of your current provider? We have a letter from Barbara Digman
Correct, that is her.
in Tumwater,
Oh, I'm sorry,
in Tumwater, Washington.
correct.
Do
And
you
we
see-
see each other at least twice a week via remote.
You see this physician remotely, well, provider remotely.
Provider remotely. And it's also just because, excuse me, where I live is also fairly remote.
Board book number 5184. 5184.
Madam President, just because it may not be evident that Mr. Hayes resides in Washington presently.
Thank you. That's helpful.
I guess it's a semantic argument. I don't think he plans to reside in Arizona, but this would be, as my understanding, and Daniel, please correct me if I'm wrong, it would be the license he keeps and his only American pharmacy license. That's his ultimate plan, is my understanding.
Correct.
Sounds like he's got a Nevada license. It's just inactive.
It's inactive. And again, I don't want to speak for Daniel, you know, the traumas that he suffered in his personal life occurred in the state of Nevada. And I believe that he has no desire to return to that state personally or professionally. When at some point, I would imagine, Daniel, you might relinquish that license in Nevada, but I can let him clarify.
Correct. I will never return to Nevada for professional nor personal reasons. And that license will always be kept on inactive status.
Mr. Hayes, if you're planning to move to Germany, you said, why do you need to keep your US license? Is that a requirement to get licensed there?
I'm not necessarily sure if I'm moving to Germany. It's European Union. Once I have the German citizenship, I can live in Europe. And currently I work for a non-licensed position within the pharmaceutical industry in this country. There are several positions there that I've been looking ahead of time at that do require pharmacist licensure. So I would require the path to go through licensure in that foreign country.
Board member had a question about whether this was the home state. Mr. Hayes is reciprocated here in Arizona.
My home state is New York, and New York has been inactive also for a long time.
But you have to keep your home state.
I don't think it has to be kept in status.
Dr. Hayes, what's the status of your New York license?
Inactive.
How did it become inactive?
I left New York and put it on inactive status years ago.
I make a motion for legal advice.
Second.
I have a motion and a second. All those in favor?
Aye.
Board members, additional questions?
Dr. Grease, Dr. Hayes has been compliant with his PAPA contract living outside of Arizona. So there's been no physical requirement to be here within the state of Arizona to meet the requirements of his PAPA contract. Is that accurate?
Yes, that is accurate. He's been able to do his recovery meetings and drug testing and mental health appointments without being within the state of Arizona.
Thank you.
What would stop him from continuing that in the EU?
Should I answer that? Okay. I'm not sure that it would necessarily. That's why, in the beginning, I mentioned that there's these two concerns about whether he could. And I can let Daniel say if he has any specific concerns, but the alternative is also that it's what Dr. Digman and Mr. Hayes think is also best for his mental health at this point, given that they consider him fully, healthy and rehabilitated from the mental health perspective. And that this is just a continuing, as she put it, it's a consistent reminder of a very unfortunate time in his life that he's working to move beyond at this point. But Daniel, if you have any particular concerns about your ability to comply while in the EU.
Part of it is going to be the ability to do the required drug testing. I'm not sure how that would work within different countries if things are available. Something I have no idea about, just as the daily check-ins, with it being between X time. If I'm in another country, those times will be off and I could be in violation of it.
Dr. Grease, what sort of concessions are there for somebody who's traveling or out of the country with their daily check-in requirements?
So historically, we have, I'm going to say, vacation, not override, there's a better word for it. But those are typically for like a 2 or 3 day window, potentially up to 2 weeks for someone going out of the country. They can still complete, I can't speak for all the EU nations, but they are still recovery meetings of sorts that are other places. So we could be creative, or there is an opportunity to be creative to find out what those were. Typically, if someone's on a vacation override, whether it's 2 or 3 days, there isn't a requirement to do the UA testing because it's going to be hard to navigate in that realm. So there's generally restrictions on, like, for the first year recovery until you've proven that you're doing this correctly, that you wouldn't have the opportunity to take that type of a vacation because we can't prove that you're being monitored correctly. When someone is being successful, then we extend the time that they can be gone. That's fair.
Thank you.
What takes place in a daily check-in?
I'm curious as to what he's exactly mean by that. With the Recovery Track app that they have to check in to be able to understand if they need to do a urinalysis or some form of drug check. I have not personally played with the app as much as I probably could or should have. My impression is that you check in on the app and it likely does have a 24-hour rolling cycle. I think that it is pretty live. Here in Arizona, we have 24-hour labs that we can use. I just don't know from the European Union, like, what their infrastructure is. I would imagine that there's something, but what that dynamic would be, that the limitations between when you could check in and then when you'd have to be able to test, we'd have to be creative potentially. I don't know if there's a problem or if it's just projection.
So it sounds to me like we can come up with solutions that could allow him to continue within the program.
I think Papa would be very willing to be as creative as we need to in order to be able to do this long term, if that is, or longer term, if that is what is required by the board.
Because there's no drug abuse portion of his diagnosis, is it able to amend the PAPA contract to take that part out where he could not have to do urinalysis?
So really good question. I don't know, and my apologies because I'm somewhat filling in a role. I don't know if it was added to the consent agreement, so we might want to have to double check if that was something that was from the board, because there is concomitant substance use and mental health, and they kind of overlap a variety of times. So I would just want to make sure that it was part of the wasn't part of the consent agreement, and then I think Papa would be very willing to, as long as we're following what the board
There
mandate.
was a diversion in the original
Right.
findings of facts.
But what was the diversion medications that were controlled substances?
No.
For his own personal use as well as for the use of at least one other person is what it says in the findings of fact. I believe so. Mr. Hayes, were they for controlled substances?
They were not controlled substances.
They were not controlled substances?
Correct.
At 3 years recovery, this is for Dr. Grease. At 3 years recovery, what is the frequency generally for somebody on this track? Once a month, twice a month? How often are people randomly selected to drop a urine specimen?
So to be candid, we don't have as many people in the straight mental health track. So Daniel's one of the first that are navigating that process. So our familiarity is much more with the substance use realm. After 3 years, if someone is doing as good as Daniel, that they are doing everything legitimate, I would say twice a month is typically where they're at, and then potentially could go down from there on the 4th to the 5th year. So between 2 to 3 times a month.
That does not sound like a undue hardship.
Madam President, may I? I do believe that the current consent agreement would need modification if you would be willing to allow PAPA to work cooperatively. I do believe that it's quite restrictive. The agreements used to be even, a little more restrictive than otherwise. So I don't think that PAPA could do it on its own. I think we would need some leeway to maybe work with staff and PAPA to craft something that we could all agree is the plan moving forward. And, I just want to make one clarification, which is that what we're hearing is that there isn't information or a history about the mental health track. And that, I guess it was my understanding that the testing issues that were just described weren't necessarily directly relevant to Mr. Hayes's situation. He didn't have a drug abuse issue. That wasn't why he was in the program. You had the evaluation, said 2 years. All contracts used to be 5. And so we would just ask you to think of what is the clinical basis when this program is designed to rehabilitate your licensees, not to be punitive against them. I'm just not sure of what clinical basis exists currently or in the original evaluation to say we're going to do 5. That's what he agreed to. He understands that. But I would just say if we're asking clinically based questions, then I think we should remember that the original clinical opinion was only for 2 and he's already beyond 3. But I do want to be clear. I let Mr. Hayes know if we can just leave today with some progress of any kind, that we'll be happy with that. And if you get to making your motions, I would ask that maybe you try to think of a way to delegate with PAPA and the board staff, a way to try and craft something that we might need to bring back to you, or that you would, give them some terms, because I do think we need to modify the agreement if you want to do anything different, because it's pretty black and white. You have to test, you have to do that. And even if we all understood that today, that we all were in agreement, it would still be a technical violation. And so that's all for me.
I don't know what those 2 more years will help the situation. I mean, me personally, he's been on probation for 3 years already. And I believe that there's a recommendation from providers, from PAPA program also, right? You support? Do you
Yes,
support
that is correct.
Okay, that's what you hear. So I feel comfortable to end his probation. I mean, regardless if he's going out of country or not. I mean, he's safe to practice or not safe to practice. Regardless, this is what I'm going to.
I agree with you. Based on the facts of the medical evaluation, and solely based on the facts of the medical evaluation, it's said at the time that he was safe to practice, but would benefit with 2 years of monitoring. He's completed that successfully. PAPA has no concerns with it. His current medical provider has no concerns with it. What Nevada did with his license, to me, has zero bearing on what our action is, but simply based on the medical facts that are in front of us, I'm supportive of ending it personally.
I'm sorry, I make my motion based on the original recommendation from evaluation, so to end his probation.
Second that.
I have a motion and a second. Any further discussion? Do we want to do a roll call or voice vote? All those in favor?
Aye.
Any opposed? Hearing none, motion carries. Thank you, Mr. Hayes. Best of luck to you and glad to see that you're doing well.
Thank you very much.
Let's see. Go back to 24. 24A, complaint number 23-0693, Jacob Wayne Doan. No, is that right? 23A? Oh, I'm sorry, that was 24A. 24A. Sorry, wrong number, but right person. Is Mr. Doan present? Do we want to proceed?
Yes.
Yes. Okay. Ms. Mitchell, go ahead.
At its February 2024 meeting, the board considered complaint number 23-0693 filed against Jacob Dunn. After review and discussion, the board decided to offer Mr. Dunn an interim consent agreement for substance use evaluation and interim suspension of license. He agreed to the consent agreement and underwent an evaluation with a provider approved by the board. Staff received the results of his evaluation on July 12th, 2024, and the matters being returned to the board to review the results of the evaluation and to determine how to proceed.
Thank you, Ms. Mitchell. Board members, questions or discussion?
It looks like based on the psychologist's recommendations that he is not fit to practice.
That's how I read it as well, Dr. Davis.
It's unfortunate he's not here to answer our questions. He's currently on probation. Is that the status? Oh, interim suspension.
My kind of initial thought was to leave him in a suspended status for a period of 6 months. And put him on a PAPA contract and then bring him into probation. We can evaluate him after 6 months suspension and see if we can move him over to a probationary status. I don't know what that motion would look like, Ms. Galvin, but I think that there's evidence that shows if he's able to be abstinent of alcohol for that period of time, that he's more likely to be successful and perhaps he could pass an evaluation.
Would you consider offering him that consent agreement to enter into a monitoring contract? Would the 6-month suspension include the time that he's already served under the interim consent agreement?
When did that go into effect?
February of 2024.
But his psychological evaluation says he's not fit to practice. So a PAPA.
And he's going to have to be evaluated to have fitness for duty acknowledged by a licensed professional before we can take action, right?
As I read that, upon his return to practice after this timeout, then it would be a reevaluation.
So a standard pop-up.
It would be a standard monitoring contract with a 6-month suspension, a reevaluation at that time,
But it's been 6 months.
Right, we're at six.
Except for his medical evaluation was in May, end of May.
And what I'm hearing you is that you want an additional 6 months.
I believe that's what the evaluation is indicating.
Yes.
I mean, he's not showing a lot of interest in wanting to keep his license, and we're putting a lot of effort into creating a motion to enable him to a pathway, and he's not even here today.
A motion could be to offer him a consent agreement with a 6-month suspension followed by a term of probation that would include monitoring and random drug screens, a typical term. And then a reevaluation to take place before that suspension is terminated. In the alternative, you could move to accept a consent agreement for voluntary surrender. We could work with him.
I would make that my motion. I think that's a good solution.
Now, you're offering a consent agreement. You could also add in there, if he does not accept, to proceed to hearing, then he had the
I love
option
that.
of signing a surrender, or it would come back to you for hearing to finally resolve.
I'll
Saves
amend
it.
that as part of my motion.
I second.
I have a motion and a second. Any discussion? Dr. Gandhi?
Mr. Braswell,
Aye.
Mr. Thorwald,
Aye.
Ms. Snare,
Aye.
Ms. Davis,
Aye.
Ms. Walmsley,
Aye.
Ms. Lehan,
Aye.
Mr. Dang,
Aye.
Mr. Al-Nassif.
Aye.
Mr. Anderson.
Aye.
Ayes have it, Madam Chair.
Thank you very much. Item 24B, complaint number 24-0217, Devin Jean Bryce. Hello, Mr. Bryce, if you could please take a seat. Push the mic button and introduce yourself, please.
Hi, my name is Devin Bryce.
Ms. Kianavong, would you like to give us a brief review?
Be happy to. Okay. Hi again, board members. Jennifer Galnavong, Deputy Director. Mr. Bryce was issued a pharmacist license on July 23rd, 2013, and his license expires next year. His license is currently suspended due to entering into an interim consent agreement for drug screening, substance use evaluation, and interim suspension effective on June 25th of this year. On April 16th of this year, Mr. Bryce self-disclosed to staff that he diverted tramadol from his former employer, Walton Drug, for personal use from 2021 to 2022. The investigative materials included in your file indicate that Mr. Bryce admitted to taking tramadol 50 milligrams from a Script Pro machine and tramadol 100 and 200 milligrams from stock bottles over the course of more than a year for personal use. He created manual entries in the drug dispensing software to account for the tramadol he took, which served to conceal the loss of the medication and trigger the automatic ordering software to add tramadol to the controlled substance order list. Mr. Bryce made manual changes to deduct tramadol from the inventory, but these entries did not necessarily reflect the amount of tramadol he diverted on each day. During September of 2022, Mr. Bryce quit working at Walton Drug and discontinued diversion and abuse of tramadol altogether, according to his account. At the time, he worked at Mount Graham Regional Medical Center in Safford. He denied taking controlled substances from the hospital. Your files show that Mr. Bryce worked 66 days between June 12th, 2021 and September 19th, 2022. On 49 of those days, there is a record of Mr. Bryce manually adjusting the dispensing records to remove tramadol 50 milligram tablets, 100 milligram tablets, and or 200 milligram tablets. Mr. Bryce removed a total of 7,021 tramadol 50 milligram tablets, 690 tramadol 100 milligram tablets, and 1,170 tramadol 200 milligram tablets. He worked each day. The dispensing records reflected the removal of tramadol. And it shows that he removed tramadol from the pharmacy again between June 28th, 2021 and September 12th, 2022. On May 23rd of this year, staff notified Mr. Bryce of the complaint against his license, and on the same day, he agreed to enter into the interim consent agreement that I mentioned earlier. As a requirement of this agreement, Mr. Bryce provided a hair and urine sample. He complied timely with that requirement. Both resulted negative. Also, as a requirement of this agreement, he underwent a substance abuse and fitness for duty evaluation. The evaluator's report is included in your files. So we're here because in his agreement, upon receipt of the report, the matter will be presented back to the board. And based on the evaluation, it's before the board to take whatever action you deem appropriate.
Thank you, Ms. Cannavong. Mr. Bryce, would you like to make a comment?
First of all, thank you for allowing me to be here today. It's definitely something that I deeply regret. I certainly wish I could take it back. I hold a lot of guilt and shame over it. But obviously that's not something I can do. I can just try to do my best from here on out. I did stop that day in September of 2022 and have not taken any controlled substances since then. And I just also would like to say, I love being a pharmacist. I love this profession. It allows me to be in a profession in the community feeling like I make a difference. And I just really regret what I did. And I just really hope to get back to returning to the profession. Thank you.
Board members, questions, discussion?
There is none. I'm willing to make a motion. Offer a consent agreement for a 5-year probation to run concurrent with a PAPA contract. Sign within 30 days, must make written request for probation to be lifted, may not serve as BIC.
5-year probation? What's the standard on our contracts? Aren't they 2?
We just had one in front of us, 5 years.
Yeah, that depends upon often the recommendation by the evaluator. The evaluator did recommend the 5-year track.
Sorry, I was thinking suspension in my head and I was like, that is very long. Sorry. Yes, I'll second that.
I have a motion and a second. Any further discussion?
And that would be lifting the suspension and moving straight to probation, correct?
Yes.
Dr. Gandhi.
Mr. Braswell.
Aye.
Mr. Thorwald.
Aye.
Ms. Nair.
Aye.
Ms. Davis.
Aye.
Ms. Walmsley.
Aye.
Ms. Lehan.
Aye.
Mr. Dang. Mr. Al Nassif.
Aye.
Mr. Anderson.
Aye.
Ayes have it, Madam Chair.
Thank you, Mr. Bryce, for being present. Appreciate it and best of luck to you.
Thank you. I do have, am I allowed now to return to work? Once
Yes.
You'll
be presented with a consent agreement, and if you sign that consent agreement, you can go back to work under certain conditions.
Right.
If you don't sign, we will be going to formal hearing.
Right. Okay.
So you'll get additional paperwork.
Madam Chair, if I may circle back to 18E Vantiv US Healthcare. Just want to clarify certain things with Vantiv. I think they may be on as Baxter right now on our virtual.
Yep. Hello, this is Robert Hancock again.
Hi,
Robert,
Mr.
thank
Hancock.
you.
Go ahead, Dr. Gandhi.
Thank you. Mr. Hancock, just for a point of clarification, you had separated from Baxter in February of 2023. Is that correct?
Let me walk through the timeline again as it's a
Yeah.
little confusing. So on February 1st of this year, we took the first step for the separation, which was essentially creating the Vantive US Healthcare LLC legal entity. Still under the Baxter umbrella at that time and still under Baxter to this day. So we're still all Baxter. That was just step one. The final separation date, I believe it was mentioned earlier, July 1st of this year. That was a date that the company had initially targeted for final separation. That date has since been pushed back to a little later this year, and certainly once that date's known, it'll be communicated to the board.
Okay, but just to plan for all this, you had applied for a change of ownership back in December of 2023, correct?
That's correct. With that February 1st, 24 legal entity date in mind.
Okay. So currently, right now, you're not operating independently. You're still connected to, but you have an application in, and that was just approved earlier. The concern the concern I had was you had separated operating on your own. And in my head, you hadn't applied maybe in time, but it looks like you had. So it wasn't to clear the air and some questions I had.
Okay.
Okay. So right now, I'm sorry, if you can reiterate when your independence is from Baxter.
Yeah, so it's to be determined. The February 1st date was step one, what we refer to as our soft spin. That was just to get the Vantive US Healthcare LLC legal entity established. But at that time, and still to this day, we're all under Baxter. And once the date of the final split or the final separation is known, certainly we'll come back to the board with more information. We expect it to be by the end of this year, but we do not yet have a final date.
Okay. And your location has not changed, right? It's still at the same location as it originally was?
That's correct.
Okay. Perfect. Thank you for jumping back on the line to answer a few questions. Madam Chair, that does take care of my concerns.
Okay, thank you. Thank you, Mr. Hancock, for being present.
Thank you very much.
All right. I think we're going to 25B as in boy. Conferences. Complaint number 23-0558. Welcome. If you could please introduce yourselves.
I'm Michael Rain with the law firm Bozen and Snow, and with me is Fahad Al Noah. And I am expecting Mr. Zach Bergen to join us virtually. He'd been kind of waiting. He's working in practice today, so I've just let him know if he happens to be a little late. I do expect him in a moment.
Or do you want to go ahead and proceed, or do we want to come back to you?
Proceed, I
Okay.
believe. He should be. I've just been communicating with him. He's just got to log in. And I'll be very brief as well, because I think that this is a pretty open and shut factual case, is at least my impression. But I understand that the violation in question is whether the pharmacy at a hospital pharmacy had provided adequate notice of its intent to discontinue or its discontinuation of pharmacy operation. And you have the two PICs that were working there in and around that time, in Mr. Al Noah and Mr. Bergen. As it pertains to Mr. Al Noah, actually, his time as PIC ended before the pharmacy engaged in any discontinuance of any kind, however that term might be defined. And so we made the argument in the brief. We don't really understand why he would be the one that you would hold accountable for having provided the notice of the change in pharmacy operation that happened after he was no longer in that role. But as to Mr. Bergen, I think we explained it, as well as we could in the writing, that they weren't. The hospital made the decision to discontinue, not discontinue, to pause operation because it had, as I understand it, the management company had parted ways. They had no census there at the hospital, and their plan was to resume within a period of time that I think began at 30 days, and then 30 days became 60, 60 became 90. But the intent was never to discontinue the operation. It's my understanding that if you go there today, pharmacy is operating. It may be operating differently, but it is operating. The intent was never to permanently close. But as to the PICs who didn't make the choice whatsoever, they had no knowledge that it wasn't going to be a temporary pause. And so there, Mr. Alnoa and Mr. Bergen can describe, what they did to secure the pharmacy, what they were hearing from the people making these decisions that would not have put them in the position to know we're supposed to tell the board anything, because it was never supposed to close. And so that's what we're here for. And they can describe some of what they were hearing.
Mr. Wagner, can you give a little bit of background from your side of things and what you've observed?
I'd be happy to. Thank you, Mr. Rain, for going through part of my summary. In October of 2023, Compliance Officer Patel arrived at the hospital pharmacy to conduct a routine inspection. He was told by the operations manager on site that the pharmacy had not been operational since February of 2022. The operations manager had the keys to the on-site pharmacy, and they entered the pharmacy space. No drugs were present. He was told that no drugs had been ordered, stocked, or dispensed from the on-site pharmacy since February of 2022. CO Patel was also told that the management company had changed and there had been no PIC as of September 15th, 2023. They were in the process of hiring a new PIC, but had no plans to resume on-site pharmacy services for several months. During my investigation, I discovered that the hospital itself had ceased operations in February of 2022. Records were on site for pharmacy operations up to that point, but no records were found for the transfer of drugs when operations ceased. There was no record of notification to the board that the hospital pharmacy had suspended operations or closed. Hospital operations resumed in September of 2022. The on-site pharmacy management company continued to staff a PIC on site who was responsible for checking deliveries, reviewing patient administration records, conducting medication room inspections, and serving as a pharmacy resource for nurses and administration. No records of these activities could be found on site. Additionally, the on-site pharmacy management company did not dispense medications from the on-site pharmacy. Prescription orders were sent to an external pharmacy for filling and delivery to the hospital. The on-site pharmacy management company shared that they were instructed by hospital ownership to refrain from ordering medication through the hospital pharmacy wholesale account until hospital census increased. In September of 2023, the on-site pharmacy management company severed its contract with the hospital. The hospital then hired a new PIC in October of 2023, who was drafting policies and procedures as well as performing the functions previously provided by the on-site pharmacy management company. However, again, all medications were sourced from an external pharmacy provider. Additional information obtained following the conclusion of the investigation included a civil penalty assessment to the hospital from Arizona Department of Health Services in December of 2023. And you can find that on page 3925 of your board book. The assessment was in response to a survey conducted by Arizona Department of Health Services in August of 2023 that resulted in several violations, including failure to ensure that the hospital had a pharmacy that was directed by a pharmacist. CO Patel again visited the hospital in April of this year, and upon arrival, it appeared to be permanently closed. The contact name and number was posted, and he called the individual and was told that the hospital had been closed since January 5th, 2024.
Is the pharmacy now operational as well as the hospital?
I just want to be clear that Mr. Bergen came after Mr. Alnoa as PIC, and Mr. Bergen ended his role as PIC in October of 22. So I know we heard a lot of stuff about what's going on in 23, but we're here today to talk about as PICs what they were supposed to notify you of. And Mr. Bergen was no longer PIC as of October 22. So I'm not familiar with any of those facts about 23, and I don't understand why they would be relevant to what Mr. Bergen should have notified the board about the pharmacy's status back in 22 when he, October 22, when he ceased.
Are you here representing Tallis Harbor? Or are you
Nope.
representing
Only
the
the
two
PIC.
pharmacists?
Bergen and Alnoa, no one else. I understand there's a separate complaint involving Tallis Harbor that we've been trying to see when that would come to the board, but I don't,
They're named on this complaint as well.
Correct.
no, I don't represent them. I only represent the individuals.
So when did Mr. Alnoa cease being the pick?
We have that date here in our materials. You can answer, you know.
Yeah,
July 2021.
Yeah, so as my role, I'm a regional pharmacist, pharmacy manager, and my role is typically helping the place get set up. And so I'm like the pick on paper to help get things launched. And then it gets, we hire a PIC to work. So I was PIC 2021.
Do you work for the management company or do you work for Tallis Harbor?
No, I work for Advanced Pharmaceutical Consultants. We're like a third party outside pharmacy service provider.
So you are not here in representation of the permit holder?
Nope.
Do we have anybody representing the permit holder?
Were they noticed? Was the permit holder noticed?
And in case it's of any help, I've had no interaction with anyone from Tallis Harbor, and it's just never been part of our consideration.
Tallis Harbor as a hospital is closed at the time, at this time. So we did serve them, but I don't know if they're gonna appear.
So the entire hospital is closed? Okay, that's helpful.
I thought we just established that the pharmacy was operating.
Pharmacy is on administrative hold right now. They have not been operating for a number of years. They, in essence, what we call them is a ghost pharmacy. Basically, they serve the purpose of upholding what DHS requires of a hospital to have a pharmacy on site. They had a pharmacy, but it was not an operational pharmacy. It was a placeholder.
So if the hospital is not operating today, there's no need for a permit.
And it appears that all of the conduct is really on the permit holder is the way that I'm looking at it. Is that fair, Mr. Wagner? Your mic's off.
I'm sorry. I believe so. There was no notice to the board for ceasing operations in, I believe that was February of 2022, when that 6-month period of no operations and the hospital had ceased operations as well. Whether you call it a closure or a pause, that's up for debate, I guess.
What were the dates of Mr. Bergen's employment?
Employment, I'm not sure he could let you know that, but he became PIC in at the end of Mr. Alnoa's time in July of 21 and served in that role until October of 22. The cessation of services was February of 22. So from February of 22 to October of 22, that's when Mr. Bergen was PIC at the location, but it was in this reduced, paused operation. And if Mr. Bergen has joined us remotely, I think, it may be beneficial to hear from him that the information he was getting about that this was going to eventually reopen, and what operation was happening under his watch of any kind.
Mr. Bergen, are you present?
I don't see Mr. Bergen online. Madam Chair, if I may ask a question too. The contracted pharmacy, that's who you worked for. Were you guys supplying the Pyxis machines and stuff like that, or?
So they actually owned their own machine. They had only one unit.
What were you guys supplying?
We were
the inventory.
At one point, we were ordering the drugs, filling the machine, processing the orders and all that.
So where did those drugs go?
It got transferred to their sister hospital in Bullhead City.
So
at the time,
the corporate permit holder still has a presence within the state of Arizona, sounds like.
I don't want to speak for them, but.
Do
they
we
haven't-
have a trail of where the medication went? I know you're saying it was sent there, but do we
Yeah.
have?
Yeah, well,
I found no records at the hospital when I went there.
Says he's on.
What's his first name?
Phone number. in it.
Zachary? Yeah, I use Zachary iPhone. So he is on.
Mr. Bergen? Mr. Bergen, can you hear us?
Oh, this may be better now. I apologize.
That
I
is
kept on
best.
hitting unmute. Yeah, kept on hitting unmute and it would not go. I apologize. I'm only on my phone at work. I do apologize.
Thank you. If you could please introduce yourself for the record.
Sure. My name is Zachary Bergen. I'm a pharmacist in the state of Arizona.
I think what Mr. Rain wanted is for you to provide some context as to what was occurring. If you want to repeat your question,
Yeah,
since
what did you know and when did you know it? I think is the classic question about the closing of the pharmacy.
Sure. At the end of February, we were given notice that the medical provider was no longer going to be there and that pharmacy operations were going to be suspended for a while. And this was in rapid fashion. I worked through Fahad to get contact with Talus, but all we knew was going to be a temporary suspensions of operations and that we were told to hold operations.
were you the pick of the pharmacy at that time?
Yes, up until I think it's February 2022, and I was kept in as a kind of, I guess, a placeholder. I was not working any more hours after that point.
But you were the pick at the time that the pharmacy ceased operations.
That is correct, yeah.
Okay, thank you.
So, Mr. Bergen, if it ceased operations and you didn't notify the board, I mean, there is still also a requirement to be operational 40 hours a week by hospital permit unless there's some sort of exception. Why did you not make any notice on that?
and I just want to jump in. We did have a deviation to work.
Yes, that is correct.
It was also, I think we were there for like 20 hours a week or something like that when at
Yes.
the peak of our operation.
That is my understanding as well, that I had seen some of the correspondence between Fahad and Dennis Wagner, the board.
Was there evidence that a pharmacy was there 20 hours a week? A pharmacist was there 20 hours a week?
I did not see specific evidence, but they did have a deviation for less hours per week.
I know Mr. Rain's already touched on this some, but I'd like to hear from you, Mr. Bergen. What were you doing when there was no operations within the pharmacy?
Basically, there was no operations happening. I was not there, and we were waiting for instructions to continue and resume.
Yeah, and if I could just jump in. So at the time, after the drugs had been transferred out and we were told it's going to be about 30 days or so for them to start taking patients in again. Let me just back up a second, if you don't mind. It's a little bit atypical, the whole thing. So, so in February of 22, we were told that they're going to close operations. That kind of got passed up the chain through me. I contacted my corporate office, which is located in Miami. My boss is a pharmacist, and then she let her boss know, who's the owner of our company. He reaches out to the hospital owner. He says, no, we're not closing. There's a problem with the management. They had another company named Kindred Healthcare that ran the hospital. They left rather quickly. And so the hospital owner told owner of my company and kind of passed it down. We're not closing. We're going to just replace the management. We have to replace the computers. I need you guys to help with getting a new wholesaler account because the wholesaler account was owned by Kindred, I guess. So we transferred the drugs. Zach pretty much on paper was a pick, but I was helping them get ready to admit patients again. So I helped them get a new wholesaler, and I was part of some meetings. I helped them with getting a new EHR fine-tuned, things like that. And then a month passed, and then they said, "Oh, we need 30 more days," and
Yes.
it kept on kind of going until I think it was September or something like that. At that point, we hired a new pick. We were prepared to order drugs again because we had a new wholesaler account. The hospital owner again said, hold off on ordering drugs, I think for financial reasons. So they wanted us to help them get a cheaper option, which is an outside like pharmacy that can deliver drugs every day. And then every month we were told, you can order next month, you can order, eventually we decided, we're not ordering drugs. We're really not operating as a typical inpatient pharmacy. And our company decided to terminate the contract, and we recommended that they surrender their license, which I believe they didn't, and they hired another pharmacist. And then I'm not sure what happened after that. So I hope that helps.
It's a little complicated to me now. I'm just trying to follow. I mean,
Yeah, I know.
I couldn't. So
Yeah.
I'll try to simplify just for me to understand.
Yeah.
So when Mr. Bergen took over as a PIC, was the pharmacy operating at that time or
Yeah.
was on pause?
No, he became PIC. I think it was like July of 2021.
Yeah, please don't give me dates.
Okay.
Yeah, the time he started as a PIC, he
Yes.
got hired.
Yes.
Was the pharmacy operating and
Yes.
there is medication
Yes.
inside the pharmacy?
Yes.
Right.
That is correct.
Correct. So in the pharmacy, then the owner decide to pause the business there and transfer the medication to a sister pharmacy.
Yeah.
And then when the PIC should notify, let the board of pharmacy know that business on pause or discontinue the pharmacy. And that's when I see the PIC responsibility there. Now, and then the owner decide to proceed the business again or no, and right?
Yeah.
And Mr. Bergen is still PIC and you right at that time?
No. He was PIC during the time that I was helping them prepare
Okay.
for patients again. Yeah. And then
Okay.
we hired another PIC.
I think what I'm hearing is Mr. Bergen ceased to be the PIC when they stopped pharmacy operations. Is
Yeah.
that correct?
He was, he
his
bridged
role,
it, I think, right at the around the time. He was picked when it was operational, and from July of 21 to February of 22.
Right.
February 22 is when the operation reduced. So he was picked at a time when it was more traditionally operating. And
Originally said October of 2020.
Yeah. He was a PIC on file between February and September of 22.
September.
Yeah.
well, I know we don't want any more dates. He was literally the pick from July of 21 to October of 22. The period of complete, change of operation was from February 22 to September 22. So it did not resume any operation as it had historically done while Mr. Bergen was pick. It did have an operation when he first started. Then he's told, we're going to pause, we're going to come back about 30 days. And that just kept going and going, where they never did resume as they had promised. He's then replaced as pick when they are ready to resume operations. Someone else took that over.
So Mr. Bergen, why didn't you report that they stopped operations if you were the pick?
So from what I was told, we were going to reopen in a month. And then unfortunately, that did not happen. Was, requested, are we going to reopen? And that went up the chain through Fahad and ownership through APC. And Talis said they were going to reopen. Please don't notify the board. That we know, because we are not going to be ceasing. We're going to be restarting. And that just unfortunately continued for a long period of time.
So in summary, we're here today because compliance officers went into that hospital, went into a pharmacy that was non-operational because the PIC didn't do his or her duty to notify this board that was non-operational. That's in summary what I hear.
Yeah, also I have just two more questions. I'm just trying to get the whole story. It's difficult for me to get it now. So basically the pharmacy is not just stopped. You kept functioning, right? But instead of using your own medications, you ordered from external pharmacy for patient specific, right? And I see this, we have few pharmacists here, board member work for hospital. You do that, right? In the hospital, sometimes you ask infusion pharmacy to ship medications. Is that right? Or you don't do it? like I know that in the rehab hospital sometimes like they don't have like a hood to mix IV meds.
If it's patient specific.
Yeah.
And medication that's shipped to the
there
hospital,
are
that's allowed,
So that's what you did.
but a normal
Okay.
everyday inventory.
So the pharmacy did not like stop functioning because they getting medication from outside pharmacy, right?
And the hospital that should be on site
Yeah.
pursuant to DHS's requirements was non-operational.
Okay, great. So yeah. So
And if I could just, I think it's simple. I started out saying it was simple and obviously I was quite wrong, right? But at the end of the day, what we know is Fahad Al-Noa was not the pick anymore when any of this started, right? He was gone before any of this cessation. So as to Mr. Al-Noa, I don't understand how he didn't have an obligation to notify anyone of it as pick.
I don't disagree with that.
So that one, I think we put aside. And then as to Mr. Bergen, even assuming that the discontinuance means something less than just complete permanent cessation or the intent to permanently cease. I think that the mitigating factors we wanted you to understand was that he wasn't in charge of the decision and was routinely informed. This isn't permanent. This is temporary. And we don't want to notify the board because we plan to reopen. In hindsight, of course, he would have said, well, I'm going to tell them anywhere, communicate with the board, let them know what's going on. And none of this would have ever probably been a thing. And
Exactly.
so what we have is a notice failure with the mitigation issue. I would argue as a legal matter, it wasn't a notice failure because there wasn't a discontinuance under his watch. It was a pause as far as he knew it. And there was minimal operation occurring. But ultimately, it's a notice issue, and his mitigation is, I didn't know it was not going to reopen, and they kept telling me otherwise. And eventually I left, and then it did reopen. The promise was kept eventually, then it again ceased. But there was a period where this pharmacy began its operation again, as had been promised to Mr. Bergen over a number of months. It's just by that time, he was no longer the pick. And he just was not aware that it was going to be as it ended up being.
And if I could just say one more thing. So just to be fair, had we thought that the pharmacy was closing in the traditional sense, I think that would be a different story. The way that I saw it at the time also is, and like I said, I typically help with starting up pharmacies in hospitals, and we are oftentimes issued a permit or at least a temporary license. And we don't have any patients. And at the time, we're basically helping the hospital prepare for their patients. And that's the type of phase that I thought that we were in, a 30-day, okay, let's get a wholesaler license, let's get the place set up. And it's not that it was closing in the traditional sense. And so that's where we were coming from.
I'm sorry, did pharmacy have any control medication in stock?
In February, yes.
Yeah,
Like
and that transferred to a sister.
They were audited and transferred, yeah.
Yeah.
Yes.
And this is another concern, is not only notifying the board, also the whole chain of custody for moving medications, and that might include control medications.
Yeah.
Also,
That was-
also another concern.
Mr. Bergen, did you notify the DEA when you transferred those controlled substances to Bullhead City?
We did, yes, we did fill out a 222 and submit the copy to the DEA. Yes, we did.
What about the C2s through 5s? C3s through 5s?
Yes,
Yeah.
Where's the document?
I believe we did. I believe it, at least the C2s, I believe we did. We followed all the legal requirements.
We have a copy of all that.
Yes, we did.
Should be, if it wasn't in the pharmacy, I can provide a copy. I'm sure we have it in our.
It was not in the pharmacy when I was there.
Yeah, I'm sure I have a copy of it and I can share it if the board would like to
And
see.
I just want to make it clear when the inspection occurred is long after Mr. Bergen had left, is my understanding. A year after, so.
Mr. Bergen, when did you notify the board that you were no longer at the PSC of this location?
Honestly, I don't remember exactly when I notified that, like as in on the website when you say you're employed there or not.
Yep.
I honestly don't remember when that was changed. I do apologize for that.
October of 22 is when he submitted, I think, the PIC change forms, or those were submitted to the board. That's the date I have for the end of his time as PIC.
That's what I was looking for. There's a lot of pages here.
Yeah, we have in here October of 2022 is when he entered his end date for Taos Harbor.
Okay, yeah, that sounds right. I did not have a specific date. I do. It was sometime in that time range, yes.
But is it fair to say that between when the pharmacy temporarily closed in September to the date that you notified the board that you were no longer the pick, that you were aware that it was not operational?
Can you restate that? I'm sorry.
Between the time that the pharmacy became non-operational in September, I believe was the time, to when you notified the board that you were no longer the pick, you knew that the pharmacy was not operational.
I think it's different dates. It's between
Yeah.
February of 22 and October when he ceased being a pick, that he was picked during that range, February to October. And throughout that time, the pharmacy was in this status of,
So it was
Off.
non-operational between February and October while you were a pick.
that is accurate.
thank you.
As to the timeline.
Yes.
Thank you. Okay, that's helpful.
And then it started back up approximately after he left.
Right. I mean, essentially, they replaced him as pick, is my understanding, because they were about to start and they were getting the pick that was going to run the operation when it did resume.
Where my head is I do think Mr. Bergen had at least some responsibility to notify the board that he was the pick and knowingly knew the pharmacy wasn't operating for a pretty long period of time. It wasn't like it was a couple of days or even a couple of weeks. It was months. I agree. Mr. Olnoa does not have responsibility here. Taos Harbor certainly has responsibility here, but they're not here today. Kind of where I'm thinking, just to kind of start to throw something out there for discussion, is potentially a letter of concern to Mr. Bergen, dismiss the complaint for Mr. Olnoa and bring Taos Harbor before us as a hearing. That's kind of where my
Can you state that again?
dismiss the complaint for Mr. Olnoa, letter of concern for Mr. Bergen, and bring Taos Harbor in for a hearing.
My thought was the $250 non-disciplinary fine for the Mr. Bergen for failure to notify us that the pharmacy wasn't in operation.
Non-disciplinary civil penalty.
Yes.
I could get on board with that too.
Yeah, I agree with that. But usually it goes to against the permit holder, right? Not the PIC usually. It's standard.
In this case, notice of closure is both responsibility,
Both
permit holder and
responsibility.
PIC.
Okay.
We haven't decided what we want to do with the permit holder yet.
Right.
Yeah.
The fact that the permit holder is not here, has not complied. They've been subject to DHS inspections and there's been a bunch of issues. I feel like we need to bring them in for a hearing. I'm kind of to the point of, first of all, they don't need a license. So do we revoke it? Which we can't do today. That's kind of where my head
And
is.
I don't know if they've ever been operational, Madam Chair. I have a survey from DHS here dated August 31, 2023, and they had nothing on the premises inside the hospital. So I don't think they ever resumed operation.
One option would be to dismiss the matter against Taos Harbor without prejudice. And that would allow you to resume investigating the issue or questioning them about the issue should they reappear.
They still hold a license in Arizona, right?
They have, yes, in Bullhead City. And that was my question again. Or do they have a similar operation going on in Bullhead City?
Yeah, I've never been there. I don't know anything about their.
Just as a
I think it's
contract.
a traditional. I think it's a traditional inpatient pharmacy operation there, and they have a different company that runs it. So
okay.
I mean, I still have questions about like documentation of what happened to the medications, different ways that things were handled. I still have some unanswered questions.
Mr. Patel, do you have something to add?
Yes, this is Chirag Patel, the compliance officer. So Taos Harbor in Bullhead City shut down earlier this year in January when they let their DHS license lapse. They hadn't renewed it, and so they had to shut down the hospital and the pharmacy both at the same time earlier this year. And they have not resumed operations yet.
Did they notify us?
Yes,
They did? Okay.
they did notify us. The pharmacy did everything right. They had no choice but to close down because the DHS license expired.
I didn't make a motion. I just threw out something
Well,
for
I
discussion.
agree with you. I would like to have them come in. I think that a hearing would be appropriate for the permit holder.
So when they closed, do you know where did they transfer the medication?
I do not recall where they transferred. Oh, sorry, I do now. They sent it back to the reverse distributor, and she had invoices and
Okay.
records.
If they're closed and they don't have any other pharmacies, are they going to show up to a hearing? Like, are we just wasting time to waste time?
Who do we notice?
But we need to have the hearing to revoke the license.
Yeah.
Unless
We can still make a ruling even if they're not here, can't we?
an option would be to close the permit, you said?
No, you would have to do that through some sort of consent or hearing.
But again, they're not going to sign it if they're not in business.
And I understand they expire in February.
No, the end of October.
Oh, end of October.
You know, if you send it to hearing, the notice of hearing would go to the address of record, which may or may not, and it looks like their email address of record is Mr. Alnoa still. Just so you're aware of that. So the email would go to you. And then
I'll
just be a
keep an eye
matter
out
of
for it.
if they respond, then the hearing would go forward. If they didn't, it would probably be a motion to deem.
I would highly recommend not trying to serve them at the wrong address. Mr. Alno is not accepting service for Tallis Harbor, so you might want to try and reach him another way or it won't be good.
I think usually it goes to by mail to the address of record and then secondary to the email. Like I said, it just appears that Mr. Alnoa does have the emails. And that doesn't mean that
You're
you have to
talking about
respond on their behalf.
Their pharmacy, yeah, their pharmacy in Phoenix. That's what you're talking about?
Yes.
Okay, yeah, that makes
So
sense.
they have a pharmacy in Phoenix?
No, this is Tallis Harbor.
This,
sorry.
okay, the one in Buckeye.
Yeah, I meant.
Okay.
Okay.
Do we need to make separate motions for each?
I think let's do that. Let's do the
Let's
easy
do
one
the easy
first.
one. I move to dismiss Mr. Fahad Alnoa from the complaint.
Second.
I have a motion and a second. All those in favor?
Aye.
Any opposed? Hearing none, motion carries. She had a different thought.
She had a different thought.
I'll make a motion for a $250 non-disciplinary fine for failure to notify the board about the closing of the pharmacy to Mr. Bergen.
I'll second.
I have a motion and a second. Non-disciplinary, any further discussion? All those in favor? Aye. Any opposed? Hearing none, motion carries. Now the complicated one, Tallis Harbor. What shall we do? Ms. Galvin, what was your recommendation potentially?
An option would be to dismiss the matter without prejudice. And if they were to reapply, we could continue the investigation. They are going to expire at the end of October. Given everything I've heard, maybe it'll be unlikely that they will reapply.
Ms. Galvin, the only, I guess, drawback to that is it's not reported to the National Practitioners Database, and they can do this in another state.
Right.
Yeah.
That's true.
What other options do we have?
I think Mr. Hargraves explained the likely outcome of moving it to formal hearing, finding a good address. We could send it to the address of record, and more likely than not, it would result in a motion to deem, and notice of hearing would have to be completed quickly.
but that would enable us to issue a revocation and discipline show on the NABP profile.
If that was the final outcome, yes.
I feel better about that because I feel like they certainly had probably the majority of their responsibility here. And for us to walk away and just close it with no prejudice, I don't know that I feel like, I don't feel good about that.
We'll move for hearing. Is that right? Yeah. So that my motion.
I'll second.
Just
Motion and a second. All those in favor?
Aye.
Any opposed? Hearing none, motion carries. Thank you all for being present. Bio break, everybody? 10 minutes? Actually, let's do 12 and come back at All right, welcome back. We are going to go to 25D, complaint number 24-0184. Oh, I'm sorry, 24C, 25C. I'm losing my mind. It's a long day. 230544. Same people, but we'll see you for both. I'm sorry. This is the one on technician training documentation. Just to set the stage. Mr. Hyber, please.
As you know, organization is key. Okay. Welcome, board members. Back again, Steve Hyber, Compliance Officer. 25C, complaint number 230544. Our agency received a complaint from a former pharmacy technician with the respondent permit holder. The technician stated in her complaint that she was hired to perform on-site training of technician employees. And the reason for the complaint is she stated that while she was auditing, she found a number of incomplete records. I guess she was tasked with, getting the records up to date, making sure everyone was properly trained and that training was documented. And she alleged that during an August 2023 text exchange with her manager, who will call in this complaint N. Nancy B. Boy, and B, to address that issue, she alleged that the individual, in not so many words, basically told her just to mark them as completed. So that was the underlying basis of the complaint. So we assigned a case number to it, and I was the compliance officer who went out to do the investigation. I went out maybe a week or so later after we got the complaint, and I met with the PIC, who's here today, Andrew Vo, and after we got the sign off on the notice of inspection, we walked the pharmacy floor. I figured the easiest way to really validate, how well they were performing their training and documentation was just to do a little meet and greet, ask individuals on the floor performing various activities, their name, their title, and what were they doing right at that moment, and then what else were they trained to do, or what else did they do? And I compiled that information through the course of the morning. And then later on, I asked the PIC, I said, well, where are the training records? And he indicated that the PIC was not involved with the training of the technicians. Okay, that was the first thing that I found interesting. But their corporation is rather large, so maybe they had a different process. Nothing wrong with that as long as they have the training documentation. So I said, well, who manages that piece of the operation? And he said, well, it was managed out of a group of individuals who were, I believe, based in Texas. So he was kind enough to set up a quick conference call. We got those people on the phone. And during the call, we kind of went through the various activities of those people. We said, okay, look that person up. Can you give me their training documentation. They had a big screen, as you might imagine, and they tried to show us that information, but they weren't able to do that at that day. So I was cool with that. I said, okay, well, you have so many days to get back, and respond to the actual complaint, which was basically saying, hey, they had incomplete records on those random employees that we walked around and met with. So he got the information back to me, and I went through it, and basically, they had a response as to why they didn't have it that day. It had to do with a technical issue. And but we did eventually get all the training documentation. And, out of those 15 employees that I met with, we only found 2. So overall, they did a pretty good job. There's only 2 where we were missing some documentation of the actual activity that I saw them doing that day. Now, it's possible the way this operation works is pretty unique. Most pharmacies will train every employee and just say, okay, I've trained them on everything, and they'll have a document that has the date and when they did it. What this corporation does is they train you on every step that you might perform. So you might work on a Parata cell, and you're trained to do that. You might work on a Baker unit. You're trained to do that. You might do replenishment. And they have so many different areas. So I'll readily admit that there could be some unique training with a name that I didn't understand, that they may be able to explain, today. But overall, I think the concerns are 2. We did have some incomplete documentation, not a lot, but again, our sample size was small. And we do have this issue with a potential individual, almost alluding to a individual to alter some training records, which is probably more serious. Now, we couldn't indicate that individual as respondent. Individual NB does hold a license. They hold it in another jurisdiction, Indiana. And interestingly enough, he was subsequently let go from the corporation. So that might kind of give you an inkling into his role in the situation. But we could refer this to Indiana for investigation if you felt that it was warranted. And that's all I have. I'm open to any questions, if you have any for me.
So you were generally satisfied with where they were at in terms of documentation of training?
I would say for the sample pool I pulled, you would, if you extrapolated that, yeah, it wasn't as bad as I thought it might be based upon the allegation.
Okay, thank you. Mr. Hio, Mr. Vo, would you like to make a statement?
Sure. Good afternoon, Madam President, board member, Susan Trujillo from Corals and Brady, and with me is Dr. Vo from Amazon Pharmacy. He's the pick. And Andrew's going to go ahead and make a statement.
Good afternoon, board members. Thank you for allowing me time to speak today. I do take these complaints very seriously, and I'm committed to improving how we deliver pharmaceutical care, not only in Arizona, but nationally. As a result of this complaint, I have reviewed the requirements of the PIC in the Arizona Law Book, read past board newsletters, and rewatched hours of board meetings to educate myself on the PIC's many responsibilities. Further, we have updated our training process so that I, as the PIC, am more involved with pharmacy technician training. Amazon investigated this complaint and found no evidence that pharmacy technicians had incomplete certification training. The missing training documents identified in the complaint were likely a result of a systems transition, and we were able to locate those documents in the old system. The learning and development team was also undergoing structural changes during the time this complaint was issued, and the technician in the role of pharmacy fulfillment trainer was likely feeling the extra stress. The technician eventually chose to leave Amazon and was not terminated due to raising her concerns regarding the paperwork. Individual NB is also no longer with the company due to a reduction in force. It was against Amazon's policy to request that incomplete training be signed as complete. As noted in the board's materials, Amazon hired outside counsel to investigate this issue, and no facts were revealed to substantiate claims regarding the falsification of records. Further, we have had a biennial inspection in March where compliance officers Hyber and Jacobson asked for training records, and we were able to satisfy the request and provide complete records. Nevertheless, we are always striving to improve our processes and made changes to our training policy effective March 18th. Our previous training process was mostly channeled through our centralized learning and development team. And I would verify a technician was trained before he or she was allowed to perform specific tasks. Now I am involved with the training process from the beginning. I meet with all the new hires and explain the training process. I also review the weekly training progress logs to ensure each technician is progressing through their required trainings. Being more involved in this training process will alleviate some of the responsibility placed on the pharmacy fulfillment trainer and ensures all technicians receive the proper training. I am confident with these efforts, this will not be a repeat issue, and I'm happy to answer any questions you may have.
Thank you. Board members, questions?
Just a point of clarification, you said that the person chose to leave, and then you also said it was the result of a reduction in your employees. So, or were those two different
Two different people.
Okay, thank you. I just don't see that we have enough evidence to substantiate the claims. So I would be willing to dismiss.
Second.
Motion and a second. Any further discussion? All those in favor?
Aye.
Any opposed? Hearing none, motion carries. Thank you. I guess you're going to stay right there. Next up, complaint number 24-0184, PIC failed to report loss of controlled substances. Mr. Jacobson is back. Welcome.
All right, good to see you again, Board of Pharmacy members. Max Jacobson, Arizona Board of Pharmacy Compliance Officer. Board staff opened this complaint against Amazon Pharmacy and the PIC, Dr. Vo, because they failed to report more than 85 DEA 106, that's the loss of controlled substance forms, to our agency. This was identified during a routine compliance inspection when I noticed that they had sent us several notice of loss, but not sent any DEA 106s. When questioned about it, and in the written response, the PIC indicated that they thought loss in transit was not reportable controlled substance losses.
Ms. Trujillo.
Good afternoon, board members. Susan Trujillo from Corals and Brady representing Amazon Pharmacy, and with me is Andrew Vo. Andrew, would you like to make a statement?
Thank you again, board members. I do take all of these board complaints very seriously and my responsibilities as the pharmacist in charge very seriously. As a result of this complaint, I have taken 3 hours of CE covering controlled substance related topics. I've attended Board of Pharmacy meetings, and I've watched over 60 hours of previous board meetings to fully understand my responsibilities as a PIC. So when this violation was cited during the biennial inspection on March 22nd, it was an oversight on my behalf to report 87 DEA 106 forms to the Board of Pharmacy and the Arizona Department of Public Safety. Immediately following the inspection, I forwarded all DEA 106 forms to compliance officers Steve Hyber and Max Jacobson. In all cases, these losses were either customer reported loss in transit shipments or courier loss of the shipment. The oversight in Rule R4-23-1003 was due to a misinterpretation of the definition of a loss in transit shipment, which I understood to be defined as a loss between wholesaler to wholesaler or wholesaler to pharmacy. It is always our intention to abide by state and federal regulations, and I accept responsibility for my oversight of this rule. Since then, I have taken measurable actions to understand all reporting rules and regulations, and the pharmacy is in full compliance with its reporting obligations. In addition, I have revisited many hours of board meetings board meeting minutes to ensure I'm well versed on the many responsibilities of a PIC. Again, I am confident that this will not be a repeat issue, and I'm happy to answer any questions you have.
What did you say the topic of your CE was?
Controlled substance related topics in reporting.
Thank you.
Could you speak a little bit, Dr. Vo, about your local policy? Your policy documents says section 4.7.3 states the PIC or pharmacist delegate must notify all relevant local regulators, including resident and non-resident boards of pharmacy where applicable. You acknowledge the the performance deficit of not reporting based on state law, but it appears you also didn't follow your own company's policy.
Again, that was a bit of an oversight on my part, and in working to understand what loss in transit was, my misinterpretation of that led to my oversight of both the company and state policy.
And just to clarify that just a little bit too, in most of these instances, the deliveries were completed by the U.S. Postal Service or UPS, and the patient reported them as lost. Basically your kind of porch pirate situation. And so I think that's where Andrew's confusion came in, is because he, kind of perceived the Arizona requirements as not applying to a situation where, it was delivered to the patient, it wasn't lost in transit. It just kind of never made it from the patient's doorstep to the patient's hands. And so he understands now that, that difference, and, is making those reports in compliance with Amazon policy as well.
So Dr. Vo, for other DEA 106 events that occurred, were there any other outside of these in-transit losses?
I'm not sure I understand the question.
Have you had any other losses that for employee pilferage, any sort of DEA 106 reports that you've made?
Yes, we did have one in May of 2022, which I did report to the Board of Pharmacy.
What sort of shipping policies and procedures does Amazon have with regards to controlled substances? And do you guys file a claim with the U.S. Postal Service when these, okay. Will you talk to me a little bit about your shipping policies?
Sure. So we do file the claims with the courier, whether that's USPS or UPS. With the replacement shipment, so if a customer does notify us that they did not receive their medication, we do an investigation. So we file that claim with UPS or USPS, and we perform the investigation. We review camera footage internally to make sure that the shipment was packed properly, and so that the medication that was missing was actually in the shipment when it left the pharmacy. Regarding issuing a replacement, we always contact the prescriber and notify them that we've done our investigation, that this was substantiated, and we get the approval to refill the prescription for them. So we always get the authorization before we send a replacement.
Do you have policies in place, say, to prevent a patient from repeating the documentation, to make sure if a patient does it more than once that you have some sort of procedure you follow to?
Yes. Yes. With each claim, it is tracked internally. And then with these 87 in particular, they were all individual customers. So no were repeat customers.
Do you require signature for shipment?
We do not require a signature. However, a customer could request a signature if they wanted, if they wanted to ensure that they received it. They could request a signature, but we don't send it with a requirement for signature.
I just want to make sure that I understand clearly. So these were reported to the DEA properly. They just weren't additionally reported to the Board of Pharmacy. So it's not like they weren't reported at all. We just did not receive the copy.
Correct.
And it was only, excuse me, for these specific category of events, not for a regular loss. It was only for these shipment events that we did not receive.
Correct.
Okay, thank you.
Yeah, because I believe any Form 106 submitted to DEA has to notify the Board of Pharmacy within 10 days, right?
Right.
For any,
Right.
correct?
Right.
So.
And you acknowledge that you knew that because you sent that DEA 106 to us for another type of loss. So you knew that you had to report it for that type of loss. You believe there was a carve out, or this was not applicable for this other type of loss.
Yes.
This seems to me like a learning opportunity. And you have clearly told us that you've learned. So I would, how many CEs did you do? 3?
3.
Okay. I would make a motion for 3 hours of non-disciplinary CE, accepting what you've done after staff's reviewed it.
I'll second.
Anything for the permit?
I think,
Oh, I'm sorry.
I
go
think the
ahead.
permit holder had the policies in place. It would be nice if they had some sort of internal audit procedures to look at this. Because obviously it does impact the permit as well, but I am happy that the permit holder does have the policy and in this case, the PIC just didn't follow it.
I'll say no action towards the permit.
I was kind of thinking letter of concern to the permit just because of the volume of these. It wasn't like it was one, it was 86 individual cases. Again, like I can understand maybe 85 individual cases. I can understand maybe one slip through the crack, but 85 seems a little excessive to me. Not
I'd
to
agree
at
with
least
that.
put something on record.
Is there an internal audit process with Amazon for looking at these?
I'm sorry. What kind of audit we looking for here? Like they report to 106, right, to DA.
Right, does Amazon corporate, whoever
Oh,
your
okay,
boss is,
they look
Dr.
into
Vogt,
those.
are they looking to see that 106s that you file from your permit are being reported? Is there any sort of audit process done by your compliance department?
That is not something I'm sure of at the moment.
So do you share this form 106 form with any
Yes.
administration compliance department?
We do forward it to,
You
we do forward it to compliance.
Does that form
Okay.
show where it was submitted to?
It shows it's submitted to the DEA, yes, but not to,
Does it show now that it was reported to the Arizona board as well?
yes,
And to Department of Public Safety?
and to the Department of Public Safety.
See, I feel like I like your thought of the letter of concern because I feel like there's a lot that these large companies especially can do to help support that. I know there are a lot of companies that when you submit the 106, it will go out to all three places and it won't only fall on the PIC's shoulders to do that. So
I'll be willing to amend my motion to be a letter of concern to the permit holder.
So do you want to restate the motion in its entirety?
Yes, I would love to. 3 hours of non-disciplinary CE to the PIC, accepting what's been done after reviewed by board staff, and a letter of concern to the permit holder.
That was on the topic of controlled substances.
Yes.
I'll amend my second.
I have a motion and a second. Any discussion? All those in favor? Aye. Any opposed? Hearing none, motion carries. Thank you very much for being present. We are going to 29A. Desert Sanita Pharmacy. Is anyone present for Desert Sanita Pharmacy?
Can you hear us okay?
Yes, we can. If you could please introduce yourself for the record.
Absolutely. I am Jared Hatchard. I am the Chief Market Strategy Officer and Pharmacy Director for Desert Sanita.
Dr. Daniel Barbara, CEO for Desert Sanita.
Thank you. Welcome. And I see Mr. Castaneda and Ms. Mitchell have joined us. Would one of you like to give us a brief summary?
Desert Sanita Pharmacy entered into a consent agreement in order for probation, civil penalty, and reinspection to resolve board case number 22-0448-1. The consent agreement became effective on July 20th, 2023, and placed the pharmacy on probation for a minimum of 6 months. They were required to pay a $13,100 civil penalty, undergo an unannounced follow-up inspection, and submit payment in full for the cost of the inspection within 60 days. They paid their penalty, underwent an inspection, and paid the fees that were incurred by that inspection.
So from the staff's perspective, they're in compliance. Yes?
Yes.
Okay. Would one of you from Desert Sanita like to make a statement?
Thank you. Yes, absolutely. Thank you very much for providing us the opportunity to come before the board today. Desert Sonida Community Health Center is a federally qualified community health center that has been serving the Ajo community and Ajo Lukeville Health Service District since 1997. Our pharmacy has been an integral part of the Ajo community for many years. During the COVID-19 pandemic, staffing became increasingly difficult, which ultimately led to compliance issues in 2022 and even several temporary closures of the pharmacy. After discovery of the issues noted by the Board of Pharmacy Compliance Officer, Desert Sonida took immediate action to recruit more stable pharmacy staff and develop a plan to prevent these issues from happening in the future. Part of this plan was bringing on a new pharmacy director, Dr. Hatchard, as well as several part-time and per diem pharmacists as a safety net to provide continuity of pharmacy services in the community. We've actually improved our staffing quite tremendously and have full-time stable staff at this point who are serving the community very exceedingly well. Desert Sonida recognizes its responsibility to the remote communities it serves and recommitted to providing the best possible care to its patients. Desert Sonida's board of directors also work to bring on new leadership, myself, that would ensure more accountability and transparency across all departments. Desert Sonida has developed many new processes, policies, and procedures to ensure the security of pharmacy, better inventory practices, and continuity and stability of pharmacy services. New softwares have been employed, as well as training programs to ensure all pharmacy staff members are well trained in the appropriate practice of pharmacy services. We wish to affirm our commitment to providing safe and compliant pharmacy services to the Ajo community and respectfully request that our probation status be lifted as a result of our concerted efforts to bring on pharmacy staff, bring our pharmacy into compliance with all applicable laws, rules, regulations, and statutes.
Thank you very much. Board members, questions?
I just like to have disclosure, like I had some meetings with the pharmacy director I just recognize his face now. Just there is no, for me, I mean, it will not affect my decision. I will look into this case in open mind, but it's up to him if you like me to stay in the board.
Mr. Hatcher, do you have any concerns with Mr. Al-Nassif considering continuing to participate in the discussion?
I do not.
Okay, thank you.
Thank you.
Any additional discussion or questions for them? I'm satisfied personally with their progress. Do we have a motion to lift the probation?
I'll make a motion to lift the probation.
I second.
I have a motion and a second. Any discussion? All those in favor?
Aye.
Any opposed? Hearing none, motion carries. Thank you very much and best of luck to you.
Thank you so much.
We appreciate it.
29C, discussion consideration of possible action regarding Jenny Yuan's request. I am recused from this one.
Good afternoon. Mr. Rain, would you please introduce yourself and your client for the board?
Thank you. Michael Rain with the law firm Bozen and Snow.
And my name is Jenny Yui Yuan.
And can you give us a summary of why you're here today?
Yes, and Ms. Yuan will have a brief statement, but the purpose of her visit is to request reinstatement of a revoked pharmacist license. A few years ago, Ms. Yuan had diverted medication from the pharmacy where she worked. She had a prescribed medication. She had changed employment from one chain community pharmacy to another and found that her prescription drug coverage wasn't what she thought. She began to suffer withdrawal symptoms that were quite severe and made quite terrible decision to bridge a gap by taking, I believe it was 3 units of her prescribed medication, Fexor. At that time, she made a second mistake, which was thinking, it was over, not participating in the board's process. So she basically just did not participate, and the board revoked her as a default. At the time, she was not as aware as she is now, at least, of the PAPA program and the fact that there was a path forward for her, even in that state of distress that she was in. And so, we worked a little bit with board staff in the background because we wanted to be sure that we presented this in a way that was most efficient. And we learned that, there was a 2-year period by default in your statutes. I wasn't aware of that, but if you don't say how long a revocation is, the default is 2 years. And so we waited a little longer from when we were prepared to come and ask for her to redeem herself before this board. She did complete all of her continuing education courses that she had missed while not being licensed. She went and got her own psychiatric evaluation from a board-approved monitor. You should have that in your material, and she was deemed fit to practice with a recommendation of a 1-year monitoring agreement. She suffered the revocation from not participating, but she never really accounted, of course, for the underlying conduct more directly other than the revocation. And with the recommendation of a 1-year monitoring agreement, what we anticipated was that she could essentially pick up where she had left off, and have her license reinstated with a term of probation, participating in a PAPA program for the recommended 1-year duration, with the requirement to, of course, appear before this board to be released from that probation at the end of the term, or any other such terms that you may require, but we would, picture relatively standard PAPA terms. And that's it in a nutshell. And I'd like to give her a chance to make her statement.
Oh, well, I think I'm just gonna pretty much repeat what you said. But in April 2022, I made the mistake of diverting 5 capsules of venlafaxine, 150 milligrams, due to a coverage caused by insurance issues at my new employment. I had been on this medication for almost 10 years at max dosage, which was 300 milligrams daily. Due to intense withdrawal symptoms and being overwhelmed, I made extremely poor decision at that time. And during the board's investigation, I was not in a position to defend myself, and I did not understand the help that PAPA could provide to address my case through rehabilitation. Therefore, my license was revoked when I failed to participate in the investigation, which is another error that I recognize and regret. However, after 2 years of reflecting upon my mistakes and tackling the core of my issues, including having sought psychiatric evaluation and with ongoing current therapy and medication management, I feel confident moving forward and continuing pursuing my passion in healthcare and doing what I feel I do best, which is pharmacy. So please allow me the opportunity I did not know existed before to participate in a 1-year PAPA monitoring program that my evaluation recommends.
Okay, we'll open the floor for discussion or questions.
I have a question. Just want to say up front, you don't need to share any personal healthcare related issues in public forum. But I do have a question related to the evaluation. I believe I read that you were not seeing a therapist or a psychiatrist according to the evaluation. And then in other statements, it says that you are seeing a primary care and a therapist. I just wonder if you could clear that up.
Yeah, so I was honestly, the cause of all my issues was that I just had no work-life balance, and I was using work as an excuse to run away from all my problems. I would just work and work and work. So I was pretty much burnt out, and what happened was pretty much the straw that broke the camel's back. And then after my psychiatric evaluation, I started seeing a therapist.
So do you have a job currently?
No, I'm at home, reconciling with my parents and establishing a support system.
Okay, so during this time, you didn't have insurance, correct?
Right.
And that's part of what led you to divert.
Right.
So you don't have a job now. How can you assure us that this wouldn't happen again? You wouldn't have an issue with like a monetary issue that would lead you to divert again?
So the big issue was that even with a coupon at that area of employment, it was still like extremely expensive. So I was trying to transfer it to a different pharmacy where it was literally 10 times cheaper. But the prescription was caught in the transferring process. And during that process, I ran out of medication. So my medications, they're very affordable with like a GoodRx coupon. And even though I don't have a job, money's not a concern right now for me.
I was just gonna say, sorry, this last thing, just to me about, you following the plan that we may or may not put forward. So you're not seeing the therapist you are again, but you're not seeking psychiatric therapy. I don't know what's been asked of you. I'm just curious.
So the pop-up approved psychiatrist recommended me seeking therapy, and that's what I have been doing and am doing on a bi-monthly basis.
She also has a PCP that is her prescriber and mental health care provider that she had in place when she got the evaluation. The evaluator recommended the therapy, so she started that and has been doing it pretty much since the time of the evaluation, which was a number of months, many months ago. January of this year, she's been doing that. And would you agree to, of course, continue that as part of the recommendation?
So to confirm that recommendation number 1 from the provider in January that says you're to resume ongoing continuous mental health care with a psychiatric provider and therapist, you are meeting that today? That's your testimony?
Yeah.
I don't know if a primary care physician would be considered psychiatric.
She's a board certified like psychiatric nurse practitioner.
If it's of any use, we did provide a letter from that provider in the file to confirm that she sees her. And
I just didn't have it clear in my mind that specialty there. Thanks.
Any other questions or discussions from Ms. Yuan?
I feel comfortable based on the evaluation to find some way to move forward with some sort of PAPA contract.
So have you engaged with PAPA already? Is a contract underway?
I have not.
So are you only willing to do that if you're ordered to do such, or are you willing to voluntarily enter into a PAPA contract?
I'm willing to voluntarily.
And I don't know if this fact is relevant. She has submitted provisionally an application for reinstatement to the board as well. So you know that there's a pending submitted application.
I have a question. How many times have you seen Sarah Jennings?
I've seen her once in May, and I have an appointment coming up with her next Thursday.
So altogether, the upcoming appointment, that would be the second time?
Yeah.
I'll make a motion to do a 1-year mental health monitoring through the PAPA program. And to be part of that, to include that you upkeep I don't know what, actually, this might be part of the PAPA contract, but just that there's psychiatric component and a therapy component.
Where did you get 1 year from?
The evaluator.
But just to maintain consistency in the past, we have asked other licensees to go through 2 or 3 years, right?
Well, we
No.
typically go with what the evaluator suggests. In this case, I recall it was 1 year.
It does say minimum of 1 year.
Okay. Did you have a different timeline? It's on page 5139.
I saw that, but then the message from the provider was somewhat to me is sort of contradictory, because on one end, she said ongoing continuous mental health care evaluation, and then the second paragraph stated 1 year. So I'm not sure that she is set on 1 year period.
Dr. Dang, what page was that?
Page 51, yeah. From Dr. Faria.
But Dr. Faria is not your
She's our evaluator.
correct. Where's the letter from the current provider endorsing your return to practice?
That was from
4
January.
pages.
It's our appendix 4 to our letter. It's a June 27th letter.
5147.
Thank you.
And if I may speak for you, before this provider, she's always had a prescriber for her medication that she's been on for over a decade. But often your agreements will specify you need to establish a direct relationship. Often it'll say with a PCP or with a certain provider, and we would be absolutely agreeable to a specific requirement of whatever level of provider you would like her to continue to see for psychiatric care, as well as the therapy component.
I would be comfortable with minimum of 2 years, either 2 or 3 years. Because even the letter that we received from Sarah Jennings did even mention that she is seeing Miss Yuan on a periodic basis. She did not even specify the time frame of 1 year.
Sarah Jennings didn't do like a fitness for duty evaluation. I think this is just a letter saying that she's treating this patient though, right?
Correct. And according to the license or the applicant, she's only seen her twice. And I don't see anything in the file. And Michael, did we miss it? Is there anything from the therapist?
I didn't understand that.
She needs to repeat that.
Microphone.
Pardon me. Now you really can't understand that. Matthew King is an LPC. That's her therapist. We do not have a letter from him. We could certainly provide that. But just to be clear, whether it's the biweekly that she's getting now or of any regularity for either provider, she's willing to accept the terms, particularly if Dr. Faria opined, but to continue both elements of treatment as a mandated requirement at any frequency and any level license that you shall desire.
Yeah, I mean, that's going to be part of the contract. Also, I mean, it says, you know, to be free of any substances, even though this wasn't part of this particular case. I would agree to that being part of the contract as well.
We would have no concern with that.
And is that a motion?
I did start a motion. I can restate it. But
Sure.
I don't know if I'm adding things that are already implied, but just basically to go with the evaluator's recommendation for a 1-year contract of mental health care with both a psychiatric and a therapeutic component. I was saying 1 year of monitoring and free of substance use.
A second.
There is a request for her to,
reinstate her.
but there's no application yet.
There is an application in our system. It's pending.
But not in
I'm sorry? Not on the agenda.
not on the
No,
agenda,
but
correct.
There's an application for consideration.
And I believe it would be premature to even know if she's met all the basic application requirements. I think what we were looking for is more of the blessing that with that in place and assuming she meets all elements to obtain a license, fills out the application, does all that. If there was any problem with that, it'd be a whole separate issue that we'd have to deal with.
Is that probation tied to that? 1 year.
1 year probation as part of,
Okay.
yes, as the standard term of the contract.
I'll second the motion.
All right, so we have a first and a second. Any further discussion? Ms. Galvin, do you need to repeat the motion just so for clarity or
No, I know what the motion is. I'm just trying to figure out procedurally. I guess it would be based upon the review and approval of the application, and should she meet all of those requirements for reinstatement, then offer her this consent agreement. So I think that's implied in your motion that the application be reviewed substantively, and if she meets all requirements, and upon signing the consent agreement with the terms that you have set forth, then her application for reinstatement would be approved and the license would issue.
I
And-
can make
and-
that as part of my,
and remain on probation?
Yes, would be a 1 year probation with the terms that we've discussed.
We would also agree that if she didn't sign the consent agreement, that the application would be denied. Would need to come back here again if she didn't agree.
Within 30 days.
Well, you may be getting ahead of yourself with the 30 days because I don't know what the time frame is on the review of the application.
And she should come before the board to remove her, to terminate her probation.
that's standard.
That's
Okay,
standard.
that's standard.
I will, if needed, I'm amending my motion to include all of that. It's just stated by Ms. Galvin.
I am in my second.
All right, very good. We've got a first and a second. Any further discussion? All right,
Ready?
do we need a roll call?
Yes, I do.
All right, roll call. Dr. Gandhi, please.
Mr. Braswell,
Aye.
Mr. Thorwald,
Aye.
Ms. Snare,
Aye.
Ms. Davis,
Aye.
Ms. Walmsley is recused, Ms. Lehan,
Aye.
Mr. Dang,
Aye.
Mr. Al Nassif.
Aye.
And Mr. Anderson.
Aye.
Ayes have it.
Thank you very much.
Thank you, Mr. Rain. Thank you, Ms. Hewlin.
Okay, I think that takes us to reports. Dr. Gandhi, would you like to start?
Certainly, Madam Chair. Organize myself here a little bit. So we're on item 30, Madam Chair, members.
Yes, 30A.
Yep. Right, 30A1, Madam Chair. As you guys are all aware, we had a JLAC meeting several months ago. And there was a request to put in a response to the deficiencies in our audit. In your board book is a pretty extensive report where my team was involved, and I think we addressed every concern that was on the audit appropriately. I think in summary, some of these audit deficiencies are always going to be there based on manpower and some statute regulatory restrictions. And that was clearly explained in our report to JLAC. We haven't heard a response back related to it, but it's in your board book for review.
No action needed.
No action needed. On that
Any
one, just
questions from
informational.
anybody? I really appreciate all the time the staff took to put it together. I know that there was a lot of work that went into it, so I just want to commend you and the team for a good piece of response here.
Thank you. Number 2 is discussion. This is related to the Auditor General as well. Is prioritizing of complaints, and this is a rough draft that's in your packet. It's prioritized to category 1, 2, and 3 based on how urgent we need to jump on that complaint. So from serious to less serious. We do it already internally based on public health and how it's going to impact the general public. But this is going to memorialize it and actually show it on even our complaints or inspections or whatever it is. So we'll add another column prioritizing what number it is. And that's a request that the auditors made. So this is again a rough draft. It's a work in progress. We haven't incorporated every possibility that we may run into, but it's going to be a bullet point format and more think tank moments to capture everything. But it's coming.
No action on this one either.
No action at this time.
Questions?
Next is, there's an NABP member forum coming up here in the near future, I believe mid-September.
It's in January, isn't it?
Member forum is, I believe,
I think it's in January this
pull it
year.
up.
It might be. Yeah, I think it's in January.
I will tell you in a second, Madam Chair.
Registration is by November.
So maybe I'm jumping ahead here.
I think it's the middle of January for some reason.
Starting December 4th. It's during the cold season.
Great time to go to Chicago.
Yeah, and we usually have a member of our boards or go to these things. It's a great learning opportunity. So something for maybe you to think about. Maybe we can bring it back at the October meeting and they can jump on the NABP website, see what it's all entailed and see if there's somebody that wants to participate.
Yeah, all the NABP events are outstanding.
Absolutely. Next one is also informational. The rule writing Article 11 update. The governor's office did approve what the board approved several months ago. It is in GERC's hands. We have Article 11 5-year review coming up at the end of this month, and then decision by GERC at the beginning of next month. But then the month after is our amendments that we worked on diligently and redlined a lot of things, condensed a lot of things, made it more clear. And that should be before GERC the following month for consideration. Again, no action needed, just informational. Next topic is NABP District 6, 7, and 8 meeting is coming up in October. It is posted for registration and hotel information and so forth. We have the website's been up a couple of weeks already, and I think we have roughly about 50 people that have registered. We also have sponsorship people that are going to show up. Roughly about 25 of those folks will be there. So head count of 75 right now. It's still early. We anticipate about 100 to 125 people that typically show up to an NABP meeting. If you guys are interested, it's live right now. During these meetings, fun topics, a lot of learning topics on where pharmacy is moving to in the near future, what people are, how the landscape's changing and so forth is being discussed. Also, resolutions are also thrown in the hat. And so I ask you guys if you have a resolution, we can talk about it briefly here, just on a high level, and see if that'd be supported. Resolutions take time to draft, to have a certain format and make sure it addresses things the right way that NABP is capable of doing. So if there's one that you'd like to entertain.
I would like to talk about one just briefly. I'm considering submitting a resolution around standard of care regulatory model. This has been a topic that's been discussed widely in a number of different forums. There is a session on the agenda as well for the NABP district meeting relative to this. I think we're doing some of that work already as a board, looking to remove some of the bright line regulations, things like we talked about earlier today, removing of the square footage within pharmacy, some of the specific things around equipment. But as we look forward, actually, as we look backwards at what happened with the COVID pandemic, in Arizona and a lot of other places, there were a lot of deviations that had to happen because the rules and the laws in the state weren't set up in a way that practice was nimble enough. So moving to a standard of care regulatory model would allow pharmacies more flexibility to practice and do things within what healthcare professionals determine as appropriate. That's how every other healthcare profession is regulated. Looking back at NABP, there was a resolution in 2018 and the board and NABP held a task force. I think there was 5 recommendations that the task force put forward. Some of them were adopted, some of them weren't adopted. But I think, as we look at declining enrollment rates, what's happening in pharmacy as a practice, I do think that perhaps this is something that NABP should look into a little bit further. I think perhaps there might be some resources that NABP could offer to states. So I'm kicking around the concept. I don't have anything kind of formalized in my head yet, but that's kind of what I'm thinking of right now.
I was just going to bring up that task force because I was on it.
Yeah.
With Al.
I looked at it.
Yeah.
So here's my ask of the board members. Will you be comfortable with myself, Lori, and maybe Mr. Anderson working together to put this together?
To put together the council resolution, sure.
That fair?
Yeah.
All right. Okay, perfect.
I also want to commend Dr. Gandhi. He has graciously helped. Dr. Gandhi and I both serve in leadership roles for the district. It is our district's turn to host. New Mexico is the host state, but Dr. Gandhi serves as the executive committee member and I serve as the chairperson for the district. So we've also put in quite a lot of time in planning this meeting to ensure that it's successful for our district so that the district is successful for years to come. So thank you. I know it's been a lot of work and we'll talk about some of the things that
From
have been
both of
happening
us, yeah.
here at the board, but I really appreciate the time you put in. He created the website and has been doing a lot of the like work behind the scenes. So thank you. I appreciate
Oh,
it.
you're welcome. You're welcome. It feels like it's our meeting in this state, doesn't it? So.
Just a different location.
Yeah, absolutely. Next on the agenda is we're getting a lot of calls regarding administration of other injectable drugs. Obviously, it's clearly defined in our rules and statutes that if you inject immunizations and vaccinations and something happens, an event happens, there's an opportunity to give emergency meds. But according to the practice of pharmacy, pharmacists are allowed to administer drugs, which means people can administer B12 shots and other psych drugs and so forth. Our statutes and rules do not address emergency meds if something happens when you administer drugs. So that's something that we will probably need to address and maybe fix in a bill in the future. So I wanted to draw that to your attention that that is a topic that we're getting a lot of questions on right now.
That already existed. It just needs to be put in the definitions.
The definition to administer drugs is in there pursuant to an order, right? But there's no order for emergency meds.
So if somebody were to, for example, B12 is a bad example because somebody probably wouldn't have an allergic reaction to that, but
No. Let's say Prolia.
Prolia,
right?
Good example. And the pharmacist administered it, they would technically not have the authority to administer epinephrine or diphenhydramine or something like that without an order of the provider. There is that in the case of immunizations in the law, but not for other drugs.
So what we've been advising is that if you're going to administer, make sure there's a footnote on a prescription that in case of an event, you're authorized to administer such and such.
And we can address this in our next rulemaking.
We will have to address it in our future rulemaking, yes.
I'm getting a note from the principal. Not really the principal, maybe the vice principal.
Any other questions on that at all?
So that would have to be done in statute. So since it's a pharmacy practice thing, is it something that our board could consider taking on, or is that something that somebody from AZPA in the audience needs to be paying attention to?
Yeah, that is more practice of pharmacy, not necessarily our scope. So we'd have to kind of encourage somebody to run that bill. I mean, it's in the best interest of patient safety. We can definitely have those conversations with somebody that's interested in running that bill.
President-elect Von Glenn, are you paying attention? Not to put you on the spot.
Next thing on the agenda is the 2026 budget request. It is in your board book. What I've added in the board book also is a fund issue. And this fund issue is really driven by the auditors once again. They want us to complete certain amount of inspections during a certain time period, complaints within 6 months. I think inspection turnaround within 108, no, I'm sorry, a year and a half turnaround. So with that, we have an algorithm spreadsheet that we've been working on for some time. Our compliance officers have put in a lot of time and effort. The PMP folks, the IT guys on that side have definitely been instrumental in developing this thing. And after putting it together, after putting numbers in, actual numbers, it kind of spit out that we do need additional manpower. And I think what it came up was, what it determined was we need at least 6 more pharmacists as compliance officers to meet this demand at a minimum.
I have a question.
Yep.
One thing I didn't notice that you had when you were calculating your cost is the cost of ongoing training. wouldn't that be part of this request for funds?
Right now, our focus is trying to get people.
If
And
you're gonna ask though.
oh yeah, we will ask. You know, I'm not very hopeful that this will get approved. Historically, we've been putting in manpower requests for multiple years and it has not been approved. So this year may be different, I'm hoping. But we'll have to just see. I mean, that's a pretty robust fund issue request. We have justification, consequences on what could happen if we don't get manpower. So all that stuff is pointed out in bullet point format, so it's easily readable. So I'm hoping that makes them understand. We also have a nice, beautiful graph in there. But we have numbers behind the scenes that support that graph on how we came up with those numbers. So I've already reached out to governor's office and OSPB and kind of getting ahead of the curve here and asking if they need any explanation how we come up with these numbers. Please let us know. More than happy to sit down with you guys. So my ask of you is to allow me to move forward with this fund request.
I would make a motion to move forward, but I definitely think you should try for more funding for training as well, but
Yep.
just my thought.
Second.
I have a motion and a second. All those in favor? Aye. Any opposed? Hearing none.
Okay, last item on the agenda is just a reminder, we're in that time of year and we have to think about renewals, right? So our renewal will not open until after Labor Day. So I believe September 4th. Am I correct? Third is a holiday or it's the second holiday. So we're going live, I believe, September 3rd. We always pick after the holidays because we don't want anybody to fall into have any issues during the weekend and not have any answers or so forth. So we'll start September 3rd, go all the way into the end of October, I believe. And I think our late fees are starting when, Jen? October 7th, just to give a little grace period.
After November 7th.
After, I'm sorry, November 7th.
Correct.
So we did build in a little grace period in case we have any IT issues or people are having a hard time getting into our system to renew, to give that little window so that we're not penalizing people for some IT technological issues. So November 7th is when we will initiate the late fee. We anticipate renewals to be about 18,000 renewals to take place this cycle.
Are you sending reminders this year?
We have thought about our CSPMP IT gurus have figured out a way to send reminders. And so we are working on that. Yes.
Those will be electronic in some
They will
form.
be electronic format. So as long as the email addresses we have on record are accurate, there should be something that goes out.
That's good. That's a good improvement.
Yeah. No. But we also encourage
If they bounce
businesses.
back, then we can give them a fine for not updating your profile. No, just kidding.
We'll pull the bounce backs and send them to you guys. But we also encourage obviously the big players to remind their folks to check their licenses and their permits as well to make sure that if it's up for renewal, please renew.
Can AZPA also put out a reminder?
Yes, they can.
You didn't know you were going to get homework for coming to this meeting, did you?
Any questions on any of my topics?
Not a question, but I would like to bring back the report that says future items and where they stand.
Yeah,
They're
we'll
still
work on it. I know we
on
got the Just Culture coming up next.
Yeah, that they're on your
next meeting.
list, where
Yeah,
they stand.
we'll put that back on the agenda.
When you get to Jen's report, we'll understand why perhaps some things slipped this meeting. But any other questions for Dr. Gandhi?
I have one. When is the next NABP meeting after October?
That would be next May.
May.
In Florida. And that's the national meeting. Yes.
I asked only because I wanted to go to this next one, but I'll be out of town during that period right after our next meeting, so. But I want to schedule it way ahead.
I would highly recommend it for any board members to attend, that there's always a huge opportunity to learn at them.
Absolutely.
Can I follow up from like previous item about the our website for reproductive like meds? There's any updates on that?
No, it's not on the agenda.
Okay, so we cannot talk about it. All right. Can we add it?
Yeah.
Okay, any questions about anything Dr. Gandhi has on the agenda? Okay, I have a request from staff to go back to item 24A. I believe we got additional information.
So 24A involves Jacob Dunn, and you made a motion that we offer him a consent agreement that involves a probation, a period of suspension, monitoring for 5 years. And it would involve a reevaluation before he is allowed to practice once the suspension is lifted. And if he did not sign that, then we would go to formal hearing. In the alternative, you would accept a consent agreement for voluntary surrender. He emailed staff at about 2 o'clock this afternoon that asking if his appearance could be rescheduled for 2 months. He states that next week he is going to be starting an outpatient treatment program. So I don't know if that information changes the motion. I don't know. We may be in a better position to get him to, he is suspended. We may be in a better position after he completes that program to have him sign the monitoring agreement. Or you could just continue and keep your motion. Sounds like he may be, committed to getting assistance.
My concern is, how do we know that he's actually going to do that or follow through or quit midway? You know what I mean? Like, how do we monitor that he will be taking place in this care?
We could request that he provide us, some sort of enrollment agreement that he has. It's through Banner, and request, a report from Banner every couple of weeks. It's an 8-week program.
But he is currently in suspended status, so there wouldn't be a risk to the public to continue it till the next meeting.
Correct.
That's fair.
I agree that that's fair, but I just wanted to let you know that he's communicated the latest, not advocating one way or the other that you change your motion, but I wanted to give you that information.
I don't know that it changes my opinion of what should happen, because I do think he should be in a monitoring program. So what option would we have to keep that same motion?
We could still come back to that if we tabled it till the next meeting, right? We could still put him on a monitoring contract. We would just potentially know at that point that he was perhaps in a better place after 2 months of treatment.
If I understand what you're saying, to continue with what you ordered.
No, to remove that and continue on with continue the case to next.
You most likely will have additional data at that point.
Yep. So you'd have to rescind your motion from earlier.
I would be in favor of that. I don't think there's any harm. We could still take the same action in 2 months, but we'll know more at that point and let him do his thing. There's no risk to Arizona, in my opinion.
Agree.
I don't know who made the motion.
I think I might have. It sounds familiar.
Does it matter, Madam Chair or Jean?
doesn't.
If someone just has to make a motion to rescind.
I'll make a motion to rescind the order.
I
and
second.
To table it to our next board meeting.
Second.
Motion and a second. All those in favor?
Aye.
Any opposed? Hearing none, motion carries.
Thank you.
Thank you, Ms. Galvin. Ms. Gannavong, you're up.
Okay, I believe Lynn is going to be sharing some slides. Right, so I'm going to start with the compliance activity report. It should come as no surprise that this team continues to stay very, very busy. We have data through the end of July on here. So year-to-date inspections, 817. No surprise that the majority of those are in our community pharmacy setting. Next slide, please, Lynn. Year-to-date, we have 87 violations that have been documented on inspection. The majority of those including controlled substances audit, counseling, and expired drugs. Lynn, next slide, please. Okay, the compliance officers have visited 59 permits for reasons not including inspection. Most of those have been courtesy visits. Lynn, next slide, please. And finally, a lot of work done with CE audits, complaints, and permit reviews. There have been 102 CE audits that have been completed, 283 complaints completed, a total of 306 complaints investigated, and 186 permits reviewed so far this year. So I want to thank the team. You guys consistently do a fantastic job. So thank you very much. We'll go ahead.
Quick question.
Yes.
You might hate this question, but is the average time between inspections about 18 months? Is that right? Or 2 years, 18 months? Do we know what the average is?
So the board has a goal of, in policy, of every 18 months for most permit types and every 12 months for high-risk pharmacy practices.
It's a question. What defines high risk? How do you define high-risk facilities?
These include many of our sterile compounders, for example.
Okay.
Any other questions? Okay, we'll move on to the licensing activity report, please. Thank you. So again, this data is current through July of this year. The board has issued 4,104 licenses, permits, and registrations. The bulk of those, nearly 2,300 being pharmacy technician trainees. Next slide. And we also report how many are closed out for various reasons, but just over 1,400 year to date. Again, the majority, over 1,000 being pharmacy technician trainees. Next slide, please. So currently, we have 851 applications pending, and a very, very rough average. We're out right now about 7 to 8 business days in our queue. So our turnaround times are very good considering the volume. And as you can see, the bulk of that volume is with the pharmacy technician trainee registrations. And last slide, please, Lynn. And these are our in-progress applications. Currently, we have just over, or I'm sorry, not currently. As of August 16th, we have 320 in-progress applications. And I always like to use this slide as a reminder for all applicants. When you submit an application, please submit all required documents and a complete application. Everything is processed in the order received. And if we have to request additional documentation, when that is returned to the board, we have to process that in the order received. So it really behooves the applicant to get everything in upfront on the first submission. And that's all I have for these two reports.
So Ms. Gannavong, if what I'm hearing is correct, so the average, for example, for a pharmacy technician trainee is 6 days average.
On the pending page?
On the pending page. So from the time the applicant applies to the time that license is issued, if it's a complete application, it's about 6 days.
Yeah, and these are really snapshots that we take
In
every
time.
2 months of where things sit. And would be the oldest pending application in the queue. So that's what that average is derived off of.
That's on 5398. That date, that's like the 100 and oops, I lost the page.
It's okay, 5397.
So the average time is like around 6 days for a trainee, but the oldest is 127 days. So we would be waiting for information on that.
Correct, on the in progress page. That time that they've been sitting in our queue is much older because we're waiting on that
But on
documentation.
average, it's about 6 days.
It's correct, business
Okay.
days.
Perfect.
Dr. Keonabon, I have another question. Regarding the closed licenses, the sheer volume of the technician trainees, just by their nature of being trainees, do we have data on how many actually convert to formal technicians and how many just leave the profession? Do we have that sort of information?
No, it's not currently something we collect, Dr. Anderson, but we could look into seeing if we can capture that. If that's something you'd be interested in seeing.
It would be.
Any other questions? Okay, I'm going to move on to the last page here. This is some board staff updates. We have had a lot of movement in our office over the past couple of months. We've had a couple of team members in the licensing area resign. Hannah Bolts, who actually was a licensing administrator and has presented in front of the board multiple times, has moved into the role of interim licensing manager. We've also replaced a couple of vacancies on our licensing team. As of this Monday, we have Jennifer Mamone and Lauren, Setnicki. They're both sitting on the side of the boardroom. So we're really happy to welcome both of them to the team. We have a new team member on the CSPMP team. His name is Connor McKinney. In addition, Jenica Brown made a move in the office from the CSPMP team a couple of weeks ago. She's actually working with me as executive assistant to the director. So really happy to have her in that role. Jenica's also off on the side and has reported to the board before on matters. And then finally, I wanted to acknowledge Ms. Sandy Sutcliffe. She's our lead compliance officer. Sandy is resigning and retiring at the end of October. And Sandy has had a very long career with the board and has made tremendous contributions to the board and to the state of Arizona in her work and with her team. So I want to thank Sandy for everything that she's done. We're working diligently to prepare to fill her vacancy. So that is what has been happening in the office. And happy to answer any questions at this time if you have any.
Sandy, I think you're still going to be with us at the next meeting, right? Okay. The end of a legacy. Thank you for all you've done for Arizona. Will not be the same. I think you've been a compliance officer the entire time I've been in Arizona. How long have you been a compliance officer? So almost my entire time. Wow. Amazing.
So that's all I have. Thank you very much.
Thank you very much. Doug. We're going to go to 30C CSPMP Director Report.
Good afternoon, members of the board. Doug Scavarla, CSPMB Director. First thing that I wanted to cover would be 30C1. We've been talking about naloxone for what seems to be better part of 2 years. And we had put a bill in play, and the bill was designed to reduce or eliminate the need to report naloxone to the PMP. And I think I've talked about that during our last meeting, and that bill did pass, and that bill went into effect immediately. I think, again, that the real value of that is, number one, it became OTC. And out of our emergency rooms, we want the emergency room to be able to give naloxone immediately to patients. We want to reduce all barriers, and this bill did that. And I just wanted to give a recap of that. I think one question I still get a lot of is what happens if you're billing insurance for naloxone? And, do you need to report that to the PMP, and do you need a label, is a question we get a lot of. Just like any other prescription, if you're billing insurance, you're going to run it as a prescription, you would be required to have that label on there, on the packaging. And you do not need to report to the PMP. That's it. So I think that's a huge win. There is a standing order, so if you wanted to bill for insurance, you could. I don't have details of what insurances are doing with that, but
This just opens up another pathway to access in addition to the OTC option that also happened earlier this year. So it's becoming more and more available, which is fantastic since it saved lives.
perfect. We can move to agenda item 30C2. And I'm going to start with apologizing to the board. I've added some documents to the board book multiple times, and if I confused you, my apologies. What we had going on was that there was a federal rules package that was proposed by the ONC just 2 to 3 weeks ago. That the rules package was almost 1,200 pages. So I've been working diligently trying to understand everything in that rules package, how it might impact our PMP, and then write a little summary here. At the same time, then I forgot to put the actual bill or the actual rules package, a link to the rules package within your document, but it is there now. And I'd like to just tell you a little bit about the summary I see out of this rules package and how we got here. Over the past year, I've been privileged to attend a work group meeting with consultants for the Office of the National Coordinator on Health Information Technology, also known as the ONC. The work group was titled PDMP on Fire, and it included administrators of prescription monitoring programs throughout the country. HL7 Fire is a standard used to access and exchange healthcare data. The ONC proposed rule aims to leverage HL7 Fire solution to improve access and enhance interoperability to prescription drug monitoring programs. Consultants for ONC met to discuss the feasibility of Fire being used to share prescription drug monitoring program data. PMPs currently use a different standard known as PIMIX. Historically and currently, all stage program utilize the PIMIX standards to either exchange data between prescription monitoring programs and EHRs, or utilize the PIMIX standard for interstate data sharing. The PIMIX national architecture is a nationwide framework designed to enable standards-based sharing of information between prescription drug monitoring program organizations and their stakeholders. Again, all data that is flowing from the PMP today is in this PIMIX standards. Nearly every PDMP is connected to both interstate data sharing hubs for sharing data across state lines. Both data sharing hubs are built on the PMIC standards. During the PDMP on Fire meetings, the administrators of PDMPs provided significant feedback regarding potential use of fire from PDMPs. Throughout these conversations, PDMP administrators reminded the consultants that PDMPs do not exchange discrete data for multiple reasons, including data security and the potential for not having a universal standard view of reports for end users. Discrete data is parsable, filterable, and storable. The consultants stated that they understood the nuances of what was being shared by the PDMPs. And then about a month ago, ONC announced a proposed rule package referred to as HTI-2. In this rules package, ONC proposes new requirements for prescription monitoring programs that may be of concern. Although the overall goal of the proposal aims to increase access and use of the PMP within the healthcare community, it directly conflicts with current state statutes regarding PDMP data maintenance and security. So in particular, what is in conflict is that the proposed requirement to enable parsing and filtering of electronic PDMP information conflicts with various state laws regarding how PDMP data must be utilized, stored, and made available for audit. And those are, that's ARS 362602 and ARS 362604. So currently, we do not share discrete data. If discrete data was to be shared, healthcare facilities or EHRs may present the discrete PDMP data in varying formats. They could create their own, quote, PDMP report. The proposed rules package reduces the ability of PDMPs to standardize how information is presented to end users, allowing healthcare facilities or EHRs to design parsing and filtering mechanisms, introduces variability in how healthcare providers would access and view the PDMP data. This lack of standardization could further complicate efforts to ensure compliance with state laws, creating challenges for state regulatory boards, investigators, even law enforcement, who may struggle to determine what specific data the healthcare provider saw at the time of decision-making. The rules package allows EHRs to query and ingest PDMP data even when not for the purpose of treating a patient. Again, that would be in conflict of our statutes today. Once data is ingested, PMP administrators would have no control over who is accessing the data and for what purpose. Anyone with access to the patient's medical record would have access to the PMP data, and there's no way to track that access. And part of my statutes requires me to know if there is an appropriate use of the PMP. Currently, state PDMPs mandate that any patient query must be associated with patient care or other defined use cases. This ensures the clinicians and other approved users of the PDMP are querying data specifically for the purpose of treating a patient and or other authorized uses, as example, law enforcement. Allowing health IT systems to query the data without direct involvement in patient care would it conflict with state laws that restrict PDMP access to specified authorized users. Again, I gave the statutes that that we would have conflict with. These queries could result in data being pulled out of context, raising concerns about misuse, overuse, or misinterpretation of sensitive PMP data. So in order to uphold state statutes regarding data security, including the ability to grant and audit access, PDMP data is specifically displayed to a healthcare professional in a PDF format. The EHR does not currently receive discrete data, requiring PDMPs to share discrete data either with healthcare systems via their EHR or with other health IT systems would be a fundamental change in the current process and disrupt the current PDMP ecosystem. Once discrete data is shared, PDMPs no longer have any control over how it is used and can therefore not control or audit who accesses it. There was another piece of the language that I can't say I'm interpreting it right or wrong. ONC has held some webinars to talk about the rules package, but they do not field questions. So the community of PMP administrators is a small community. We work together on problems over and over again. But one piece of the rules package, and again, I can't say I'm interpreting it correctly, but it seems to suggest that PDMPs may be required to collect prescribed and dispensed prescription data. So currently we get all dispensation data. We don't get the EHR or the EPCS prescriptions or a copy of a handwritten prescription. If that is the case, again, that's a big change for PDMPs. And then I can't put a dollar figure because I don't even know if that's exactly right. But to be able to ingest EPCS prescriptions would be a major difference in what we do today. So that's my summary of it. What I could tell you is that, again, the bill or the rules package is like 1,200 pages. I can tell you that in your board book, I put a link, and there's two links, and one of the links is a link with. Let me just pull that up. It's the PDF version. And if you pull up the PDF version, trying to make it as easy as I can without telling you that PDMPs are mentioned throughout the entire document, the bulk of what I'm talking about is on pages 63547 through 63552. And that is again on the PDF version. I just gave you a lot of information, guys, and you know what ONC has is a public comment period. That public comment period ends October 4th. We will not have another board meeting before October 4th. I'm not sure that you have thoughts on this, and if you do, or you have questions for me, maybe we start there.
Doug, I know you participate in NASCA. Is NASCA going to make comments?
You know, yes.
Okay.
Their conference is after the public health, the public comment period ends, but yes, they're going to make comments.
I mean, I'm hearing that this is going to potentially pose a lot of challenges for us as a board. So I wouldn't necessarily be opposed to making comments, but I'm not sure what that process looks like. Is that something that we can and have done as a board to make comments on a federal rulemaking authority?
you would have that authority and they are inviting comments. The dilemma is that comments are due by October 4th. And so we would not be able to meet as a public body and review that and make those comments. So Doug and I were discussing what option you have. We could hold a special meeting, or you could authorize, the chair, vice chair, or whoever to work with staff and Seth and myself to develop comments on the board's behalf and submit them.
If it's helpful, in preparation, yesterday or 2 days ago, I reached out to my peers, and of course, not everybody's had a chance to respond, but the question was, is your state plan on making public comments? And from my peers, I received 7 answers. 4 of them are yes, 2 are no decision, and 1 was no.
Yeah, I looked at the register. It looks like there's nothing that's formally submitted from any state. Most of the comments were anonymous when I just pulled it up on the comment page. Several from providers.
I think when you think of public comments on this bill, this rules package, it encompasses hospital systems in a big way. And a lot of the comments are related to that. There's probably not a lot of people that can speak to the PMP side of it. And, as administrators, we know a lot about it, but if there's a comment to be made, it would need to be through you guys.
I would be supportive of it personally. If it's going to impact how we operate today and we can't be in compliance with our statutes, I think we need to at least put it on the record that it's a concern for us.
We need a motion.
Need motion?
Yeah, and so because time's an issue, it may be best to appoint 1 or 2 people to work with Doug to come up with a comment, and the rest of the board, if they're confident, and 2 people working with Doug to submit a comment on behalf of the Board of Pharmacy. I think that's probably the best approach.
If they're okay with it, I'd make a motion for the president and vice president to speak on behalf of the board to work with Doug on this.
I second.
Second.
Any discussion? All those in favor?
Aye.
Any opposed? Your mic's off.
Sorry about that. Was that off the whole time? Thank you. I would hate that. 30C3, just a summary of our annual task force meeting. We covered a lot of things I've talked to the board about already. But some of those things that we covered include dispensation data. And I put those charts up for you a couple meetings ago. We also talked about the naloxone bill that I just mentioned, where it no longer needs to be reported to the PMP. Maybe I should backtrack just a minute. And who's on this task force includes representatives from the medical community, the Medical Association, other licensing boards. Mr. Thorwald often has mentioned, better collaboration amongst boards. And I think the CSPMP task force meeting is one that really brings those people together, because the PMP affects all prescribers and dispensers of controlled substances. So, when you put that type of group together, sometimes they may not have been aware that the change in naloxone has happened and these dispensing trends. So it's really a great time to be able to get together. There's also representatives from the law enforcement community too. We also covered our educational efforts, which I've talked to you guys about. And then we discussed our compliance efforts, and the compliance efforts affect the other boards, right? Because we are sending information to those boards and I want their feedback. I want to hear, is this working for them or is it not working for them? And what can we do better to give them the data they need? And then that's kind of like a recap of the past year. And then we transition into, maybe like what I'd like to call hot topics. And the hot topics included, and these are things that we've talked about as a board before, but many of the board members may not have been around on the board at that time. But, in our statute, you have to check at the PMP upon a new course of treatment. But we don't have that defined anywhere. So when you measure compliance, that becomes a little bit tricky. So we talked about, should we one day get a definition for new course of treatment? We talked about ICD-10 codes, like Nevada captures ICD-10 codes in their PMP. That can be helpful for compliance measuring from the PMP standpoint. It could be helpful for pharmacists making clinical decisions, but it also has some negative potentials, and those negative potential would be, what if the ICD-10 is not on the script and it's Saturday and it's 10 in the morning and you can't get a hold of a prescriber? What's the pharmacist supposed to do? Is that gonna impact patient care? So, with every blessing, there is a curse with this too. Finally, we talked a little bit about the pharmacist identifier that we've talked about before that would help us measure compliance. And last of all, there's been changes to 42 CFR Part 2, and one day Arizona may want to react to that. And what those changes are, it does allow OTPs to report into the PMP if your state law says you must. Our state law does not say that they must. So if one day that's a direction Arizona would want to go, there's that statute would need changed, and then we would have to teach OTPs how to report into the PMP too. So I tried to cover my task force meeting in 5 minutes, and I put all the materials in your board book, but I'll open up to questions for you guys.
Regarding the new changes, and I know you and I personally had this discussion about methadone clinics and how they dispense methadone. And some of the challenges that we see on the acute care side when we transition those patients into the acute care environment. With any of the new changes, it sounds like there might be some methadone data going in if it's through prescribing or.
So, from a prescribing standpoint, methadone can only be prescribed for pain. But if we wanted that OTP data to come in, step one, we need a law change.
So OTP's outpatient treatment program, or
my apologies.
Okay.
Yeah, outpatient treatment programs, because they're going to be the ones mainly doing the what we would say an administration of methadone.
Right.
Our statutes say that administrations aren't captured in the PMP. So we would need that statute change to allow that, and not just allow, require it to be reported. If our state ever goes that direction, I would hope that we would build in a plan to educate, because we know the pharmacies didn't report into the PMP the best in 2008. To think that OTPs are going to be required to report into the PMP and do a fantastic job on day one would be unrealistic.
Anything, I mean, if these OTPs are using these EHRs that are on fire,
yeah,
would the ordering of that flow across potentially?
Yes. You know, as with any system, you could probably build filters to filter out these type things. I'm not that good on the IT side, but you know, I think with money, anything's possible. But I think it's an expensive bill.
Thank you.
Madam Chair, I have a question for Dr. Gandhi regarding the availability of naloxone to Arizona residents. To my knowledge, Department of Public Health is encouraging the dispensation of naloxone to patients in the ED setting. So from the logistical standpoint and regulatory standpoint, how do inpatient pharmacies handle the dispensing of naloxone to ER patients?
Well, it's over the counter. So if you have the over the counter product, you could treat it like ibuprofen. Yeah.
Oh,
Dr. Deng, we just looked at this and the product that's supplied through the foundation or the nonprofit that provides that to healthcare organizations, it is the OTC product, so it can be dispensed.
Thank you.
Or provided.
And not reported to the PMP, which, you know, it's a time saver.
Yeah.
Yeah.
Thank you.
Any other questions?
That was a very succinct summary of our 2.5-hour meeting.
Thank you. You know, some of those hot topics we talked about building some work groups. I haven't had a chance to dig into that, but more to come. You know, and those subjects would be the pharmacist identifier, define new course of treatment, ICD-10 code.
And I do think that we would benefit on that. And I think we talked about this in the work group to make sure that we have some of the IT folks from both hospitals and some of the large organizations, potentially even an independent or two, to see what the impact would be, because those are things that are not kind of happening broadly across the country. So I want to make sure that we don't set up unintended barriers.
Yeah, I think there's a lot to digest with all those subjects. And if anybody has any IT folks or want to volunteer on those work groups,
I will volunteer somebody from us. I'm happy to help. But
And I will
I'm not the
volunteer.
IT. I'm not the IT person, but
And I will volunteer one from us also.
I'll do my best to try to get somebody from Banner.
appreciate it. Thanks so much.
thanks, Doug. I think we're good except for call to the public. Hopefully Roger will come back tomorrow and we can hear.
I could call him.
He could still call in.
Yeah, he may.
For those of you that are in the public, if you didn't sign in for your C for this afternoon, if you want it, last call.
Are you calling it?
Don't see anybody, Madam Chair.
All right, we will